So it's really lovely to be able to welcome the 8th District over to our place as well. And so without further ado, I will welcome Judge Mary Jane Boyle from the 8th District Court of Appeals to get us going.
Good morning, and welcome to the 8th District Court of Appeals Advanced Appellate Seminar in conjunction with Case Law School. First of all, we would also like to thank Case for assisting us in putting on this program, also making it free of charge, as well as if you're in person, you get a free lunch. So that's wonderful. Welcome to the online group. I have to say, with the online group and the in-person group, this is the largest advanced appellate seminar that we have put on. So thank you for joining us. Thank you, Professor Paulus, for agreeing. Thank you, Eric Siller of the law school as well, and Rob Cones, who is assisting with the IT. He's the IT specialist here at the law school. I also want to thank all the presenters that you're going to hear from today, except for two, but all the presenters are from our Court of Appeals. You're going to hear from judges, and you're going to hear from judicial attorneys and staff attorneys, our court administration, both our Court Administrator Aaron O'Toole, and also thank you to our Deputy Court Administrator Bridget O'Brien. Without these presenters giving up their time and preparing the program, we wouldn't be here. And they did put in a lot of hard work. So thank you to all the judges and the people from the 8th District Court of Appeals for giving up your time to prepare for the program and present it here today. It's no easy task. A few housekeeping matters to keep in mind. First of all written materials and speaker bios are found in the law school's website where you registered for the event. You can download the material at your convenience. Second, the CLE information will be provided at the end of the program. And finally, due to the time constraints for the program, we will not be taking questions during each presenter's segment. For those attending here in person, the speakers will be available to answer your questions during the breaks. If you are attending remotely, please reach out directly to the court and we will forward your questions on to the designated speaker. The contact information will be provided during the breaks. As you see, we have quite an aggressive program. That's why we're not going to do the question and answer period, because we've really packed it with a lot of information. Without further delay, it's now my pleasure to introduce to you our first speaker. Our first speaker from our court is Judge Lisa Forbes. Now, Judge Forbes has been with us for a couple years now. It's kind of hard to say that, but she was elected on November 3rd of 2020, and she hit the ground running that year. So you are coming up on 2 years. Wow. It's been wonderful to get to know her. Prior to joining the bench, Judge Forbes was a partner in the Cleveland office of the law firm of Voyer, Saters, Seymour, and Pease, where she practiced in the area of complex litigation. As a litigator, Judge Forbes represented clients in the state and federal trial and appellate courts throughout Ohio for 27 years. Throughout her career, she's been active and engaged and a member of the Northeast Ohio community, including serving on the boards of the Center for Families and Children and Circle Health for over a decade. She currently is vice chair of both boards and chair of the Quality Improvement, Risk, and Program Committees. In addition, while practicing, she regularly wrote and presented on developments and on application in the law. She graduated summa cum laude from Case Western Reserve University of Law School in 1992. She has served first as an associate editor of the Law Review and then as an executive notes editor. She majored in public policy at Cornell University and has a Bachelor's of Science degree. Now, I asked her just before we came on here one fun fact of herself, and And her fun fact is she fulfilled a lifelong dream of hiking in the Grand Canyon this summer, and she lived to tell the tale. So without further ado, Judge Forbes.
Good morning, everybody. And I have to say, it's a smidgen misleading to say that I'm going to be the first presenter, because I'm actually have the good fortune of being on a panel with Tony Farkas and Newton Cargill, two of the longest-serving judicial attorneys at the Court of Appeals. Newton is a judicial attorney working now with Judge Emanuela Groves. Previously, he worked with Judge Pat Blackman, and he's been at the court for years. And Tony Farkas is a judicial attorney now with Judge Eileen A. Gallagher, and previously she worked with Judge Kenneth Rocco. So not only are these two of the sharpest legal minds that we have at the court, but I just want to warn you that if either Tony challenges you to a foot race, or Newton suggests you should just go play a round of golf, you should be forewarned that they are both exactly as skilled at those avocations as they are at their vocation. So with that, hang on one second, I'm going to grab my water. All right. So the first topic today, we have titled our presentation as "Can You Fix It?" And the topics we're going to go over are, and I'll get into the specifics of them in just a second. I'll focus really on what can you do as opposed to what can the court do. What can you do before you even get to the court of appeals that can make your sailing there a little bit smoother. And then that's going to be my part, talking about final appealable orders and ways that you can fix a trial court's order to ensure that you can stay in the Court of Appeals. And Tony's going to talk a little bit about ways in which you can maybe fix a trial court order without coming to the Court of Appeals. That's doing a deep dive into nunc-pro-tuncs. I know, everybody's like, thank God, I've always wanted to know. Then Newton is going to talk a little bit about how do you fix a trial court order without appealing by looking at 60B. And again, that'll focus on Civil Rule 60B. And then lastly, time willing, we'll talk just a smidgen about motions for reconsideration, and you'll hear about en banc motions later in the day. So here you go. Can you fix it? Remember this guy? Very inspiring. So the importance of final appealable orders. This isn't going to come as a shock to any of you. This is an advanced appellate advocacy seminar. But you can't come to the Court of Appeals unless you have a final and appealable order. And that's because our jurisdiction is limited. The Ohio Constitution specifically says that we can only review final orders. So we don't have discretion. And we can't do anything with a trial court's order that isn't final. We just have to send you back. So you look to 250502 to understand what is a final order, of course. And the simplest and easiest way to think about it, and what I'm really going to focus our look today at, is going to be on the notion that a final order is one that disposes of all claims against all parties. That's really just the simple formulation of the more artful statutory definition of affects a substantial right that determines the action and prevents a judgment. Of course, there are other ways in which final orders can be created. I'm just going to throw them up on the screen here. But again, we're just going to focus today on this really idea of when have you disposed of all claims against all parties or affected a substantial right determining the action. So before we get on to some of the more civil aspects of things, because I was a civil practitioner, so I apologize to the criminal practitioners out there, there is one thing to pay attention to in particular with regard to to matters in criminal actions that relate to final appealable orders. You must have your one document that articulates not only the fact of conviction, but also the sentence. And that comes from two Supreme Court cases, Baker and Lester. Tony's going to talk a little bit about how to fix it if you don't have one final order. But I already, in my brief tenure on the court, I have already seen cases where they're fully briefed, only the appeal has been fully briefed, only to realize at oral argument, oh, one of the counts hasn't been disposed of. So, you have a journal entry addressing 30 out of 30 counts in the indictment, announcing the fact of conviction, and then lo and behold, count 29 was never sentenced. There's nothing we can do. It has to go back. So don't let that happen to you. You can take care of it at the trial court, so you don't have to do it twice at the Court of Appeals. Now, just real quickly, I'm not going to belabor these points, but of course, a denial of a 12B6, a Civil Rule 12B6 motion to dismiss is not a final appealable order because it doesn't affect a substantial right that determines the action. In other words, doesn't dispose of all claims against all parties. There are, of course, special rules regarding some discovery orders. We're not going to dwell on those today, though, but do remember that. Oops. Sorry, it's not moving forward. There we go. Denial of summary judgment. Remember that generally speaking, that is not final and appealable. Again, doesn't dispose of all claims against all parties. But where immunity is at issue, that is final and appealable. You don't need to do anything to get to the Court of Appeals. At the conclusion of a case, sometimes denial of summary judgment is going to be final and appealable, but usually not. It's only final and appealable if you're dealing with a purely legal question that hasn't been rendered harmless by a subsequent trial on the merits. So what if you do have a summary judgment ruling that involves multiple defendants and the trial court only grants summary judgment against one, or you have multiple claims and the trial court only grants summary judgment on one of the claims? I'm sure all you civil practitioners out there are thinking, I can fix that with a Rule 54B order, 54B entry. Just ask the trial court to give you your no just reason for delay ruling. Well, what we're going to talk about here today is going to be a little bit about things to be cautious of to ensure that you get your 54B ruling correct and when it is that you need your 54B ruling. 54B, you can see the language up there. 54B is for the general purpose of accommodating a strong public policy against piecemeal litigation and weighing that against the possible injustice of a delayed appeal in certain special situations. And I bring that out because it's not always available. So 54B language is necessary. You cannot bring an appeal of fewer than all claims against all parties to the Court of Appeals without the magic language, no just reason for delay. Oh, but wait, did I just say magic language? Is it magic? No, in fact, having those magic words won't necessarily make your 54B appeal appropriate. We do still review the 54B designation. And we have to, because as I said at the outset, it's jurisdictional. So really, there are two questions you have to answer to understand whether 54B language appropriately applies. The first is it final under 250502? And you're probably thinking, wait, didn't you already say it has to dispose of all claims against all parties? Here, when we say final, we mean within a unique, distinct branch of the case. So the question that we look for under when we're doing a 54B analysis is, did the trial court's decision fully resolve of any of the appellant's claims? So using the words of 250502, does the order affect a substantial right that determines an action and prevents judgment? So we look at that in the narrow context of the specific question put. And then the second question is, has the trial court correctly determined that 54B language was added that there is appropriately no cause for delay, no just cause for delay? And to assess that, courts look at whether the interests of judicial economy are going to be served by an immediate appeal. So let's look at this in practice. And those tests, I would like to lay claim to them, but that's not me, that's the Ohio Supreme Court. What if a plaintiff claims that the defendant has been drag racing, he causes a motor vehicle accident, he sues for negligence and loss of consortium, he requests compensatory judgment, punitive damages, and attorney fees. The trial court grants summary judgment on the punitive damage and attorney fees claims for relief and knocks those out. The court says there's no genuine issue of material fact on whether the defendant was drag racing, so there's no malice, but the negligence and loss of consortium claims remain. So the question is that a final appealable order? No. I see a number of you shaking your heads no. It's not a final appealable order. Now the next question is, the trial court actually added this language, partial, there is no just reason for delay. Is that enough to allow the question to remain in the Court of Appeals? And I see many of you shaking your heads no, and you're right. It is not enough. It's not enough because the partial journal entry there did not resolve any of the appellant's claims. Negligence and loss of consortium remained. And so addressing those two potential measures for relief did not render that a final journal entry, so we couldn't look at it. And this is a case, as you can see the site there, that had to go back. Let's look at another scenario. What if you have John Doe defendants? John Does are oftentimes sort of confounding, right? Here we had a case, here's a scenario. You've got a complaint for medical malpractice against one named individual and 10 John Does. Trial court grants summary judgment against the named individual, dismissing him from the case, and the plaintiff tried to appeal in a timely way. Can the plaintiff appeal?
Maybe.
Oh, we got a ringer over here. That's right. That's right. Any yeses that he can? Any no's? And now no. Yeah. So the question is, do you want more information? All right. Well, here's a little bit more information. The plaintiff did not ever amend the complaint to identify any of the Doe defendants and did not serve any of them before the summary judgment was granted. Is that enough to answer whether 54B language can fix this? Yep, and those of you, like Judge Boyle, who said maybe, I'm going to agree with you, and in fact, so is the 8th District Court of Appeals. Here, the more than a year had passed. So the complaint was filed, more than a year had passed, no Does had been identified, so no Does had been served. So they were not properly before the court. The case had not commenced as related to the Doe defendants, so that when summary judgment was granted as to the individual doctor, that was a final and appealable order addressing all claims against all parties properly before the court. No 54B language was necessary, and the appeal could go forward. What if less than a year had passed? Any thoughts? Well, if less than a year, pardon?
You have a finality problem.
You have a finality problem if less than a year has passed, and that's because those Does could still be identified and they could still become parties to the case. And so you do need 54B language depending on the amount of time that has passed. Or I should say you may. Now, getting the 54B language may not be your only solution in that situation if you have unserved defendants or if you have served defendants, right, depending on the amount of time. And that other solution, possible solutions, you might be able to dismiss those unserved parties or the other parties. But you have to remember here that you can only dismiss parties, not claims. So this doesn't work, this dismissal doesn't work for claims to make a final appealable order under Civil Rule 41. The proper way to dismiss fewer than all claims is to file an amended complaint under Civil Rule 15. So just real quick, and I'm not going to belabor all these reminders, but I do want to remind you that reconsideration of a summary judgment, if that summary judgment does indeed dispose of all claims against all parties, does not toll your time for bringing your notice of appeal. It is a legal nullity. So you can ask, but if that summary judgment disposed of all claims against all parties, your 30 days are running, and the trial court doesn't have jurisdiction anymore. So if, in fact, all claims have been resolved against all parties, you need to come to us to get your, quote, fix. And so now I'm going to turn it over to Tony, and thank you very much.
Hi, good morning. I'm going to talk a little bit about the use of nunc-pro-tuncs to fix errors and omissions by the trial court. You might think that nunc-pro-tuncs are fairly rare, but actually we see them with some frequency in the appellate courts, at least our court. The last time I did a check on Lexis, there were over 6,000 Ohio appellate cases referencing nunc-pro-tuncs, so they're actually a little more common than you might think. I'm going to go over some of this material fairly quickly. So if you find that this is an area in which you have an interest, I'd encourage you to look at the written materials because the written materials go in a little more detail about these nunc-pro-tuncs. So get started. So what is a nunc-pro-tunc? Nunc-pro-tunc is Latin for now, for then. It's an order that's issued after a prior order that seeks to correct some clerical error or omission in the prior order so that the record speaks the truth. The sources of authority for nunc-pro-tunc orders, you'll see that common law. In the civil rules, you can find it in Civil Rule 60A, and in the criminal rules, you'll find it in Criminal Rule 36. And I'm not going to read all these rules for you. So what's the effect of a proper nunc-pro-tunc entry? Why does it matter? Going back to that now for then, a proper nunc-pro-tunc entry has the same legal force and effect as that prior order. It relates back to the original entry, and as a result, it generally doesn't have an effect on the time for appeal. Now, there are some exceptions that's been recognized over time. Just because a nunc-pro-tunc fixes a clerical error doesn't mean it might not have significant consequences. There may be certain circumstances in which a nunc-pro-tunc properly changes a sentence, where it adds a couple of zeros to a judgment, or something else. And so in those circumstances, there have been instances in which an exception has been recognized where a nunc-pro-tunc affects a matter of substance, or creates additional rights, or denies an existing right. It may extend the time for appeal. So what's the effect of an improper nunc-pro-tunc? It doesn't have any effect, it's invalid, it's void. So from an appellate perspective, I said we do have quite a few instances in which these pop up in appellate cases. Why does it matter? Whether or not a nunc-pro-tunc entry is valid may determine whether a final appealable order exists. It may affect the time for appeal, and it could determine what the substance of the order that's being reviewed on appeal. You know, the court speaks through its journal entry, so knowing what that journal entry is, whether it's the original journal entry or the journal entry changed via the nunc-pro-tunc, matters. So how can error be corrected via a nunc-pro-tunc? It can be done sua sponte by the court, or it could be requested by motion by a party. So now we're at what errors can be corrected via a nunc-pro-tunc entry. They can be used to remedy clerical mistakes. You see that term used in the rules, in judgment, orders, or other parts of the record. So what's a clerical mistake? A common definition is a mistake or omission that's mechanical in nature and that's apparent on the record that does not involve a legal decision or judgment. Although it's called a clerical mistake, it's not limited to mistakes by a clerk. You often see errors in mathematical calculations or typographical errors. Those are common clerical mistakes. In addition to clerical mistakes, nunc-pro-tuncs may also remedy errors in the record arising from oversight or omission. Again, that goes back to the language that's in both Civil Rule 60A and Criminal Rule 36. And that's basically something that's omitted from a journal entry that was in fact done or decided. So something that was done that just got omitted. So what errors can't be corrected via a nunc-pro-tunc entry? My judge, Eileen A. Gallagher, likes to say, and I'm quoting her here, the trial court could not nunc what it did not first tunc. So have to give credit where credit is due for that one. So in other words, non-protunct cannot be used to supply omitted action, to do what the court should have done or intended to do, but did not in fact do, or as a vehicle for changing the court's decision. So how do you determine whether something is a proper non-protunct that reflects what the trial court actually did or decided, or is an improper non-protunct, where it's a mean by which the trial court's trying to change its decision or correct a judicial error? Look to the record in the first instance. If you look at the definition of clerical mistake, it talks about a mistake, omission that's apparent on the record. So unless you have something that's tangible in the record you can point to, showing that there's a clerical mistake or omission, you're probably not going to have a valid non-protunct. That being said, when you look at the case law, some courts have also considered the context and the surrounding circumstances and whether something makes sense when you're evaluating whether a non-protunct entry is proper. So we did the how, the what, now we're at the when. When can a judgment or order be corrected via a non-protunct entry? If you look at the language of both Civil Rule 60A and Criminal Rule 36, you'll see the language says at any time. But does any time really mean at any time? What about while an appeal is pending? Civil Rule 60A specifically addresses that circumstance and says that during the pendency of an appeal, mistakes may be so corrected before the appeal is docketed in the appellate court and thereafter while the appeal is pending with leave of the appellate court. You'll notice that Criminal Rule 36 is silent on that issue, but courts have looked to Criminal Rule 57B, which states that if there's no rule of criminal procedure that addresses a particular issue, you can look to a rule of civil procedure to fill that gap. Courts have also used Appellate Rule 9E as a basis to provide authority to issue a non-protunct to correct a clerical error or omission while an appeal is pending. And I know that our court has at times remanded cases back to the trial court to issue a non-protunct to fix a very obvious error that is noticed when a case comes in so that an appeal can proceed. And that sort of addresses the circumstance that Judge Forbes mentioned about the fact where you're looking at it and you see, oh, a count hasn't been sentenced, and our court notices that. It may be a circumstance in which the case is remanded back to the trial court to issue a non-protunct, if in fact that count had been previously sentenced on at the sentencing hearing and just didn't make its way into the sentencing journal entry. Where you don't have a remand by the appellate court, jurisdictional considerations may limit the ability of the trial court to issue non-protunct entries while an appeal is pending. As you may know, it's well established that once an appeal is perfected, the trial court's divested of jurisdiction over matters that are inconsistent with the reviewing court's jurisdiction to reverse, modify, or affirm a judgment. And a number of courts have applied this to non-protuncts. I mean, this just makes sense. You don't want to have the appellate court reviewing what it thinks is the substance of a particular order, and then the trial court comes in and modifies the substance via a non-protunct. So, I mean, that just makes sense. Sometimes courts will say it depends on what's being corrected and what is being appealed in determining whether or not there are jurisdictional issues at play. What about after an appeal? It's not uncommon to see non-protuncts being ordered, a case being remanded for the issuance of a non-protunct as part of the relief granted on appeal. We see that with some frequency with regard to sentences and sentencing journal entries where something was in fact done and it's just not reflected in the sentencing journal entry. With regard to other post-appeal non-protunct entries, you're back to that language at any time, but again, there may be some limitations. For example, you can't issue a non-protunct entry correcting a sentence after the sentence has already been completed. All right. So we thought that the best way to look at some of the do's and don'ts of non-protuncts would be to go through some examples. I can't promise you that this is going to be as exciting as Michael Strahan on the $100,000 pyramid, and I don't have any money to offer you, but hopefully this will make it a little more fun. All right. So example number one. The trial court issues a non-protunct entry to correct the filing date where a petition for post-conviction relief was received by the clerk's office on August 2nd, but was file stamped August 3rd. So a non-protunct entry is issued to correct the filing date to August 2nd. I'm not going to call on anyone, but by a show of hands, who thinks you can fix it with a non-protunct? Who thinks you can't fix it with a non-protunct? Well, the answer is at least based on this case. This example is from the case listed there, State versus Miller. It's sort of a quintessential example of what's considered a clerical error, and so you could fix it with a non-protunct. All right, example number 2. A trial court originally dismisses a case with prejudice, and then it issues a non-protunct dismissing a case without prejudice. Who thinks you can fix it with a non-protunct? Who thinks you can't fix it with a non-protunct? Overwhelming majority, as you see, it's not something you can fix with a non-protunct. That being said, unless there's something in the record that specifically shows that the trial court had actually decided to dismiss the complaint without prejudice and then due to some clerical error inadvertently dismissed it with prejudice, this is a substantive change. It's the court changing its mind. It's a judicial error. All those things that you can't use a non-protunct for. Doesn't matter if it's the other way around and the trial court first dismisses a case without prejudice and then seeks to dismiss the case with prejudice. No. But I did want to point this out because this is an example of when you have a valid non-protunct can affect whether you have a final appealable order. A dismissal with prejudice is usually a final appealable order. There are some exceptions, but a dismissal without prejudice is usually not a final appealable order. So if your non-protunct order dismissing a case with prejudice is void, you may not have a final appealable order. So that's one of just the reasons why non-protuncts can actually be very important. Okay, example 3, sort of looking at what Judge Forbes talked about earlier about 54B language. The trial court issues a non-protunct adding Civil Rule 54B language to a prior order while an appeal is pending. All right. Can you fix it with a non-protunct? Can you not fix it with a non-protunct? This comes from the case Stepp versus Sterrett, and in that case, there's actually 2 issues that they raised. One is the fact, it goes to the adding of the 54B language. A non-protunct, 54B is actually a determination, akin to a factual determination. Is there no just reason for delay? So it is a substantive determination. And this is a circumstance in which a non-protunct cannot be used to supply omitted action to indicate what the trial court should have done or decided but didn't do. And then you have the other issue that this was while the appeal was pending. And again, that court said that, the trial court lacked jurisdiction to issue the non-protunct while the appeal was pending. I will say that doesn't mean that it couldn't be fixed. Because the original order without the 54B language was interlocutory, once the appeal was dismissed and remanded back to the trial court could then issue a subsequent order adding the 54B language. So this is a circumstance in which, one fix might not work, but another one might. I will tell you there are some cases in the materials that do say that you can add 54B language via a non-protunct, but when you look closely at the analysis in those cases, really it seems to be what they're saying is that you can have a subsequent order that adds 54B language, not that order is a true non-protunct entry. And you wouldn't want it to be a non-protunct entry because then it might affect your time for appeal. So it could shorten that. What about if the trial court issues a non-protunct order seeking to delete 54B language? Can you fix that with a non-protunct? Who thinks yes? Who thinks no?
Only if the court said, no, I'm not issuing a 54B language from the beginning.
I think Dave's hit it right on the nose. Once again, unless you've got something in the record you can point to, it's not going to be a proper non-protunct. That's based on that Infreas case that's cited there. And they say that where there's nothing in the record to indicate that this was what the trial court had previously done, you can't strike that language and make your judgment less final via a non-protunct. Okay, one final example. We talked some about sentencing issues, so I thought this might be a timely one. It's based on a case that the Ohio Supreme Court decided a couple months ago. At the sentencing hearing in 2003, the trial court properly sentenced the defendant to a mandatory term, a 5-year term of post-release control. The original sentencing entry did not specify that mandatory term of post-release control. And then in 2020, following a motion by the state, the trial court issued a nunc-pro-tunc entry to reflect that the defendant was subject to that mandatory term of post-release control. So here you go. You can see the added language at the bottom. That's all they added via the nunc-pro-tunc. 17 years later. Can you fix it with a nunc-pro-tunc? Who thinks yes? Okay. Thinks no? All right. The Ohio Supreme Court said, yes, you could do that. In this particular case, the defendant had filed a mandamus action seeking to compel the trial court to vacate the nunc-pro-tunc entries, arguing that since the original sentencing journal entry did not properly impose post-release control and the state did not appeal, that they should be precluded from, by res judicata from seeking to correct that error via a nunc-pro-tunc. But in Randlett versus Lynch, the Ohio Supreme Court said, where a valid nunc-pro-tunc entry can be issued under Criminal Rule 36, res judicata does not preclude its use, which to me was sort of surprising given the whole Harper-Henderson Bates line of cases. But they said a proper nunc-pro-tunc entry is not a collateral attack on the judgment it corrects, and so it could be done. So I'm going to turn things over to Newton, who is going to talk about another means by which you can fix it via Civil Rule 60B.
Good morning. Thanks for coming out. My segment, 60B, intends to strike a balance between finality on the one hand and perfection on the other. Finality meaning that we want an end to litigation. On the other hand, we want a just result. So you have two competing parties. You have this party over here that has a final judgment and want it to stay. Yet, on the other hand, you have this party that says, no, I want that to be unraveled. So we come to 60B. So what does it say? On motion, so it has to be by motion, the court may relieve a party from a final judgment for the following 5 reasons: mistake, newly discovered evidence, fraud, the judgment has been satisfied, or any other reason. Now, the key here is it has to be filed, the motion has to be filed within a reasonable time. And for the grounds 1, 2, and 3, it has to be filed no later than 1 year from the time of the final judgment. For 4 and 5, reasonable time, and we're going to get into some of that, the nuances of that. The other thing to keep in mind is that it does not affect the finality. So the clock keeps running. So your appeal time keeps going. Now, what type of things are subject to 60B? It has to be a final order. Final appealable order, and as Judge Forbes discussed earlier, it is not applicable to interlocutory orders. It is not applicable to voluntary dismissals. And it is not applicable to appellate proceedings. Now, a trial court is vested with broad but not unlimited discretion to grant or deny, to grant a motion for relief. Now, how do we review it? We review it for abuse of discretion. And as you know, an abuse of discretion occurs when a decision is unreasonable, arbitrary, and unconscionable. Now, is a 60B motion a substitute for an appeal? No, no, no. The other question is it used as a substitute for an appeal? All the time, right? No, it is not a substitute for the appeal, but it is used a lot as a substitute for the appeal. And in those instances, when generally the moving party misses the deadline to file their appeal, they file a 60B motion. And that gets denied. And it gets denied because it doesn't get granted. It doesn't get granted because they're arguing the same things that they would argue in a direct appeal. So if you file a 60B motion as a substitute for a direct appeal, res judicata applies, right? So the key is that you need to file your direct appeal. Now, some people, there might be a 60B motion that is pending when you file your direct appeal. In that case, you're going to need a limited remand. But later in the program, Jake Dykers is going to discuss more on that, so I'm not going to touch on that at all. The leading Ohio Supreme Court case on 60B continues to be GT, right? On the GT sets forth three things that a person seeking relief has to demonstrate. One, they have to demonstrate a meritorious defense or claim to present if the relief is granted. Two, that they are entitled to relief on the one of the 5 grounds. And 3, that they have filed this within a reasonable time. All 3 have to be filed within a reasonable time. Now, as to a meritorious defense or claim, the key with this is that the meritorious defense or claim, it doesn't have to show that you're going to succeed, but it just has to give the trial court some idea that, hey, look, you know, this is worth vacating this order, right? So you have to specify operative facts. The more you can put in to show that you are entitled to relief, the better. So put in as much as you can, right? You can't just deny things and expect that you're going to get relief. You won't. Now, when it comes, I need to click, right? Okay, reasonable time. What is this reasonable time? The reasonable time, there are like 2 different standards. So when it comes to grounds 1, 2, and 3, the reasonable time, but it has a 1-year limitation. When it comes to grounds 4 and 5, it's just reasonable time, the 1-year limitation doesn't apply. However, 60B is equitable in nature. So you have to be diligent to be entitled to it. So you could file a motion for relief on the 1, 2, or 3, and you file it, you know about the grounds 2 months after the final judgment. But you wait until 5 days before the 1 year expires. The court is going to say that's not a reasonable time. Right? So the key is that you have to move quickly. Now, as to the meat and potatoes of the different grounds, on the ground 1, mistake, inadvertent, surprise, excusable neglect. That, as I said, you have to file that within a reasonable time, but no later than 1 year, right? And you must set forth operative facts. Now, we all understand mistake, inadvertent, surprise, but this excusable neglect, the Supreme Court has termed that an elusive concept. So it's going to be based on case-by-case scenario. Recently, in May, from the 4th District, Itels Towing, and that's 2022 Ohio 1639. The 4th District held that the trial court did not abuse its discretion in granting defendants' motion for relief from a default judgment on the 60B1 because defendants' neglect was excusable because of the problem created by the pandemic. It went on to say the cause of the neglect was a result of a unique pandemic over which defendant had no control and which caused significant difficulties on a worldwide scale. So you see that excusable neglect is indeed elusive, right? What about a hearing? Does the trial court have to hold a hearing? Well, that depends. If the okay, I keep forgetting to do this, you know. Okay, and you know I can't even see what's up. Okay, all right. So that's my usual excuse to when I'm golfing. I can't see. But they don't believe me. So it depends. If the motion for relief is accompanied by operative facts, and the trial court can look and see that, yes, you know, I should undo this final judgment, then, yeah, hearing. If they can look at it and there's nothing there that shows that they should grant it, then they don't need to have a hearing. So the key, again, is you present facts, facts, facts. Then I've presented some examples, right? And I believe, yeah. And I'm going to have you look at that at your leisure. Number 2, newly discovered evidence. Again, this one has to be filed within a reasonable time, but not to exceed 1 year. Now, the key is that it is newly discovered evidence. So it is not anything that you knew about before the final judgment. So it has to be new, right? I'm not going to go into that example, Strack versus Pelton, but that's a very good read. Number 3, fraud. Again, it must be brought within a reasonable time or 1 year. But not to exceed 1 year. The person moving for relief as a burden, right, of establishing the fraud. The key here too is that fraud or misrepresentation constitutes sufficient grounds to vacate the judgment, right? Interesting note. While a litigant's false statement may justify release from judgment, unless a party relied on that, then they're out of luck. Satisfaction, right? The 4th ground, this one has to be filed within a reasonable time. The 1 year limitation doesn't apply, right? But you still have to keep in mind that you want to file things as soon as you discover a ground. Now, the staff note indicates that on the 60B4, relief would most likely work to afford relief from the operation of a prospectively operating judgment, such as an injunction, right? So it's not anything that happened before the final judgment. That's the key to keep in mind. Then, number 5. Any other reason justifying relief. Now, this one is where a lot of people who didn't file their motion for relief on the 1, 2, and 3, and the 1 year has passed, this is where they go to. But guess what? Yeah, you can tell, right? The caveat is the 5th ground, any other reason, is limited to the reasons other than those set forth in 1, 2, 3, or 4. So it's termed the catch-all provision, and it reflects the court's inherent power to relieve a person from the unjust operation of a judgment. Now, the grounds for invoking and getting relief on the 60B5 has to be very, very compelling. So it just any little thing is just not going to work. So it is construed very narrowly. So and again, the main thing is it applies only when a more specific ground for relief does not apply. All right. So that, my friends, is a quick snapshot of the 60B. All right. Thank you so much again for coming out.
All right, wonderful, wonderful, wonderful. I encourage you to read the written materials that is in the program. As you see, they did an overview, and then they did a lot of work to put in and prepare those written materials with the case law cited. I am not Judge Eileen T. Gallagher. However, it's my honor to introduce our next speaker in our next panel. Hot topics in the law, and I'm here to present Judge Michelle Sheehan. Michelle Sheehan was elected to the 8th District Court of Appeals in November of 2018. So, another highlight. Today you're going to see a lot of our newest judges who haven't finished their first terms yet presenting or introducing. And we did that on purpose so that everybody can get to know the new faces of our court, not just on the day of oral argument. Judge Sheehan, prior to being elected to the Court of Appeals, was a shareholder at large at a large litigation firm, that being Reminger and Reminger. She has litigated cases in both state and federal courts on behalf of both plaintiffs and defendants for over 25 years. She is one of 28 attorneys throughout the state of Ohio who is certified as an appellate specialist by the Ohio State Bar Association. She has represented clients in appellate matters before the Ohio Supreme Court, the Sixth Circuit Court of Appeals, and almost every appellate district in the state of Ohio. She has served in various leadership roles within the community. She is the former president of the Ohio Women's Bar Association and has held various leadership roles in local organizations such as the Cleveland Metropolitan Bar Association, the YWCA, and Cleveland Marshall College of Law, and Rocky River Civil Service Commission. She earned her bachelor's degree from Miami University of Oxford, Ohio, and her law degree from Cleveland Marshall College of Law, where she met her husband, the Honorable Brendan Sheehan. She is also a member of the Florida Bar. As a side note, one of the reasons our court likes to put this seminar on, and it's entitled Advanced Appellate, is because there's not a lot of seminars that focus just on advanced appellate law. We have been approved by the Ohio State Bar Association for these credits, so if you are going for your appellate specialist, these CLEs will qualify. One fun fact about Judge Sheehan is she's a secret wedding planner. Not only can she preside over weddings and perform them after special assignment from the Ohio Supreme Court chief, she also likes to secretly prepare them. And I have to say, she's a quite organized jurist who is an extraordinaire, I think you said, of various things. With that, her group is going to present hot topics. The first one being, are you sure you want to attach that? An appellate perspective on Civil Rule 12 and how to avoid reversal on appeal. Thank you.
Reminder, everyone, I'm a little organized, and if you want to be married, anytime, we have one on Monday. I know someone in Common Pleas Court, we could do a double wedding, it'll be great. But thank you, Judge Boyle. Today we're gonna mix things up with hot topics. We're gonna make it really easy for you though. So 20 minutes, we'll give you the highlights on 3 up and coming areas. We've been watching trends in the Court of Appeals, and over the past 2 years, there's been a few that we think are important, and that hopefully if you just take a few tidbits away from this, you can hopefully prevent you from making a few mistakes.
we're going to cover 2 civil procedure rules and en banc. En banc will cover both civil and criminal. But the first one is Rule 12. By a show of hands, if you're willing, how many people have been involved in a decision that's been reversed by the Court of Appeals involving a 12B? If you're so inclined. And I know in Zoom land, there's a few more out there. It's a trend we're seeing, and we're going to talk a little bit about that. I don't know if COVID was a factor, but during COVID, it seemed to me a lot of the trial courts were granting a lot of 12B, 12Cs, and practitioners were attaching things that you didn't typically see. So, for example, if a case was resolved in domestic relations and then some of those same issues got filed in common pleas court, they would attach the domestic relations opinion to that complaint or to that motion to dismiss, and it would get granted. Well, we're limited. We can't look outside the pleadings, and that's what we're going to cover today. So hopefully you'll hear, I was smart enough to bring in some veteran practitioners who deal with this on a daily basis, and you're going to hear from them. So first up, we have Melissa Geist, who was in Thompson Hines Business Litigation Unit before she came to join us at the Court of Appeals and was a judicial attorney. And now she's at Flowers and Grube, and the name partners are in the audience, so there's no pressure today. You'll be fine. She's also a case grad and an adjunct professor on appellate practice as well. We also have Alex Frondorf, who's with Littler Mendelsohn and focuses on employment law. He also was a judicial attorney for the Honorable Ann Aldridge and Kathleen O'Malley in the Northern District some time ago, and is also an adjunct professor both at Cleveland Marshall and Bowling Green. So with that introduction, would you please help me welcome Alex and Melissa? And I'm just going to hang out here and pipe in every now and then, but really, you're in charge of the slideshow.
Thank you, Judge Sheehan. As Judge Sheehan just mentioned, we're going to focus on just a couple rules, one of them being Rule 12 and its various permutations, but also starting with Rule 8 and Rule 10 to lay some background, because that will come to bear on how we view Rule 12. And then finally, what happens when you don't answer the question right? Are you sure you want to attach that? Conversion from Rule 12 to Rule 56. I'm going to hand over to Melissa for the first couple slides.
All right, now before we can get into the issues that come up with 12B6 and 12C motions, it's important to understand what exactly is a pleading. So Civil Rule 7A tells us that a pleading is a complaint, an answer, and responses to counterclaims and cross-claims and third-party complaints. As you all know, again, this is an advanced seminar, but a complaint must only state a short and plain statement of the claim here in Ohio, and answers need to admit or deny the allegations and state a short and plain statement of the defenses. Where it gets a little bit more tricky is the attachments to the pleading. So Civil Rule 10C tells us that written instruments that are attached to a complaint, and sometimes an answer, which we'll get into later, are also part of the pleadings. So
say that again. A written instrument. You can attach something to an answer, and that's part of the pleading.
yeah, so a written instrument attached to a pleading is part of the pleadings. So it gets into a little bit tricky when we get into what exactly a written instrument is, which we will talk about a little bit later.
So Judge Sheehan mentioned Rule 12 is taking on the spotlight this morning. And the 2 rules that we want to focus on within Rule 12 are Rule 12B and Rule 12C. Most of you are probably most familiar with Rule 12B6, and you would file that when the plaintiff has filed, you would file it as a defendant, when the plaintiff has filed a complaint that fails to state a claim upon which relief can be granted. And it must appear on the face of the complaint or its attachment beyond a doubt that the plaintiff cannot prove any set of facts to support his or her claim which would entitle that plaintiff to relief. Now compare that to Rule 12C, judgment on the pleadings, which after the pleadings are closed, but within such time as to not delay the trial, a party may move for judgment on the pleadings. So what are the differences between these two? Well, first, 12B motion is filed prior to the defendant filing an answer, typically. Plaintiff could always choose to amend the complaint as a matter of right, depending on the timing after a 12B6 is filed. So the plaintiff has a shot at getting out of the motion to dismiss if he or she can amend the complaint in such a way as to avoid the pitfalls that were brought to the court's attention in the motion to dismiss. Now compare that to a 12C motion. Unlike a 12B motion where it is the defendant bringing the motion, in a 12C motion, any party can bring that motion. And so if the defendant's answer either fails to assert a critical affirmative defense or admits or fails to deny certain key allegations, a plaintiff can then bring a motion for judgment on the pleadings under 12C. A 12C motion, unlike a 12B motion, can only be made after the pleadings are closed, so after the answer is filed, unlike 12B. And in a 12C motion, once the pleadings are closed, the plaintiff is locked into his or her complaint and can then only amend the complaint with leave of court. We most often see a 12C motion filed for matters like declaratory judgment or breach of contract claims, when the defendant would have the opportunity to attach a written instrument to the answer, which then becomes, as Melissa mentioned, part of the pleadings. So, when do you attach and what do you attach? Making a Rule 12 motion, it really depends. Is it 12B? Is it 12C? What party are you? What is the document that you seek to attach? And when you attach it. And now we're going to get into those details. So, it depends. Melissa?
So while, regardless of whether you're filing a 12B6 or 12C and whether the attachments to those documents themselves are written instruments, attachments to the motion to dismiss themselves are not part of the pleading. So if you include attachments to your 12B6 motion or 12C motion, the court is likely to convert that motion to a motion for summary judgment. So a great example of this is the case Heck versus Equity Trust Company. In this case, the plaintiff brought a breach of contract claim, but didn't actually attach the contract to the complaint. Now, the complaint vaguely referenced that a contract that was formed in a particular year, but didn't provide any details about, the details that would identify the complaint itself, the contract itself. The defendant filed a 12B6 motion to dismiss attaching the contract. And the 8th District said that that was not allowed, right? The contract wasn't attached to the complaint, and because it wasn't specifically identified in the complaint, the complaint didn't incorporate the contract, and the court remanded for the trial court to convert the motion to dismiss to a motion for summary judgment, giving the parties an opportunity to submit additional summary judgment evidence if they had to. One of the requirements for converting a motion to dismiss to a motion for summary judgment is to give the parties notice and an opportunity to respond or present additional materials.
So, Melissa, you said the complaint reference. We see that a lot. People in their complaint will say, they reference a docket to a case in California, and then they say, well, it's incorporated into the complaint. Well, it's not. So have you had any experiences? What can they reference and it truly be incorporated? Does it have to be attached, or are there some things maybe that they could reference that are still allowed?
Well, that really comes down to the definition of what is a written instrument,
Okay.
which might segue nicely. Not quite. Hold that question.
Okay.
We're
I'll put a
We're
pin
going to
in
get
it.
into that in much more detail. So I mentioned Civil Rule 10 earlier. So if your complaint is based on a written instrument, like a contract, for example, in a breach of contract case, you actually need to attach that written instrument to the complaint. But if you don't, it doesn't render your complaint invalid, so the proper remedy wouldn't be a 12b6 motion to dismiss. Instead, it's actually a motion for a more definite statement under Rule 12. Has anyone filed one of those motions? A handful. That's more than I expected. I don't, it doesn't seem to happen all that much.
So finally, we get to the question, what is a written instrument? Written instruments are documents that show a party's rights or obligations, like an insurance policy, a lease, a deed, a promissory note, or a contract. So it is a document that lays out clearly one or both parties, perhaps, rights for a given issue. The attachment must be a written instrument to be part of the pleadings. And that requirement comes from Rule 10, which we saw before, and it is also referenced later in the rules, again referring to a written instrument, but written instrument is not defined in the Ohio Rules of Civil Procedure. Regardless of what it is that you're attaching, the written instrument must still be authenticated, and that's a key step to avoid a potential pitfall of having something thrown out because you've attached it thinking that this contract, this promissory note, what have you, is properly attached, but if it is not authenticated, it may not get the job done.
Yeah, can we stress that? If in doubt, attach an affidavit. Just do it. Just please go above and beyond, because then we're stuck with what do we do with this? So.
But you don't want to get bounced out because you didn't file the affidavit. All right. What written instruments are not? A police report is not a written instrument. Court documents from a previous case are not technically a written instrument, but we're going to see here in a little bit that there may be some wiggle room on that point.
So, jurisdictional issues. This one, it's a little sneaky, right? It's not actually a 12b6 or a 12c issue. It's, if someone's going to challenge jurisdiction, it's through 12b1. But a lot of times these challenges are raised together in the same motion, so it can be a little tricky to tease out. But this distinction between the two is important because courts are allowed to look outside the pleadings to determine whether they have jurisdiction. So it's just something to be aware of as you practice or are considering these types of motions.
Res judicata issues. So you get a complaint comes across your desk, and you look at it and you said, my God, this has already been resolved. We took care of this in this previous case a year ago. What do you do? Well, again, it depends. If you file an answer, if you're the defendant, you file an answer and you attach a certified copy of the court docket in the prior case that you believe gives rise to res judicata, that may constitute a written instrument and may allow you to prevail on a motion on the pleadings. However, that's not 100% certain. So earlier last year, in February of last year, the court looked at a res judicata issue and accepted a certified copy of the court docket and ruled on a 12C motion. However, 6 months later, again last year, the court looked at the certified copy of a docket in a malpractice case and found that that did not meet the bar for a written instrument and therefore did not consider it in the 12C motion.
And I would just add on that, it was a statute of limitations issue in the legal malpractice, and they were trying to establish it was outside the statute of limitations. So we had to take, some may argue you could take judicial notice of a date of the filing. I think but that was not the holding.
So you have, it really does depend on the specific facts of the case and whether or not you can establish res judicata cleanly on the record, the prior court record, or whether the plaintiff might have a claim, well, that claim wasn't a compulsory counterclaim or wasn't compulsory to bring that claim, and therefore it's not truly res judicata, in which case you'd have to go to facts and documents outside of the court document, which would probably then bring it outside the bounds of a proper 12C motion. So it really depends on the specific facts of the case, the details of the case, the statute of limitations that might be relevant. So there's no, I can't give you a clean black letter law on that particular question. But it is out there, and depending on the facts, some courts have accepted it, other courts have not, again, depending on the specific facts.
Can I make one other note? I don't know if you have statute of limitations coming up, because this is something I didn't really appreciate as a practitioner. You know, we're stuck with the four corners of the complaint, and if it's a statute of limitations issue and it's not pled that it's within the statute or outside the statute, then we've had motions to dismiss filed trying to show it's outside the statute of limitations, but the four corners of the complaint pled it's inside. Well, we're kind of stuck with that, and then now you're under summary judgment. So be aware, if you're the plaintiff, I mean, you don't have to plead it's within the statute of limitations. If you're a defense, you're gonna have to think long and hard how you're gonna show that's outside the statute of limitations properly in a 12B or 12C.
And often those kind of issues, if the dates, the relevant dates for when the bad act allegedly happened are not in the complaint, then you're probably stuck with filing a Rule 56 motion as opposed to a Rule 12 motion. But remember, that doesn't doom you to prolonging the case unnecessarily. You can bring a Rule 56 motion at any time if the facts of that particular case warrant it.
Then the last issue we want to go over, Judge Sheehan hinted at it a little bit, is judicial notice. And it's a little bit unclear whether courts can take judicial notice at 12B6 or 12C stage.
We don't like to. Let's put it that way. We don't like to.
Right. So obviously the general rule is courts can take judicial notice of their own dockets, but not the dockets in other cases. But there seems to be some surface level inconsistencies in the cases and how that's actually applied on a motion to dismiss stage. So a great example of this is Edwards versus Kelly. This is the legal malpractice case that Alex was referring to, and the majority held that they could not take judicial notice of the prior criminal case, or certain journal entries in that case that would have been dispositive on the motion to dismiss issue, and cited a lot of authority and support for that. And then the dissent would have taken judicial notice and cited a lot of authorities in support of that too. So the takeaway here is to just be careful and be cautious, and maybe consider a summary judgment motion instead of a motion to dismiss when the court would have to take judicial notice of something.
Okay. I think we have like 2 minutes on this segment, right, Bridget? Yes. So does anyone have any questions? Because we got 2 more good hot topics too. Okay. Well, if there's no other questions, thank you very much, Melissa. Thank you. Who's my next presenter? I'm going to sit over here so he doesn't feel all alone. Next we have Tony Petruzzi. We're going to talk, by a show of hands, how many people know last year the Ohio Civil Procedure Rule 37E was completely changed? I know we're all in COVID land, but take a seat. I'll put you over here. But the rule completely adopted the federal rule 37E. 37E dealing with electronically stored information, what happens when it's when it's destroyed, and sanctions courts can impose. It's a really big deal. I know when I was in practice, electronically stored information was like, sometimes the case just didn't warrant getting involved in it. It was a small case, or the lawyers just agreed not to deal with it. But I think we're going to see a lot more of it, and because of this rule, the courts have some very specific options to sanction. So you need to know what needs to be done and how you can avoid being sanctioned yourself. So Tony Petruzzi is a local expert, I'd like to say, on this. Partner at Tucker Ellis, civil litigator, business, as well as all the way to white collar crime and everything in between. But he's also in charge of the firm's e-discovery program, and he's on the working committee for the Sedona Conference, which, if you don't know the Sedona Conference, that's a national organization that researches, writes white papers, and really focuses on electronically stored information, discovery, and these issues. And they're cited quite a bit in federal case law. So to be on a national level, you're kind of a local expert hero. And this is what, your 3rd presentation in 2 weeks?
Yeah, third this month.
Yeah.
Every Friday I've done a presentation apparently. And then next month we have our annual meeting for Sedona Conference. So unfortunately for the firm, I haven't been doing much work.
Well, please help me welcome Matt.
All right, well, thank you very much. Can everyone hear me?
Yes.
Do I get to play?
Well, I wasn't at the rehearsal,
Okay,
so
sorry, I have to
we'll
look
have
forward.
to see when we can do that.
Okay.
All right, well, thank you very much and good morning, everybody. It's definitely an honor to be here, and it's definitely an honor to be here with Judge Sheehan. As she had mentioned, Ohio Civil Rule 37 was amended on July 1st of 2021. And what it did is it tracks the federal rule now, 37E. We've had some amendments to multiple rules lately. 26B1 was amended in 2020 relating to proportionality to mimic the federal rule. And then recently we have the addition of Evidence Rule 502, which we did not have previously in Ohio, which tracks the federal rule. So we're seeing a lot of changes in terms of that. And so what's good about that is, since this is so new, we're able to look at federal cases to kind of see, how courts are handling these different things like we have here with 37E. Now, in 37E, what we're doing is you look for what the culpability was and then determine what are the appropriate sanctions. And for that, what you do is, and there's a couple different, scenarios and types of sanctions you have. In 37E, you have to see, was there a duty to preserve data? Was that data lost? Was that data lost because of a party's failure to preserve it? And can that data, and this is ESI, can it be replaced or somehow obtained through additional discovery? So if that's the case here, and if you look at it, then you can get to sanctions. And there's essentially two types, two versions. There's E1, which you see here on the screen. And basically, it's the prejudice. If you find prejudice, but you're not looking at intent to deprive here, just prejudice on the party, regardless of how it occurred, then a court can issue measures no greater than necessary to cure that issue. And so, again, these are all, in a sense, sanctions, but sometimes you will hear under E1 is curative measures, not so much sanctions, although it technically is.
So just to drive the point home, because I know we'll talk about it a lot, but you may say, they destroy data, haha, I get sanctions. But that's not necessarily the case. You still got to show they were prejudiced at well, not at a minimum. Under E1, you have to show that it wasn't just like you deleted my Ring doorbell and I don't really need that, I'm going to get sanctioned. There has to be it has to be relevant and prejudice has to occur.
Right, exactly. And so that's a good thing. If you have a case like that and you feel like the elements weren't properly found, that's when you take it up to the appellate court. So first we have E1 with prejudice, and then we get to E2. E2 is intent to deprive. And what is intent to deprive? That is where you're going to look to determine whether there was really bad faith in doing it. And if there was a reason, they actually deleted the information. And if that's the case, you're going to get harsher sanctions. And the sanctions that we could see here is that a court can presume that the information was unfavorable to the party. The court can also instruct the jury that it either may or must presume that it was unfavorable to the party. And we'll talk about what scenario in a minute. And then you can also have dismissal or a default of a case if the sanctions are severe enough. And so you do see that in some cases, and sometimes you don't, because that's a very, very harsh sanction. We had something recently, it was on the news last year, related to the opioid litigations. There was a case in Tennessee where the court felt that the sanctions were so severe, or the e-discovery issues were so severe that they actually issued a default judgment and a $1 billion judgment against the pharmaceutical company. That had since been reversed, I think, based because there was a motion to recuse the judge pending. But that's where you could see, significant problems if you make sure if your client's not taking care of data. So next is...
This is a reiterate. I just don't think you can say it enough. There's 4 requirements, and you have to meet each one of those in order to get your sanction. So it's easy to be, like I said, oh, they deleted the data, but that's not good enough. So go ahead. Sorry, I jumped in.
Okay, so, yeah, exactly. So you have 4 questions that have to be asked before you can even get to sanctions. And all 4 of these must be proven. If any of them cannot be proven, you're not even going to get to the sanction part. So that's another thing to look at in terms of whether you have a case and whether to bring that, a decision that you did not like up on appeal. And the first one, as you see, is was there, in terms of relevant ESI, should it have been preserved in anticipation of litigation? And we all know what that is. You do preservation, legal hold, that sort of thing. So first of it, was this data that should have been preserved? Because that also goes into proportionality, because not only is there proportionality in discovery, there's proportionality in preservation. So should
it be before the complaint is even filed?
Right, exactly. Before the complaint, if you're put on notice, which we'll talk about a case in a second where that was a scenario, put on notice that you should have preserved it and you didn't. If the answer is you should have and you did not, and it's yes, then you can move on to the next question. If it's no, then you don't have to even go to the other questions because you cannot get sanctions. So
Before we move on, though, we talked a little bit about this. Is it the lawyer's obligation to send out a preservation letter? If you don't know what a preservation letter is, tell your client, make sure you preserve all your electronically stored information. Can the lawyer get in trouble if they don't do that? Has that been developed?
Yeah, it's not fully developed. A lawyer can be sanctioned for failure to do that. I can tell you there are cases where they did and did not get sanctioned. So, it is a best practice. There was a case recently where it said, it didn't sanction the attorney, but chastised the attorney for not sending out a legal hold, but stated that ultimately it is on the party to preserve the data, regardless of whether the attorney did it or not. And that case was based upon a case called Paisley Park, which is, if anyone recognizes that name, and you don't have to raise your hand, it relates to Prince. And after he passed away, there was a loss of some data, and the court basically did not sanction the attorney, but stated that, the duty is on the party to actually preserve the data.
What about the plaintiff, too? Like, if it's a plaintiff and they have a cell phone and they have text, are they out? Like, if you're a plaintiff's lawyer, should you also tell your client?
Oh, absolutely. It's you have to preserve the data. Especially if you're going to bring litigation, there's really going to be a high standard looked upon you. You want to bring it, but yet you didn't preserve any of the data because you think you're a single plaintiff, and then maybe you're up against this big company, and they're the ones that have all the discovery. You can't lose sight that you have to make sure that you preserve certain things. And in the world of e-discovery, more and more things are being sought after. And it's not just text messages, it's instant messages, it's WeChat, it's anything, messaging on your phone. And so that has to be considered, that if you're going to bring a litigation, make sure that your party, that your client, can comply with everything if you want the other party to comply as well. So that would be important.
Okay, what does it mean to be lost?
So lost is pretty simple. It's you don't have the data anymore. So that is the second question. If the data is lost, then you can go to the next question. If it's not lost, then you're not going to have sanctions. So generally, it's pretty straightforward. You're going to bring a motion if the data was lost, and if it wasn't, you won't bring a motion.
What if it was deleted, but it's backed up? Is it lost?
Well, it's not lost. That would be the fourth question.
Okay.
And
Wait, then skip 3. Let's go back to 3.
So you're in charge. You're the judge. You're all right. So basically, and this kind of goes to the question about preservation. So it was lost, but wasn't lost because of the party's failure to preserve the evidence. And again, the yes or no question. And maybe there wasn't a failure to preserve, or not failure to preserve, but reasonable steps taken to preserve something. You'll see cases where, so they put a litigation hold on something, and a phone, for instance. And then there actually is a case out there where the phone, unfortunately, which had very relevant information on it, was stolen. Now, I have doubts as to whether it was stolen, but the court did say, well, the plaintiff did, file an insurance claim, so there's evidence that it was stolen, and so there were no sanctions for that type of lost data or for failure to preserve. That was a failure to preserve case. And so you do have scenarios where, maybe someone, it was lost, but it wasn't, they took reasonable steps. It wasn't foreseeable that the phone would be lost if you were to believe that the phone was lost or stolen. So that's a scenario where you could have a no, and then you don't go to sanctions on it. And there wasn't sanctions on that case. And I remember that one was, it was a GoDaddy case. It was a wrongful termination case. And so then you go to the fourth question, can it be restored or replaced? And being restored or replaced, as the judge said, maybe it's backed up. So if it's backed up, it's going to be, you can restore it. If it's emails, and say you deleted one email account, but hey, those emails are also in this individual's account, well, again, it might be a question of fact, but you can argue that, that is restored in a sense or replaced. You can get other scenarios where a case we'll talk about briefly today where you have data, and that was data that you could utilize for a certain element of the case, for damages, for the opposing party. This would have been able to help them establish their damages, but you lost it, you deleted it. So then the question is, okay, do you have other data? And in one case, which we'll talk about, yes, there was replacement data. It wasn't the same data because that data is gone, but it was a different type of data, and the court held that that data could be used for the same purpose, therefore it was replaced, therefore you don't go to sanctions.
This seems to be a hotbed of arguments. Like, there's always going to be an argument whether it's replaced. The plaintiff might say, well, I took a photo of that text, and so I have the text. And then the other side will say, but I don't have the metadata to go with that text. I mean, it's going to be perpetually.
Yeah, no, absolutely, that's important. I don't know if Alex is still here, but he had, well, not him, but his firm had a famous case out of Southern District of New York where it was a fraudulent text. It wasn't a real text. And it was the individual took a photo of their old phone because they couldn't screenshot it because that phone was broken. Turned it over as a PDF. They're like, oh, well, we want to see the metadata, of that picture. And so they sent the picture over. There was no metadata showing that an iPhone X took a picture of an iPhone 5. And unfortunately, both of those phones were broken. And so they weren't able to access them. And I know Alex's firm, Littler, New York, they hired an expert and actually proved that it wasn't even an actual text message. They looked at the font. They looked at the emoji, they looked at the picture of the battery icon, and they said these did not exist on an iPhone 5 or iPhone X, therefore it was just completely altered evidence. So, yeah,
I like when they go to get their phone repaired at Verizon and the tech accidentally cleans the whole phone.
Right.
And better yet, the lawyer goes, it's okay to go to Verizon and get your phone fixed. Right. You shouldn't do that either.
Yeah, no, that happens.
So if you fulfill all four of these, what do you get?
Well, now you can go to sanctions on whether it was prejudice or whether there was an intent to deprive. And prejudice, again, is pretty simple. Was it prejudice to the party who could have benefited from the data? And if so, again, they're going to have measures, that can kind of be curative in nature and fix it. But the bigger one is intent to deprive, and that's what people are going to look for there. And so the question is, what is intent to deprive? Now in this one, you don't have to actually show prejudice like you do for E1, so we're going to talk about E1 versus E2. You don't have to show prejudice, it's going to be presumed. But we're looking at bad faith, and we're going to look at intentional destruction of data for intent to deprive. It is not going to include negligence or gross negligence, unfortunately, for those of you who want to go after someone. And one of the main reasons of it is that you could negligently delete, or your client can negligently delete their data, and that data actually has been, useful for them or helpful for them. So that's why, negligence isn't there. And the new rule really does split it up between, prejudice and intent to deprive. So it's going to be bad faith. And a good way to kind of explain and show the difference is showing what are examples of prejudice versus an intent to deprive. And for prejudice, you might see an example would be you failed to turn off the auto delete, such as on your cell phone text messages. You always want to tell your client, turn that off, because a lot of people have it deleting automatically in 30 days. Same with email systems. A lot of companies have email systems set up for auto delete, so you want them to turn that off. But if for some reason they just didn't, even though it was on litigation hold, if there wasn't that intent to just make sure you got rid of the data so the other party doesn't get it, you're going to see a curative measure. That's going to be prejudice. Also things like, you have a 1-year retention policy, but you started deleting all your stuff in 6 months. Well, unless there's some evidence that you did it on purpose, so the other side couldn't get it, you're gonna see just only prejudice there. You'll also see like a failure or delay in issuing a litigation hold either by counsel or by the company, because a lot of companies do that themselves. Also, you can do litigation holds on certain devices, and like we talked about, the cell phone and emails. So that might be just something that's prejudice as opposed to intent to deprive.
Unfortunately, it seems like we just have to learn from case law and other people's mistakes on a lot of this, which again, go back to federal law, because really the federal rule has only been around 7 years.
Yeah, it was 2015.
So there's not a ton, and everything's really district court decisions or magistrate decisions. So there's not, I think there's 2 cases out of the Sixth Circuit? There's not a lot.
Not many cases at all. So yeah, very small in terms of Sixth Circuit, but that's why we look to all around for federal and see what kind of cases are coming up, just to see how different things are handled. And all courts decide things differently, as you all know. Burden is one of them. Who has the burden? Usually on motions to compel and whatnot, the moving party has the burden. But in this instance, burden is not placed on an individual party, one party or the other, under this rule. And the court has discretion to determine who the burden is going to be put on. And what you will see sometimes is, and the committee notes stated to the federal rule, is that sometimes it might be unfair to put it on the moving party. So what I've seen in the case law is definitely the courts go different ways depending on what it is, but maybe the different element, it will determine which party has the burden. For example, is there anything in existence that is relevant? Well, it might be unfair for the moving party because they didn't see the data. They don't know whether it existed or whether it's relevant. And the case will reference really quick about, video cameras, the movement doesn't know whether there was video on there because they didn't have it.
I appreciate the employer who had the video camera, and supposedly there was a fight, and they said, well, the plaintiff's got to prove that we did have it. But they were the ones who controlled the camera.
Right, exactly. And they control the camera.
The court didn't buy that one.
Yeah, no, they didn't buy that one, and so they said, you know what, the burden's going to be on the other party because they had the ability to do that. So you will see the burden, different, and then who decides it? The judge usually decides what it's going to be, whether there's intent to deprive, but in certain circumstances, the judge may have the jury decide whether there's intent to deprive and then let them know. If you find an intent to deprive, then you may use that and say that it was unfavorable to the party who lost the data. So you may take that into consideration.
Do you think that happens more than not in really egregious cases? Like, I'm really surprised that the judge has the option. The judge can decide intent to deprive or give it to the jury with a jury instruction and let the jury, so now the jury's going to hear all the facts and determine whether that party had an intent to deprive and delete that.
Right, and it's something you don't want, but that is a measure. It can be considered a curative measure if you find prejudice. Okay, I find prejudice, I'm going to now send it to the jury to find intent for a much harsher sanction. So that's what you'll see in these cases.
But I would say, oh, God, there's a question.
Well, at what point are you getting into what a spoliation claim is, right? Because I feel like you get a jury once you rise to the level of spoliation. And, what's the difference really between 37E and a spoliation claim under the common law?
All right, well, you have 37E, it is spoliation, but it's under a rule. And now what you normally see in terms of spoliation, you'll see the Rule 37 is actually related to e-discovery, or ESI, not documents. You're going to see documents come under common law.
You could still have e-discovery. You could still have a spoliation claim of electronic documents that were intentionally destroyed, right? So you could insist on a jury. If, say, you have a judge that doesn't want to give you a jury. I personally like to have a jury when I can, most of the time. And so, I have a judge that, I say this actually is beyond just Civil Rule 37E. This should be a spoliation claim that goes to the jury. What's the difference?
The difference is, and I think you're seeing now with 37E, they're trying to do a push to have some kind of structure in terms of sanctions when it comes to electronic discovery. So this is similar. We had a 37E prior to this, and it is very similar to it, but now it gives structure. And the reason why the federal rule changed in 2015 was to give structure to the spoliation of e-discovery, and to give, to kind of point out to the fact that you have prejudice and you have intent to deprive, and what a judge can do there in terms of versus just a common law spoliation, because you're mostly now seeing it under 37E, whereas you're seeing just regular documents under the spoliation type of thing.
And I would think this is right during the case the spoliation occurs, which is you're filing a spoliation claim after. Like that's your whole claim primarily. But
Yeah.
so it gives and then you have to be careful. Do you file your motion under 37E1 or 2 or both? I don't know.
There's a lot of overlap. It's
There's a
really,
lot.
and when do you file it? Do you get it in the same case?
Right.
Does that prejudice?
And sometimes they'll wait till after the files their motions, and then there's a lot of things to still bubble up on this. We just want to hit a couple highlights, practitioner points. It seems the theme in these cases, if you're the attorney, do everything you can do, and you're less likely to be sanctioned. So one of the cases that Tony had touched on, we've all seen this where you do as a lawyer everything you can do. Here's my litigation hold, I gather all my documents, I told all my clients, and there's always that one employee who opens up the drawer right before deposition and goes, well, did you want this? And only in this case he had it all stored at home on a hard drive, then he transferred to a thumb drive, and then he transferred to another drive, and then cleaned his computer. I don't know why people feel the need to clean their computer, but it happens. And that happened in a case, and the court said, okay, you know what, the employer was very forthcoming. As soon as they learned, they produced it. The employee said, yeah, my employer didn't know I had this. The employer tried to do everything right and ultimately was not sanctioned. But those scenarios come up versus the employee you mentioned with the plaintiff's case, where the attorney didn't really research what the plaintiff was giving him as far as, here, it's a harassment claim, and here's the text that proves the whole case, and ultimately it's proven that text was fraudulently created, and the attorney got sanctioned in that one for not doing more diligence and making sure that it was legitimate. Did I summarize those correctly?
I think you did. The first case was Metadata versus Viva Systems. That was out of Southern District of New York, September of 2021. And that was a case where the kind of what we just referenced is it looks like it was brought under E2, intent to deprive, but not E1. And the court did not discuss E1 at all. And again, they just completely lost data, and it was, I guess, an accident. But they went for intent to deprive, and therefore didn't even look for prejudice, and there probably could have been prejudice there. In terms of the one we talked about, the text message, that's Rosbeck versus Montefiore, Southern District of New York, August 2021, fraudulent text message, and the attorney just really didn't, basically didn't instruct the individual to preserve the data and allowed this, in a sense, charade to go forward because of their failure to do that. And then the last one we mentioned, we kind of referenced videotape earlier. That one is, it's Hollis versus Seva Logistics, and that is a case where they actually sent it to the jury instead of the judge deciding on the intent to deprive. And I just had a couple quotes from it. The court basically said, look, I think it probably is an intent to deprive here, but, a competent attorney can argue that their client was incompetent as opposed to intentional. And they said, humans are just as likely to be dim-witted as they are dastardly. So in that instance, we're going to send it to the jury to decide whether there was an intent to deprive.
So our time is up, but I would say if you have a lot of these questions, not only look to federal law for guidance, but doesn't the Sedona Conference put out to the public, to practitioners, documents?
Yeah, you'll see there's a Sedona Conference. They do things called commentaries in addition to their Sedona principles, where if you have a question on e-discovery, and including spoliation, Rule 37, Tom Allman, he's from Cincinnati, he has publications on the Sedona Conference website which talks about all that, and does the difference between 37 and spoliation and all that. Gigantic ones. And then we also have secret ones that haven't come out yet, but expect to see one hopefully soon related to 37, an updated one. So.
Well, thank you so much. Our next speaker is going to move down. So the last hot topic is en banc, which I've never filed a motion for en banc. Has anyone here filed a motion for en banc? There's like more and more en bancs getting filed all the time. So we thought, maybe we'll talk about this, because why all of a sudden are we filing, there's this increase in en bancs?
Excuse me, Judge Sheehan?
Yeah.
We're getting some feedback from the online participants that they're not able to hear the speakers. So if everybody could make sure to lean in and speak loudly and clearly into the microphone, that would help. Thank you.
Thank you. Is that better? Okay. I probably was too far away from the microphone. So en banc. For those that don't know, I mean, Jim's going to cover it, but I don't even know where to begin with this title. When you ask 12 people where they would like to go to dinner, all the judges, if there's two opinions in conflict, then all 12 of us will review that legal issue. But Jim has the unfortunate job of being our en banc lawyer. So that means not only Jim was a judicial attorney both in common pleas and the Court of Appeals, and then willingly took this job as en banc lawyer. And all he does is review the motions for en banc. Jim is also a certified appellate specialist that Judge Boyle had mentioned, and he's also a graduate of the Ohio State Law School. So please help me welcome Jim McGlone.
Thanks so much. As Judge Sheehan said, I am the 8th District's en banc staff attorney. So a huge chunk of my work entails basically facilitating conflict resolution. And the reason why I exist is that we have a
We like you more.
yeah. We have a very diverse court and a large court with 12 judges, and they have backgrounds from all over the legal spectrum. We have formal prosecutors, partners from civil law firms, trial judges with decades of experience, former magistrates. We even have a former nurse. So we have a lot of different perspectives that go into our decisions. And so conflicts in the way that we view the law inevitably bubble up occasionally. And the en banc process is the way that we resolve those. And en banc really boils down to promoting consistency in the law that you get out of our court. And so the purpose of the whole process is to iron out instances where perhaps we're not being consistent with a past decision, even if it's from decades ago and we simply need to clarify that it's no longer controlling law. The en banc process exists to remove that ambiguity so that practitioners, parties, and trial judges know what the rules are for the law as they're trying to apply it below, and they're not confused by perceived differences from our court. Our court takes it very seriously. Other courts have, I think each court in Ohio does it a little bit differently. Most of the courts are smaller than ours, so their process is a little bit more simplified. But with our court, all 12 judges will look at these en banc applications. They'll get a detailed memo from me analyzing whether or not there is, or at least I perceive there to be a conflict in the law that's being raised, and they'll take a hard look at it and decide whether to proceed and potentially resolve the conflict. And then, if it does, in a rare instance where we do acknowledge that there is indeed a conflict, our process for resolving it is quite time consuming. That the judges really put a lot of work into a full-on en banc opinion and straightening out the law. And you'll get in the rare instance where we do send out an en banc opinion, you'll see the judges will develop them in great detail and explain the different positions and even the side that might not come out as controlling in the end, they'll still have an opportunity to say why they think the law should be otherwise. So these opinions are very big endeavors. But from the practitioner's perspective, we can get into what an en banc is exactly and what it's not. And it's probably easier to define it as what it's not, because they are fairly rare to have a legitimate en banc conflict. it's not an opportunity to re-argue your case. And that's sort of the biggest thing I see on failed en banc filings. It's just a party will use it as a Hail Mary and essentially re-argue things that have already been addressed by the panel, even instances where they simply think that, hey, I think this Ohio Supreme Court decision means that I should win this case, and you didn't rule the way I wanted to, so I think this is a conflict in some sense. But that's not a conflict.
Do you think practitioners are saying, well, this panel got it wrong, but if I get it in front of all 12, they're going to get it right?
Right. Yeah, that certainly is. But in the
do we have that authority to overrule another panel?
No, and not certainly not in the en banc process. It's not designed for that. It's designed for a one-to-one conflict resolution where a prior panel addressed either the same exact black letter law and said the law is XYZ, and a new panel says no, it's ABC, and we have to hit that head on. But those ones are fairly rare. The more common instances of an actually successful en banc is where the court agrees on what the black letter law is, but when they're applying it to nearly identical facts, they come out differently, and that's when we have to really sit down and see the nuance and how our judges look at the law and how it should be applied.
See that very often?
More often than the black letter law conflicts, yes, but still, it is a rarity. I was looking at our numbers yesterday, and I think that amongst all the en banc filings we have, which often approach 60 a year, only about between 1 and 4 a year are legitimate en banc conflicts that we accept and we resolve. So over 95% of the en banc filings we reject because either the party has filed something that is just frankly frivolous, or the parties are arguing that dicta is in conflict, or some other variety of issues. But yeah, it's when you do have a legitimate conflict, it sort of jumps out and hits you in the face, because you can tell practitioners or trial judges will be confused on what the state of the law is.
Well, can you touch on, because motions for reconsideration and motions for en banc are filed at the same time, right?
Yeah, and that's they are supposed to. You have a 10-day window when your case is when our court sends out its decision. You have 10 days to file your Appellate Rule 26 motions, and recon and en banc are the two main ones where you can ask the panel for reconsideration if you feel that they have misapplied controlling law, made an obvious error. En banc is a much smaller subset. Recons are more common. En banc is strictly limited to claiming that a prior 8th District case basically got the law the complete opposite, and that we need to resolve that conflict.
Well, before we move on from that, can you touch a little bit about the paths? So it's in one motion, a motion for recon and a motion for en banc, but do they take different paths and how they're going to get resolved?
Oh, absolutely. The motion for reconsideration can commonly be resolved by the panel fairly quickly. It's just the 3 judges on the panel. They'll look at the argument that they've completely missed something and that they need to change course on recon. And they can deny it fairly promptly if they want. That can be handled in a matter of weeks or so.
It's not held in abeyance until the en banc's resolved?
Occasionally it can. That's a discussion amongst our court as to how our judges like to do it. I like to encourage them to hold off on ruling on motions for reconsideration when there is a pending en banc in the same case, because it allows our court an opportunity to issue a reconsidered opinion that might moot an en banc. A lot of times we'll get conflicts that are arguably unnecessary, where we went down one path and potentially put ourselves into a conflict bind, but if we had just chosen an equally applicable path, we could avoid the conflict. I saw there was a question in the back by Judge Forbes.
We actually ran out of time in our presentation, so I'm going to take a smidgen of yours. What is the different test that you apply? Like, what do we look for on the appropriate way to resolve a reconsidered motion? Can people fix a trial or a court of appeals opinion that they don't like by asking for reconsideration? Will you state the question?
Sure. So Judge Forbes was asking sort of what the appropriate standard is for a motion for reconsideration, and there actually is a black letter law definition that I'm sure I'm going to mangle off the top of my head, but it has to be an obvious error in the panel opinions analysis. For instance, a controlling Supreme Court decision that the panel did not apply, or other controlling precedent that they clearly have missed or run afoul of.
Anyone been successful having a motion for reconsideration granted? It happens.
They do happen. We issue far more motions for reconsideration than we do en bancs. And in fact, many times we'll get an en banc filing, and I'll look at it and say, hey, we do have a conflict here, but it's a completely unnecessary conflict. We can even keep the same outcome on this case and simply issue a reconsidered opinion, but go down an equally applicable pathway that gets you to the same outcome. So it's kind of, the conflict might be irrelevant in that instance, but in order just to keep clarity for the law, it's still a good practice to issue the reconsidered opinion so that future readers and trial judges aren't confused by our court saying different things. So the recon is a very, very important tool that sort of coexists alongside en banc.
I didn't mean to get you off track.
Oh, you're
so
fine.
back to filing a successful en banc.
Let's see, where are we at? Slide.
It's impossible to read from here.
Yeah, right. So the most important thing when you're filing it is to take a hard look at both Appellate Rule 26 and Local Rule 26. And the biggest component, and one that we see that gets you kicked out administratively without a thorough analysis, is the first one here. You really need to give us a concise description of what the conflict is. If I read your motion and it is meandering and I can't tell what exactly you're arguing as to conflict in the law between various decisions of our court, then that's a quick way for the motion to simply be summarily denied. You have to also provide citations, so tell us exactly where in the relevant opinions, the current opinion and the prior cases, tell us exactly what paragraphs are in conflict and how they're in conflict. You also need to explain why this is relevant to this case, why we need to resolve this conflict. If it's just a conflict that stems from dicta or it has no bearing on the outcome of the case, that's not going to get you an en banc opinion.
And it's important that it could be administratively dismissed before it goes anywhere.
If you don't comply with the rule, and it is jurisdictional, that 10-day window to get in your motions for recon and en banc is a very hard deadline with a very tiny exception for extraordinary circumstances, basically. And if you don't read the rule and comply with it, you're going to miss your bite at the apple for both recon and en banc. Not that en banc should be filed nearly as often as recons. You don't want to equate the two. En bancs are a much smaller segment that should only be used when there is a one-to-one conflict with prior 8th District decisions.
And I know you're going to talk a little bit about a few of our recent en bancs, but before, can you pull the curtain back a little bit and tell them a little bit procedurally how we handle these motions for en banc and the process so that they know when they're writing it, where is this motion going and how is it being handled?
Sure. So when they come in the door on day one, I'll immediately take a look to see if it complies with the rules. There are numerous instances where a case will be administratively dismissed by the administrative judge for failure to simply comply with Local Rule 26 and tell us what the conflict is, give us some citations. We get numerous filings, very rarely by attorneys, but more often by pro se litigants that don't even give us an 8th District case. Or you file your en banc motion and your alleged conflict is between your current decision and the Supreme Court decision. That's just not an en banc. That's not the purpose of en banc.
If it's administratively dismissed, is there a way to fix it or is it done?
No, it's pretty much done. In rare instances, de minimis non-compliance with the rule will allow the AJ an opportunity to let you correct it. For instance, if you under the rule, you're supposed to file your recon and en banc jointly. If you're going to file both, you can't. If you're going to file an en banc with a recon, you have to do it in one 10-page motion. So we will often allow parties who file that separately a chance to file a corrected motion. But nothing is going to save you from the 10-day period. If you don't get your motion in on time, it's going to be administratively dismissed. In fact, we have to. We just don't have jurisdiction at that point.
And that's not circulated amongst all 12 judges so much as it's between, the AJ takes a look and determines, right?
Yes, so that's still in sort of the administrative process. I'll flag a motion that just simply doesn't comply with the rules. It's not an actual en banc motion worthy of the 12 judges reviewing it, and we will, in appropriate situations, it'll just be administratively dismissed. But assuming it gets past that sort of screening phase, then I will take a hard look at the alleged conflict, and I'll provide our judges with a memo sort of giving them a neutral, objective analysis as to whether or not I think this is a conflict, whether or not I think the Supreme Court will view this as a conflict, because if we don't, we're duty bound under their decisions to resolve our conflicts, and if we don't, then we're shirking our duty. And so I will tell our judges honestly when I think that maybe they've created a conflict, even when perhaps they don't want to hear it. That's sort of.
So what kind of time frame can a practitioner expect that to take place from the filing of the motion en banc until you circulate a memo to the judges?
Under the best of circumstances, it should be between 2 and 3 months, depending on how many cases we have had filed on any given year, or if we have a really large decision like some of the ones I'm about to highlight. It can take longer. It can take up to 6 months or so. And in the rare instance where you do hit on an actual conflict on a substantial area of law, it can take a significant amount of time because of the back and forth with our judges in resolving the conflict and drafting an en banc opinion.
Those were all my questions.
No worries. So we have 3 en banc decisions from the last 3 years, I think, that are worth highlighting. The first one is probably the biggest en banc decision that we've done in about 4 or 5 years now, and that was State versus Del Valle. And if you're a criminal practitioner, you've probably encountered this case by now. And it dealt with the constitutionality of the Reagan-Tokes Act. And this is actually the rare example of a black letter law conflict, where this is not a panel is stating the same law as the prior panel, but they're applying it, the same facts differently. This is straight up whether or not a statute is constitutional, and some of our judges believe that it was, and some of our judges believe that it was not. And so we recognize this from the inception. I don't think anyone was surprised. Reagan-Tokes was a long time in the making, and we, from the very first few cases, I suspected we might have a break in how judges would view these constitutionality questions, which were very substantial.
By the way, not all appellate districts have determined in their district if it's constitutional or not.
Oh,
I know it's pending in the Supreme Court.
It is. This is still an issue, and Reagan-Tokes, I think, went into effect over 2 years ago now, and we're still at a place where we're waiting to hear from the Supreme Court on whether or not the final answer on constitutionality. I do think that
Cavalli's been released from jail, but
yeah, he might be out already. It has taken a long time, and that is sort of an important thing to highlight here. When you have a conflict like this, that it is a conflict on black letter law and substantial issues, resolving it takes a long time. It's very time consuming. In this instance, we knew immediately when we had a conflicting decision from a panel, before we even released the case, we knew that we were going to have a conflict on this. We have a couple tools for situations like that. We can hold off on releasing a potentially conflicting decision and try to resolve the case internally, or we can release the case and immediately acknowledge that we have a conflict and let the parties know. In this instance, I think the benefits of releasing the conflicting decision were very helpful. this is the only case I'm aware of where we let the defense bar and the prosecutors come in and raise oral arguments on en banc about whether or not which side of the constitutionality coin they felt was correct. So this was as thorough an en banc as you can get.
Which, by the way, another procedural note, when we've agreed to take an en banc, there's no order that says we're going to take it, right? We just hold it, and then there's no order. That's the first oral argument on an en banc I'm aware of.
It is. This one was a sua sponte en banc, so we didn't wait for the parties to tell us, hey, what are you doing? You just issued conflicting. We acknowledged it from the get-go that hey, we know that there's a split of authority in our court as to how to resolve this important constitutionality question. In a case that does not get sua sponte treatment, a party will file a motion, and if it is a successful en banc, they might not see the result or hear anything from our court for a good amount of time before suddenly we issue an en banc opinion that says, yes, we acknowledge there's a conflict, and here's the fix to it.
So no news is good news.
Yeah, so no news is good news. In fact, and again, the process is very time-consuming. I think Reagan Tokes took somewhere between 6 and 7 months to fully resolve, and the phrase "iron sharpens iron" really does come into play here. You know, our judges, at one point I think we had 6 judges that were considering writing on this case. I think we ended up with 4. And the exchange of the various drafts between the writing judges made each draft stronger as the judges considered, the other side's view of things, good points raised by someone on the other end of the question, and they would address, each other's issues. And so, internally it can be a stressful process, but it actually results in very, very high quality work. So the process might not be super fun, but it is good for the law.
But if it's denied, you don't always get an opinion saying why it's denied, right?
If in a lot of instances, my test on this one's actually pretty simple. If the motion in an average practitioner could look at the case and immediately know why we've denied an en banc motion, we will issue a rather plain vanilla denial entry without any decent explanation. If it's an instance where I think there's some confusion that could arise, or it's a close call, and I think the Supreme Court might not understand why we've denied something just looking at it on its face, we'll provide a brief but detailed explanation as to why this is not being accepted for a review.
We have a couple minutes left. Is there one?
I have a question. Can you discuss the sua sponte en banc, please? And
Sure.
how it happens and how our court processes it?
Sure. So Judge Boyle asked about the process for sua sponte en bancs. We have 2 different tracks actually on that. Del Valle illustrates one of those, where our judges proceed to publish a decision that is in conflict with a prior black letter law decision. In Del Valle, it was yes or no, is this statute constitutional? And we will in a sua sponte en banc like that, we'll almost immediately, we have 10 days in order to issue an entry alerting the Supreme Court that we know we have a conflict, that this case is going to stay with our court through the resolution of that. The 45-day period to the appeal to the House Supreme Court doesn't run until we resolve our en banc. So as long as we issue a sua sponte en banc entry within 10 days, we retain jurisdiction on that case. The other track for doing sua sponte en bancs is a quieter, more internal process, and that's where a panel prepares a decision that is going to conflict with a prior decision, and any one of our 12 judges can raise their hand and say, hey, I don't think that what we're about to do here is consistent with past law. In that instance, we handle the entire thing internally. We get to the point where the opinion is otherwise on its absolute last step. It's ready to go out the door. There's no voting to be done at that point. The panel is resolute in their resolution of the case. And then we'll do an internal en banc process at that point, and it could result in an en banc opinion as appropriate. But that's the alternative route.
We got 1 minute. Anything else you want to summarize?
To summarize, again, only 2 to 3% of these are successful. They will delay your case a decent amount of time. So if you're filing these and you think it could arguably be frivolous. I would encourage you not to. We have a good number of filings, not so many from the attorneys, but definitely from pro se litigants that are rather frivolous or close to frivolous. And again, when you file an en banc, that is just not a good conflict argument. You're putting that in front of all 12 judges, and so that's a quick way to sort of
What's your recommendation
build a
on
reputation.
filing a brief in op?
I would always file a brief in opposition. You don't ever want to leave the court, if you're a litigator on the other side, you don't ever want to leave the court with just one side saying, hey, this is a conflict and you need to resolve it and you need to resolve it in my favor. The entire case can get flipped on that. It can be very important. So if you're a practitioner on the other side and oftentimes you've won on the original opinion, you're going to want to defend it and file a brief in opposition and argue, hey, this is not a conflict. The alleged conflict cases are distinguishable because of X, Y, and Z. Don't take this case.
And you don't get a reply in an en banc, but for a regular appeal, please file a reply brief. They're really important. That's my plea, message of the day. Any other before we? Oh, yeah.
Judge and Jim, is there a provision in the rule that provides for frivolous conduct when filing the en banc when you know it should not be filed?
No. So the question was, do we have a provision in the rule regarding frivolous conduct in relation to en bancs? The answer is, at present, no. Usually we weed those motions out fairly quickly.
But there is a Rule 11, and then we have a
There is-
appellate Rule 2. So.
Yes, you still are bound by Rule 11. You should not be filing frivolous motions. It's not a second bite at the apple. It's not I want all 12 judges to review my case. And the judges, they recognize when you file a motion like that. So it can be a negative way to build a reputation if you file frivolous en banc motions.
Well, thank you, everyone.
So thank you, Judge Sheehan and Jim. We're going to take a 15-minute break. I think we're just a couple minutes behind schedule. So if everyone can return by 10:47, there's coffee and water behind us. Thank you. court administrator and magistrate at the 8th District. She is a certified court manager. Prior to rising to the position as court administrator, Erin served as a judicial attorney, a staff attorney, and the deputy court administrator. Erin has over 20 years of experience at the court. You probably could not find a better person to moderate a discussion on practicing in the 8th District Court of Appeals. Erin's detailed legal experience prior to joining the court is detailed in her bio, which you can find on the law school's website, along with all the written materials for this segment and the other segments. Outside of the court, Erin is a passionate advocate for persons with disabilities, and she proudly serves on the Down Syndrome Association for Northeast Ohio. Please welcome Erin O'Toole.
Thank you very much. Can everybody hear me? I just want to take a second here and thank Bridget. Without her, this would not have happened. And of course, all of our judges of the court being so committed to education and interacting with our court users and practitioners. So also thank you all for attending here in person or on Zoom. And thank you to Case for hosting this, and specifically Eric, thank you for all you've done for us. We have a lot of material to cover because, as you see here, we have Andy, Jake, and Dave. They're our staff attorneys. They have a ton of duties at the court, but in addition, they serve along with Jim to answer questions. They will call you. You can talk to them directly. You can walk in and talk to them. We are committed to serving the public and you as practitioners. They will answer your questions of appellate procedure, but please reference the materials that we have on our website before you call, because they do have a lot to do. So,
but we won't do your research for you.
Thank you. Here we represent over 80 years of combined experience at the court, and that doesn't include, and if you throw mine on that, let's say 100. So really, if we don't answer what you're looking for here today, give us a call. We're available to you. So let's begin.
My name is David Parcham. I have been a staff attorney with the 8th District Court of Appeals for over 32 years. Among our duties is to jealously guard the jurisdiction of the court. And the primary way we do this is through screening of cases. Screening began even before I came onto the court, when the judges examined a file and questioned whether there was a final appealable order. So they put the file on the podium, and when the appellant's attorney came up, they said, Counselor, show us in the file where there is a final appealable order. And that was the start of the screening process, so we get an opportunity to determine whether this court has jurisdiction. We look at a few other things. We look at timeliness, we look at finality, we look at the briefs to make sure they are compliant with the rules, and there are a few other things we'll look at. But the primary purpose is to guard the jurisdiction of the court. Now, in regard to timeliness, you all know you have a 30-day time limit in which to file your notice of appeal. If you miss that 30-day window, you're clipped out, the court doesn't have jurisdiction, we couldn't help you even if we wanted to. A couple of things to remember. Probably the most new important thing to remember is that with the advent of electronic filing, judgment entries get entered on a Saturday and Sunday sometimes. Pursuant to case law, this is when the clock begins to tick for your filing of your notice of appeal. It doesn't kick over to the next Monday. So look and make sure that you are filing within 30 days of the file stamp on the journal entry, even if it's a Saturday or Sunday. Also remember, there is a potential problem for months that have 31 days. If you say, oh, I got 30 days, just go to the next day of the month. Well, if the judgment comes out on August 15th, and you wait until September 15th, then you already hit 31 days and you've missed your appeal as of right. We occasionally run into what I call double clutched entries, where the judge will enter the final appealable order, a full judgment, on July 1st, and for whatever reason, the judge re-enters it on July 10th. And you file somebody files a notice of appeal on August 5th, timely from July 10th, but not July 1st. In those instances, the first one counts, and that's what we look for in regards, one of the things we look for in timeliness.
And Dave, just to be clear, it's not the non-count that you're talking about. These are the exact same entries.
Right.
Entered for whatever reason.
Right, that is correct. That is correct. And occasionally, if we look in a day, it looks like the notice of appeal was filed 1 or 2 days later, well, I'll pull out my calendar and do the computation to make sure that the 30th day wasn't a Saturday, Sunday, or legal holiday. Because if the 30th day does fall on a Saturday, Sunday, or legal holiday, then the due date kicks over to the next day the court is open. But the primary thing we look at is finality. And as Judge Forbes said earlier, generally that means all of the counts are resolved and all of the claims against all of the parties are resolved. In the criminal area, the dismissals with prejudice, the dismissals without prejudice, and the nollies of counts all count toward creating a final appealable order. So we will examine and make sure all of those counts are taken into account. Now, pursuant to Baker and Lester, on a sentencing entry, you must have all of the convictions that are specified, the fact of convictions, and a sentence for each count. And it must be all in one document. Now, and occasionally, especially in municipal court cases, we've had problems with this, where the judge on the form checks off guilty on day 1 of a DUI, and then when the sentencing comes around on day 10, this judge just puts in a 180-day jail sentence. That's not a final appealable order under Baker and Lester, and we will have to either send the case back if it looks like it's an authentic clerical error, or dismiss the case if there was an authentic problem. Similarly, blanket sentences can be a problem. This usually comes up in terms of community control, where the judge says there are 3 counts, and the judge says, I sentence the defendant to 3 years community control. That's not good enough, because there isn't a sentence for each count. And this is pursuant to a case called State against Dumas. Instead, the judge has to put in defendant sentenced to 3 years of community control on each count. And under those situations, that will obtain a final appealable order. And as the judge said, occasionally we'll come into all sorts of problems, especially in the multi-count cases, where it's not clear whether or not sentences should have been merged or as allied offenses, or you get some strange journal entry like, count 30 is sentenced on count 30. That creates a jurisdictional problem, and we will look at the transcript to see what really happened, such that, there really was an explicit resolution that counts 30 and 31 were to merge. And if that's the case, the court has the right, and has often done, a remand to the trial court to remove the potential jurisdictional impediment. Otherwise, if we look at this and say, no, there really never was a resolution at count 30, the court will dismiss the case for lack of a final appealable order because we don't have jurisdiction.
And if I can just jump in right here, we are trying to prevent that from happening by putting it on the docketing statement. You are supposed to be going through that and certifying to us that you have a sentence on every count. So please do that, because that'll help your case be streamlined.
On the civil side, once again, all claims against all parties must be resolved. And I'll put down all of the parties, I'll put down all of the claims, all the counterclaims, third-party complaints, and cross-claims. And as I'm going through the record, I'll check them off to see whether or not everything has been resolved. There are a couple of special rules. As Judge Forbes said, you can dismiss an entire party without prejudice, and it will count toward creating a final appealable order. But you can't do that with individual claims, such that if you brought a claim and you got assault and battery, negligence, and breach of contract, and you get your judgment on summary judgment for $25,000 on breach of contract and you're satisfied, you just can't dismiss the assault and battery and negligence claims without prejudice. Rather, you either have to get 54B language, you may dismiss the claims with prejudice, or you may file an amended complaint eliminating those claims, and then you have a final appealable order. Cases that are referred to magistrates can present special problems. First of all, after the magistrate issues the report, the judge has to approve. If the judge just says, "Oh, I approve the magistrate's report," that's not good enough. Pursuant to a case called State against Zinni, the judge must state the actual judgment. Judgment for the plaintiff in the amount of $25,000. And if you don't have that, there's not a final appealable order. Similarly, after the magistrate issues their report and the judge signs off on it immediately, the party has 14 days in which to file an objection. If objections are timely filed, there must be an explicit resolution of those objections, or there is not a final appealable order, and we don't have jurisdiction. So make sure when you're bringing your case that the magistrate's boxes are checked. And occasionally, we'll find some really peculiar procedural problems. Picking up with Judge Forbes's example on a John Doe, we recently had a case where 10 John Does were listed. And there was not service or naming of the John Does, and judgment is rendered for the defendants before a year has elapsed. So the John Does are still outstanding. However, in this particular case, this was a refiled case. And in the first case, the John Does were named too, and more than a year had passed. So this presented the court with a peculiar procedural posture, and the court asked the parties to brief it. And in this case, the party said, "Oh, we have a final appealable order because of this distinguishing characteristic." And the court said, "Okay, we'll go along with that." But the main thing to remember here is when we come across these rather bizarre incidents and we issue an order to the parties to brief this jurisdictional issue, please take this very seriously. Read the cases the court cites, because that will tell you where we're coming from and what our thinking is. And then do your own research, do additional research to help the court resolve these serious jurisdictional problems. We also look at the briefs to make sure they are compliant with the rules, that the briefs are signed, that they have all of the component parts, especially the assignments of error, and that it comes within the page limitation. Remember, for page limitations, the assignment of error and the statement of issues presented count toward the page limitation. And if you start getting over that area, like you get 41 and a half pages, well, you're getting into the how lucky do you feel category. Will the court strike your brief? and say we were requiring a new brief compliant with all the rules, or we just may issue a warning saying the court accepts the brief as filed, but notes that the brief exceeds the page limit by a page and a half and appears to have footnotes in less than 12-point type.
We prefer you comply with the rule.
Yes, and in the future, the failure to file a complete brief in compliance with all the rules may result in the court striking the brief, requiring a new one, or imposing other sanctions. And Andy?
As part of the screening process, we take a look to make sure that there's compliance with local Appellate Rule 13.2. A little background. In December of 2013, this court adopted local Appellate Rule 13.1, which deals with electronic filing. Going forward, all attorneys, and not necessarily pro se litigants who can take advantages of the electronic filing, are required to file electronically. What does that do? It gets out into the internet. We have the clerk's office has on their website the ability to list everything that's filed in a particular case, and you can go to the clerk's website and look that up. That same applies to the appeal process, where you have everything from the notice of appeal to the final judgment to the motions for reconsideration and the en bancs that are online. They're either TIFF files or they're PDF files, so anybody can go to a particular case and look at that particular case. Now, 13.2 was put into effect to ensure that certain information was not revealed to the general public, and that included personal, private.
Andy, I'm sorry to interrupt. Can you speak closer to your microphone?
Sorry.
That's okay.
13.2 was put into effect to prevent the release of personal, private, and confidential information through the internet, such as social security numbers, financial documents, driver's license numbers, names of juveniles, and victims of sexual offenses. The most important part that we look at when on the briefs is the juvenile names and also the victims of sexual offenses, because, and Dave likes to say, well, this information can get out to the general public, and it can be used, if you're a child, can be used to bully you, or your employer can use this in the future, because everybody has a social record now through the internet, basically, and it can be used to say, oh, well, when you were 15, were you the subject of a sexual attack? Well, that information does not have to be revealed. It does not have to be. So we passed 13.2, and 13.2 is applicable to all documents filed in the court. It includes, but is not limited to, the notice of appeal, press fee document statement, the affidavit of indigency, also known as the poverty affidavit, briefs and motions. Local 13.2B1C specifically provides that a juvenile's name, except for the juvenile's initials or a generic term, such as child, son, daughter, must be used instead of the juvenile's actual name. Now, the majority of the cases that we deal with this particular issue are juvenile delinquency cases and also adoption cases or parental rights cases. So we screen those very carefully to make sure that no information with regard to the children, or if it goes back to the mother or the father to allow you to identify the children, is in that brief. I just screened a brief the other day where we had to strike the brief because the attorney included parts of the transcript. And the parts of the transcript were with regard to testimony from one of the caseworkers. And the caseworker specifically stated, well, Joan or Sam or Bob or mother or father, the actual names were part of what was repeated in the brief. We have to strike that entire brief. What the party should have done is said mother, father, child 1, child 2, or child 3, or even grandmother or grandfather. So please, in the future, be careful when you're writing your brief to make sure that there's no identification of the juveniles or a victim of a sexual crime. We protect the victims of the sexual crimes to make sure that their name is also not mentioned within the brief. So if you have a victim of a sexual crime or multiple victims, use victim 1, victim 2, or V1 or V2.
Or something like high school senior, something like that.
Just so you don't have the actual name of the parties in there, because we look at these briefs very carefully. You don't want to have to redo your entire brief, because if you're appointed, I don't think we're going to pay you twice for doing the exact same thing all over.
No.
You gotta move a little quicker.
Yeah, we are really trying to protect the kids and the victims so they're not bullied. And if you use a parent's name like Fred Fungible and you use the kid's initial as DF, well, that identifies the kid as D Fungible, and that identifies the kid. And we're really trying to protect the kids. We also check for some other things, like is this case appropriate for the accelerated calendar? Is there a conflict of interest in hot topic issues, such that in the constitutionality of Reagan tugs, we listed and noted all cases raising that issue so the court could get a good grip on just how extensive and what we need to do to make sure it's all consistent.
I just wanted to add, with regard to 13.2, in the materials that's handed out, we have a copy of a notice of appeal that was properly redacted. We have a copy of the judgment entry from the trial court that was properly redacted, a copy of the Presbyterian docketing statement that was properly redacted, a copy of the affidavit that was properly redacted, and finally, a judgment entry from this court which struck a party's brief because they did not comply with 13.2. So that's all in the materials. If you want to take a look at that.
And I am finished, and that's the basic screening process in a nutshell.
Thanks, and Andy, could you go over the amendments to the rules?
All right. As everybody knows, there's two sets of rules that apply to all of appellate practice. There's the general rules and the local rules. The local rules modify the general rules in certain fashions or in addition to the general appellate rules. I'm going to go over three rules that were changed on July 1st, 2022. Mediation, local appellate rule 20, oral argument, local rule 21, and amendments to local 46, appointed counsel fees, which I'm sure everybody's interested in because that involves the money. Amendment to local rule 20, mediation. 20 controls the mediation program. Prior to the amendment, all revised code 149.43 original actions that dealt with public records were referred to a panel or to mediation. The mediator would then draw the parties in. They would take a look at and see if they could settle the case, because it's usually a matter of, well, I wanted these records, you did not give me these records, please provide these records. And then there'd be an attempt to settle. David Shively, who's our mediation program authority, he did a very good job in mediating these cases. However, there were certain objections filed by certain panels that did not want to go to mediation. So what we've done is we've changed under C that all cases do not go to mediation under 149.43 public records cases, but it's up to the panel whether they wanted to go to mediation or not. Under 20D, it was provided for a stay of appeal on mediation, and it was for 60 days. That's been modified. It's not automatic 60 days to go forward from the date of reference. Once the mediation is over with, your case goes back into the hopper, and then it goes forward from there. Mediation 20D added to clarify the counsel of record for every party, as well as the parties themselves, must attend the mediation. Language also emphasized that if a party to an action does not have full authority to settle the case, then a person with authority to settle the case shall attend the mediation. Copy of the local rule is in your handouts. Local Rule 21.
This is a big one.
Local Rule 21 governs oral argument. Prior to the amendment, which was effective on 3/1/22, Oral argument was presumed on all cases. You didn't have to do anything. If you wanted to opt out of oral argument, you could file a motion with the court, but that does not apply anymore. What happens now is that if you want oral argument in front of the 8th District Court of Appeals, you must request oral argument. The request is made on the cover of the brief. Don't put it down in a little 10-point type or anything like that, or at the bottom of your signature. Make sure that it's in bold letters, request oral argument. Now, one party is all that is sufficient to request oral argument. Both parties do not have to request oral argument for it to go forward. So, for instance, if the appellant requests oral argument, it's set for oral argument. If the appellee requests oral argument, it's set for oral argument. Do not use the reply brief to the answer brief to request oral argument. It's either in your main brief or in your answer brief.
And just as a caveat to that, we do allow you to request Zoom arguments if you prefer that. And we have that laid out on the website, how you would go about doing that, or give us a call.
Okay, 21A1 lists how parties now will be notified of a hearing, including reference to the court's website for viewing the oral argument schedule. We have a complete schedule going forward, I believe, 6 weeks now?
It's 5 to 6 weeks.
5 to 6 weeks of cases that are scheduled for oral argument in the future. 21A2 requires that the parties be notified of the date on which the case is submitted to a panel for a decision when no oral hearing is requested. So, people look at that schedule and say, well, I didn't request oral argument. And I'm scheduled for a hearing. Well, if there's no oral argument scheduled, that is the date that the panel will consider that particular appeal, and then they will conference the appeal and then come up with an opinion. Make sure that you understand that you're limited to 15 minutes of oral argument, and that's it. In certain circumstances, you can request in advance by motion to extend the 15-minute period of time, but that's very, very rare. If you want rebuttal time, make sure before you start your oral argument that you petition the court that you would like to reserve 15 minutes or 5 minutes, 7 minutes, 8 minutes, whatever you want for rebuttal. Amendments to Local Appellate Rule 46, appointed counsel and fees. Local Rule 46 expands the appointed counsel list to include attorneys, appointed counsel in juvenile and termination of parental rights cases. It clarifies that appointed counsel seeking reimbursement for fees must attach 2 documents to the application for fees: a completed financial disclosure form and a copy of the judgment entry appointing counsel to the appeal. It clarifies that the applicant for a payment of attorney's fees shall be filed with the clerk of the appellate court, not the clerk of the trial court from which the appeal was taken, or the county. It gets filed with our clerk of courts. It clarifies that the timing of when to file an application for fees no earlier than the release of the opinion and no later than 30 days after the appeal has been journalized. If you miss that 30th day, you may be penalized by no payment of fees or a reduction in the fees. I want to emphasize, 30 days is 30 days is 30 days, unless it falls on a weekend. But even then, please file within 30 days. And finally, I have attached in the material, we have an application to serve. The application is only good for 1 year. You have to renew your request to be appointed counsel on a yearly basis. I've also attached the motion and certification for appointed filing fees, a listing of the itemized fee statement, and also a schedule of the fees that have been adopted by Cuyahoga County. The fees are no longer part of the rule. They are listed as an appendix because they're constantly changing.
They'll be reevaluated every 6 months.
Okay.
And can fluctuate.
Yeah, so then they go up. I don't think they're going to go down.
Could go down.
But
it's tied to the reimbursement amount that the public defender gives to the county, so it's a budgetary rationale. But they will never go below what they were prior to July 1st.
Now, the most important thing about local Appellate Rule 46, 30 days. Get your fee bill in. If you don't get your fee bill in, you're not going to get paid.
One other thing I would like to add, I'm sure you're all aware, but if you're not, the oral arguments that you're having are being recorded. We're obligated to do that by rule. We're doing audio recordings. It's the Appellate Rule 21J. Anybody can request those. We have a form for it under our forms, and you would just submit it to the email that's specified on the request.
Oh, and with regard to oral arguments, we have a process in place where an inmate may request oral argument if they file a pro se brief. And we will consider that. And then if the institution has a process where they have a camera, we will then allow oral argument by that pro se litigant.
Yes, we've been doing that all throughout the pandemic. I believe they joined by telephone at this point, but it's through Zoom.
All right, I'm going to talk a little bit about motion practice in the Court of Appeals. Just some motion basics. In writing, filed with the clerk for the Court of Appeals, served on the parties. Be specific in your motion, especially in the relief that you request. If you include a memorandum in support, your conclusion paragraph could be exactly what you want the court to do. There's an option in the rules for a hearing on a motion in Appellate Rule 15. That is exceedingly rare. Most motions will be decided on the briefing that's filed. Your motion must also be signed, even though there's no appellate rule that sort of indicates that. We've interpreted Civil Rule 11's requirement for signature through Civil Rule 1 and Criminal Rule 1 to apply. So your motion needs to be signed with a signed certificate of service. The time you have to file a motion, then you have 10 days, the other party has 10 days to file a brief in opposition, and the rule does provide 7 days for a reply brief. However, the court may rule on procedural motions at any time, even before the time period has elapsed for a response. If you are affected by that, then you can file a motion for reconsideration within 10 days of that. So what is a substantive versus procedural motion? I'm not going to spend a whole lot of time on this, but substantive creates, defines, and regulates rights versus procedural is the manner in which rights are enforced. So what happens when you file a motion with the Court of Appeals? It's filed, say it's e-filed with the clerk's office for the court. It's processed by their staff. And this process isn't immediate. It can take time for them to process depending on the queue that they have at that time. And then it's transferred into our system, which is a separate system, and it also has to be processed by our court staff. So as a practice point, if you're filing an emergency motion in the Court of Appeals and you need to set yourself up for immediate or you want immediate decision, you can't really control that, but what you could do is you could call the Court of Appeals, ask to speak to a staff attorney, tell them, hey, look, I'm filing this motion in this case. It's very important that I get a ruling as soon as possible. We can then alert our staff and the clerk's office staff to keep an eye out on this case to make sure we get that motion as soon as possible, and then we can get it to our administrative counsel as soon as possible. So that's what happens. The motion goes to the administrative counsel, and then it go generally one of three places. If it's a first motion for extension of time, the court administrator, Aaron, will rule on those motions. If it's a procedural motion, it could go to the administrative judge most often, or it could go to a rotating panel, motion panel of judges. It rotates throughout the year.
Jake, I just want to, your emergency is not necessarily the court's emergency. So be aware that standing around in the hallway is not going to accelerate the process. Once it's filed, we know what we need to do.
These are some of the types of motions that each of the different options would handle. I just want to circle back to something Tony said about non-pro-tonc entries. If a non-proton entry is entered after the notice of appeal is filed, the Court of Appeals isn't necessarily aware of that, especially for a municipal court case where that may not be included in the record. So if you may want to file a motion to supplement the record with that attached journal entry of the non-proton entry. If you want to remove any sort of question of validity of that order because the non-proton was entered while an appeal was pending, then you may wish to file a motion for a limited remand so that we could remand the case, the trial court could re-enter that order. There's no question of its validity then. Or if you want that to go away, you may argue in your brief, hey, look, Court of Appeals, this entry was entered without jurisdiction. So maybe even if you affirm, maybe you want to remand it back to vacate that order that was entered without jurisdiction.
That just makes me want to jump in right here on motions, just so everyone's aware in the criminal arena, the PSIs and the psych reports, we don't get those automatically, and you should be asking motions to supplement the record to include those, so that you have all the information that you need to advance your appeal on behalf of your clients.
I also want to highlight Appellate Rule 5 here. If you're in a criminal case, if you're filing a motion for delayed appeal, you need to serve the prosecutor's office. And similarly, if you're a prosecutor filing a motion for leave to appeal, you need to serve the public defender's office. And at the same time, you want to set your appeal up so that the court is in a position to do everything quickly right away if your motion is granted for a delayed appeal. So file a motion for transcript at state's expense or for appointment of counsel so that we can handle all that at once and get the appeal moving forward. But did I say there were 3 options? There are actually a 4th option. It's our entire special effects budget right here. The motion can be referred to a merit panel. This can happen if the motion panel or the administrative judge feels that this should be a ruling that should be put in the hands of the panel hearing the case to decide. So if you get a journal entry that says the motion is referred to the merit panel, you won't get a ruling on it until a merit panel is assigned. And that doesn't stay your case. So your briefing schedule is still the same, your brief is still due. If you need to file a motion or the court needs to enter an order staying anything, this doesn't automatically stay your schedule. So those are some examples of things that may be referred to the merit panel. And one of those things may be a motion to dismiss. We see practitioners do this in a couple of different ways. They may file a specific motion to dismiss the appeal for, say, lack of a final appealable order. Or they may argue that in the appellate brief sometimes. So how does the court handle those? Generally, if you file a motion to dismiss, there it is. Generally, if you file a motion to dismiss, it's going to be handled by a motion panel for the most part. And the motion panel may decide that it should be referred to a merit panel or not. So you may get a ruling soon, prior to your briefing schedule on that. But it may be referred to a merit panel, and then it will be decided after briefing. But if you argue it in your brief, most of the time that's going to go to a merit panel. So those are just 2 different options. But let's say you file a motion to dismiss, and it's before the record has been filed with the Court of Appeals. How's the Court of Appeals going to handle that? There is an appellate rule that is exceedingly rarely used. Appellate Rule 10F allows for a party to designate portions of the record to be sent to the court by the clerk's office to decide the motion. If you decide to try to use this rule, be prepared for some blank looks from the clerk's office. They probably aren't familiar. They probably haven't had one in a long time, if ever. I talked to our administrative counsel. She's not seen this rule used, and she's been there for several years.
A while.
So you may need an order from us. You may file a motion with us directing the clerk to, and that's something you would give the clerk to say, hey, look, here's an order from the court, please do this. But what we see more often is that parties will attach, as Appellate Rule 15A allows, parties can attach things to motions and affidavits. So we see certified copies of journal entries or time-stamped entries from the lower court record, and you may want to include an affidavit with that saying these are part of the lower court record. Court of Appeals, you can consider this in deciding this motion.
You could just really run quickly through the Zoom protocols.
Okay. Oh, I did want to mention, just because Newton left it up to me.
Oh, yes.
For Appellate Rule 4A. Local Appellate Rule 4A is different because it's not included in the Ohio Appellate Rules. We've developed a procedure for handling 60B motions that are pending below. So if there is a 60B motion pending, you can ask us for a limited remand. We'll send it back. The trial court can rule on that motion. And then you need to file a separate notice of appeal from the 60B decision, and then move to consolidate that with the current appeal.
That was important, so thank you.
I'm going to skip the post-judgment motions. Jim talked about that a little bit. But I did survey the judges and asked them for anything they liked or didn't like about, basically 2 years of Zoom hearings. And so some of the things that I got are an appropriate place to argue your appeal. And to be well lit, minimize distractions. A car is not that place. At least 2 separate oral arguments occurred where attorneys argued from their car. I asked an AI to draw what it thought this would look like, and it was as equally confused as the judges who witnessed this in person. And if your office is not free of distraction, you may want to implement a virtual background to sort of free up if you have other coworkers or family members or pets in the background who may distract the judges or your audience from your argument. Virtual background, but make sure it's appropriate. Virtual background, palm trees swaying in the breeze, probably not appropriate from the solemnity of an oral argument.
And so just to be clear, this example is an inappropriate background.
Also, judiciously use the mute and unmute buttons and familiarize yourself with that and practice with it. Some of the judges even called out their colleagues about not using it enough. So just make sure that you do use the mute and unmute buttons. And finally, video. Some oral argument practitioners, some attorneys were just doing audio oral arguments without their video on. Some of the judges found this less than optimal. They liked it when they could interact with attorneys and see them. They also, one of the comments was that the appearance wasn't what you would normally see if someone was coming into the courtroom to argue. So make sure that you dress appropriately and look presentable while in the argument.
Thank you. Yeah, just keep in mind it is a courtroom, so whatever you're going to wear in the courtroom, wear to the virtual courtroom.
I just want to add one thing. When we're screening these cases, sometimes we come up with a final appealable order issue that's not addressed by any parties. The court will issue an order to the parties to brief the issue. Please respond to that particular order. If we don't have a
Keeping them
response
from lunch.
We'll make a decision without input from the parties.
Thank you. Thank you guys.
Also, we're available, like Aaron said, if you have a question, give us a call, ask to speak to a staff attorney. There's a staff attorney on call. So.
Thank you for your time.
So please feel free to grab a box lunch that you'll find against the wall behind here. And you're free to eat during our next segment. Judge Sean Gallagher will be presenting for an hour and 15 minutes, and then following his presentation, we'll have another 15-minute break. Okay, thank you.
Can I tell a joke? Can I read a joke? It's Greg Groves. Okay. Time for another joke then at that point. It's right here. Yeah, okay, whenever, I'm fine though, I gotta go get my water. Are you sure? No, it's not. Maybe it is. Wait, no, it is. It is.
You quiet, but then you may holler a little more. So how's everyone doing? I'm Judge Anita Laster Mays, and I have the honor of introducing. What, someone was clapping, they wanted me to sing? Look, how are you doing? No. I have the honor of introducing Judge Sean Gallagher. Judge Gallagher and I have been friends for a long time, and one of the things that I always say about him is that he knows the court from the custodial work through the judicial work, because at some point he was a custodian, he was at the court, juvenile court I should say, he was a probation officer, a bailiff, a trial court judge, and now an appellate court judge. And so you can ask him anything about the court and also the secret corners around the court as well. But this presentation that he is about to do is a very good and interesting presentation. And it's a landmark case, and he tells it so well. He's a very good historian within the court, and he brings that knowledge also on the bench with us. And so, again, it is my pleasure to introduce Judge Sean Gallagher.
Thank you. Thank you, Judge. Judge, my favorite judge. You are my favorite judge. To invoke Judge Larry Jones, Judge, our former colleague Larry Jones would always refer to us as his favorite judge, usually when he wanted something, but but he did mean it. And Judge Mays, thank you so much, and all the other judges that are here. Judge Groves, I'm not sure why you're not sitting with Greg, but my wife would make a comment about me if I wasn't sitting there. But no. So anyway, I thought I would start out, though, with a little bit of humor. My cousins in Ireland always like to give me some Irish jokes, so I always like to go through these. And excuse me for kind of reading this one a little bit. It's short. So this fellow Murphy walks into the police station and asks to speak to the head of the Garda. The Garda in Ireland is the police department. And when the chief comes out, Murphy tells him he wants to be, a member of the police force. And the chief says, come back in my office and have a seat. I'd like to ask you a few questions. And the chief says, what's 2 + 2? And Murphy says, right, that's easy. The answer is 4. Okay, what's the square root of 100? And Murphy thought for a moment and answered, I think it's 10. The chief said, you're doing great. Now, can you tell me who killed Abraham Lincoln? And Murphy thought about it for a while, and he replied, no, I can't. And the chief told him, find out who killed Abraham Lincoln and come back and see me. So later in the pub that night, a guy named Sullivan asks how the job interview went, and Murphy replied, not only did I get the job, but the chief already put me on a murder case. So the Irish love those stories. So I'm going to cover 2 cases today, Mapp v. Ohio and Terry v. Ohio, and I like to do this from a completely different perspective because everybody that's a lawyer has read Mapp v. Ohio in law school, or you read Terry v. Ohio in law school, and if you're not intimately aware of all the details and the law that it represents, we'll touch on some of that, but believe me, I'm not going to be citing to paragraph 34 of any opinions or referencing anything like that. I like to take a different approach on law and history, and let's look at the people that were involved in the cases. Who were these people that made up these cases? And I think you'll find this rather remarkable, that Mapp v. Ohio was really a story about 2 different and separate cases that were intertwined. And within Mapp v. Ohio, there's arguably 2 separate legal issues that were decided during the course of the case. So I'm going to go through this, and we'll take you back in time a little bit. There's a little bit of Cleveland history here. And I think it's an interesting story, and I think you're going to see some things that you did not know about some people in the past. So let me start this out. This is Dalry Mapp. She was also known as Dolly Mapp. She was born in Austin, Texas on Halloween in 1930. She was the 4th of 6 children. Most people don't know this, but her father was a Cherokee Indian, and her mother was African American, and her mother was a school teacher in Texas. So in 1940, when she was 10 years old, in an effort to, obviously the South wasn't the greatest place for a young African American girl, so she had a relative in Cleveland, and the families agreed that Dolly would move to Cleveland and live with her aunt and take advantage of educational opportunities and economic opportunities that were in the North. And she moved into the neighborhood in Cleveland that is kind of adjacent to Shaker. I think a lot of us like to call it the Cleveland school system that gets Shaker schools, or the Cleveland neighborhood that gets Shaker schools, that kind of reference. But she was a very bright student by all accounts. Many of the autobiographies that have been written about the case describe her as very outgoing, very assertive, and she was very popular with her schoolmates. Now, Alex Chandler Burns was an individual that was originally born in Hungary, and his family came to the United States in 1907 when he was a very small child. Now, he went by the name Chandler, which is an offshoot, I think, of a Hungarian reference for Alexander, but in Cleveland among his friends, he was simply known as Sean. He was just the short Sean, so the people that were associated with him. Now, as a young adult, Burns was arrested 18 times over a 12-year period. In 1925, he was arrested and convicted of auto theft, and he spent a year in the Mansfield Reformatory. You remember the building for Shawshank Redemption. So he would have been there if there really was a Shawshank Redemption. He probably would have been one of the inmates with all the people in that movie. He also was convicted of bribery in 1933. He only did 60 days for a bribery conviction in 1933. He lived off of Woodland Avenue in the Jewish Quarter, South Woodland, that area, not far from where the cemeteries are when you're going out Woodland Avenue. Now, over the course of his criminal career, Burns often beat charges by producing alibi witnesses, paying for alibi witnesses, or influencing jurors with bribes to acquit him. So he was a well-known figure in Cleveland underworld circles. Here's one of Burns's arrest photos or mugshots. Now, he couldn't be in the mafia because he wasn't Italian, but he was indeed very much involved in the mafia and interacted with them regularly. He developed a reputation as a brutal, ruthless enforcer. He often worked with the mafia to establish a lucrative protection service. He ruled by fear and intimidation. He often used bombs as preferred method of sending a clear message to anyone who crossed him. He extorted money on a weekly basis from numbers and policy operators on Cleveland's east side, predominantly all African Americans that ran the policy and clearinghouse games on Cleveland's east side. Burns would extort money for him. Now, despite the extortion, in many instances, he had what can be described as a good relationship with many of these operators, in part because he helped keep the peace between groups. Now, in terms of his criminal background, he also had a number of front businesses, if you will, to shield his criminal activity. He often referred to himself as a labor consultant, and he described himself as an executive of the Union Supply and Towel Company, which I found out was located originally on East 34th Street in Cleveland. He also owned a place on Chester at 1011 Chester, which surprisingly enough was known as the 1011 Club. And he also owned the Alhambra Tavern at 103rd and Euclid. So he had legitimate business interests that were out there, but his primary operation was in the rackets and in enforcement and working with the mafia and other underworld figures. Now, let's talk a little bit about the numbers rackets. I look around the room, and most of you were born after the advent of the Ohio Lottery. And the Ohio Lottery was passed by Ohio voters in 1973. The first game came into play in August of 1974. And we didn't really have what we would call the machine lottery, you know, where you go to the gas station or you go to the delicatessen or the corner store. That didn't come in until 1979. But back in the 30s, 40s, and 50s, particularly in African American communities in large major cities in the north, there were numbers games. And there were two primary illegal gambling games in the 40s and 50s, which were called clearinghouse and policy. Now, clearinghouse games were also referred to as a numbers game. It involved players picking a number 000 to 999. Now, you think the Ohio Lottery is so creative. They stole all of their games from African American operators in the past. I mean, they stole literally. They copied them exactly as they were. Even the clearinghouse game and the policy game was with ping pong balls. And as I did this research, I kind of snickered and laughed at remembering when you watch that show that's on at 7:15 every night when the ping pong balls come out. I mean, it was like a policy game in a black neighborhood 50, 60, 75 years ago. So all those things were stolen from these operators and legitimized for, of course, tax purposes. So policy, though, came from the idea of having an insurance policy. So what an operator might do is approach you, not unlike the drug trade where there are code phrases and names. An operator might approach you and ask, do you want to buy an insurance policy? Well, that means you want to play policy. You want to play the game. So people would do this. Now, on this slide, there's an image of a book here called New Gipsy. It's a dream book. So how did this work? What were these dream books? Well, you go into delicatessens today and you see like there's the Cleveland Scene. It's free. You pick it up, right? There's apartment magazines you can pick up for free, Auto Trader free, Cars.com free, whatever. These policy books were often produced by numbers operators and distributed around the community, or they were sold in some instances. But a dream book would be this. Let's say you went to sleep last night and you dreamed about a train, a locomotive train. You woke up in the morning and you said, geez, I had a crazy dream about a train last night. Well, you could go to the dream book and open up the dream book and look under train, and it would give you a numbers or a series of numbers to play. And so this was one of the ways that policy was played. So policy was the ping pong ball game. Clearinghouse is the straight numbers game. And I mean, it was very, very common. You could pay as little, you play as little as a penny. And these games were racking in $20,000, $25,000 a day for some operators in the community. Just unbelievable. So, how did they work exactly? Well, here's an example of a shoe shine parlor in the late 30s that fronted as a policy house. Like in the back room, that sort of deal. You'd have, not all the games. The numbers operators could come. You send a runner out to come to your house and pick up your bet, but also people could go to a location and play. Now, there were 6 to 8, depending on the era, major numbers operators on Cleveland's east side. Some of them were William Buckeye Jackson. I don't know how William got the nickname Buckeye, but maybe he had some tie to Ohio State, I don't know. Ed Keeling, Elijah Abercrombie, Sam Elmore, Fred Stitman, Virgil Ogletree, and Thomas Turk. Those were the major players in Cleveland. So a writer would collect the bets, and he would keep 25% of the total collected. And these bets would then be turned over to a pickup person and eventually end up at a clearinghouse where all the bets would be tallied by 4 o'clock in the afternoon. Now, very creatively, they had a way of assuring how they could measure if you won or lost. Those involved as pickup persons earned 10% of what they took in, and in the 1950s, winners were determined by looking at the stock market tallies in the Cleveland News. Cleveland News was similar to the old Cleveland Press in that it was published in the afternoons. It went out of business many, many years ago. But under advances, declines, and unchanged, there would be a series of 3-digit numbers, and those numbers would determine whether you won or lost. So everybody in the community was reading the stock pages back in those days. There was a tremendous interest in stocks. But that's how the winners were determined. And then the runner would either come back and pay you your winnings the next day, or you could go to a policy house or a clearinghouse and collect your winnings. But it was all an elaborate operation within the community. So let's go back to Dolly or Dalray map. And every autobiography, there are 3 probably decent ones. The 2 of them focus more on the case but have a lot of information about her. But a woman named Patricia, I'm going to mispronounce her name, Zatane, she wrote a pretty extensive biography of her in the late 1990s. And she described her as charming and cunning. She was very streetwise. She was extremely attractive with model looks. And she used her looks and her personality and her charm to her advantage. And a lot of powerful men, and let's face it, this was an era when men were, controlling everything all the time. And she managed to get the upper hand with many men that crossed paths with her in her relationships or in any of her business dealings. She was very, very sophisticated, and she became involved with a lot of the major gamblers and a lot of the major boxing figures of the era in the 1950s. She would be seen at nightclubs around Cleveland, and so she was a very, very interesting individual. Now, she got involved with Jimmy Bivens, and Jimmy Bivens was a legendary boxer, and they had a daughter named Barbara. And this was a very tumultuous relationship between these two. They were constantly fighting and battling. But Bivens was one of the top boxers in the United States from 1940 to 1953. He had a record of 86 wins, 25 losses, and 1 tie, and he won 31 fights by knockout. He defeated 8 of the 11 world champions he faced during his career, and he's inducted into the International Boxing Hall of Fame in 1999. Now, sadly, Jimmy Bivens died in Cleveland in 2012 under really tragic circumstances. He ended up with a caregiver and was left on the 3rd floor of a residence and basically to rot away and die. And he died there, and I believe the individual was prosecuted for the care that was given to him. So Bivens was a very accomplished boxer and very well known, and Mapp and her tumultuous relationship. But when she left Bivens, she got involved with Archie Moore. And Archie Moore was another world-famous boxer, champion. After the divorce, she got involved with Moore, and at one point, Moore was the oldest boxer to win the world's light heavyweight championship. He was the only boxer who fought professionally in all the eras of Joe Louis, Rocky Marciano, and Muhammad Ali. His career spanned 4 decades, and we'll take a look at this record. 185 wins, 23 losses, 11 draws, 1 no contest, and 131 knockouts. Archie Moore was an accomplished boxer in the world of boxing. So, in the 1950s, Mapp filed a lawsuit against Archie Moore at one point. This shows you how driven Dolly Mapp could be. She filed a $750,000 in the 1950s, folks, lawsuit for breach of contract. What was the breach of contract? He had promised to marry her and reneged on the promise. She also claimed he had assaulted her, and eventually the case was dismissed as baseless. But it does give some insight into just how forceful and strong-willed a person Dolly Mapp was. Now, on May 28th, 1954, Dolly would have her first encounter with the authorities. She was stopped and arrested by officers Carl DeLau and Michael Haney, 2 officers who would later play a role in the Mapp case. She was charged with possession of clearinghouse slips and clearinghouse paraphernalia. She was fined $100. There's a picture of her and Moore after one of Moore's fights. Now, Carl DeLau. Carl DeLau served under General Patton in World War II. He earned a Purple Heart, or was awarded a Purple Heart after being wounded in October of 1944 in France. DeLau was sworn in as a Cleveland police officer on January 2nd of 1946. Now, over his time in the police department, he gradually transitioned over to become involved in vice crimes, and he joined the Cleveland Police Bureau of Special Operations, which was kind of the prostitution, gambling, vice, that type of division within the police department in the 40s and 50s. Now, interestingly enough, on August 9th of 1949 at 2:30 in the morning, he stopped Chandra Burns for speeding on the Shoreway. It made the news because at the time, Cleveland law enforcement had a policy that if you were going over 60 miles an hour for a speeding offense, you had to be booked. So Burns told DeLau, hey, just let me go, I'm Chandra Burns. And DeLau said, no, you're coming with me. Down to the station he went, and he got booked. Well, the news media picked up on this, and of course they ran a story, which I was able to find online. So Burns lived at 1063 Cove Avenue in Lakewood. That's the eastern edge of Lakewood, near Clifton Boulevard, for most of his career. Now here's another interesting figure from the story, which is Frank T. Culleton. And Frank T. Culleton was the Cuyahoga County prosecutor from 25 years, from 1931 to 1956. He personally led the raid on 2 notorious gambling spots, deputizing private agency workers because he couldn't trust the elected sheriff at the time. There's some famous pictures of Culleton and Elliot Ness on some of these raids at Harvard Avenue. If you go under the Cleveland Memory Project of the Cleveland Public Library, there's a whole series of photographs about this era. And Culleton is a very interesting character because he would go out on raids personally. He tried cases personally. He was very active, very involved. And like I say, worked very closely with Elliot Ness. And in 1954, during the Sam Shepard murder investigation, he threatened to remove the Cleveland detectives who were aiding Bay Village on the case unless they acted to charge Sam Shepard with Marilyn's murder. He felt that the Bay Village authorities were being a little too protective of Sam Shepard. And I thought one of the poignant aspects about his life when I read about it was he left office in 1956 and he died in June of 1957. And he reached out to the prosecutor's office. He didn't, he was dead. His wife reached out to the prosecutor's office and asked that 6 prosecutors come and serve as his pallbearer for his funeral, which they did. So he passed away in 1957. Now, following him was John T. Corrigan, and many of you in this room will remember John T. Corrigan. I worked under John T. Corrigan in the prosecutor's office. What some people don't know about him was he was shot and lost an eye in the Battle of the Bulge. Whenever you had a conversation with him, you always knew to look in a certain way so he could make sure he could see and understand what you were trying to convey. But he was elected county prosecutor in 1956. He then served 35 years and retired in January of 1991. So between Culleton and Corrigan, they served, what is the math on that, 60 years, 60-year period where they were prosecutors. Now, one of the things that Corrigan did that will have a play in this map case going forward is he hired a woman named Gertrude Mann. And her name was Gertrude Bauer originally, but he assigned her in the 1950s the map case. Now imagine that, a woman in the 1950s, a woman lawyer, as remarkable as that is assigned a case that ends up as significant as map is in our criminal jurisprudence. And she's given the case, and she handles it all the way through. Corrigan went with her to the very first pretrial, or the arraignment of the case, and she was on her own the rest of the way. And it was an era when really, let's face it, women were second-class citizens in professional circles, certainly in the law. Now, another little side note about Corrigan is in 1960, when the MAP case was pending, it hadn't reached the U.S. Supreme Court yet. MAP's lawyer was a fellow named Alexander Kearns, who I'll touch on in a moment. But Kearns decided to run against Corrigan for the prosecutor job. You can imagine this case is going on, and the two lawyers, or at least the supervising lawyer, Corrigan, was being challenged by MAP's lawyer. So obviously Corrigan won the case, or won the election. So kind of interesting. So what about Gertie Mann? Her friends called her Gertie. She was in the prosecutor's office. I don't know, Greg Groves, you at least probably heard of her. I mean, she was right before kind of all our eras, you know. Not trying to put age on you, Greg.
We both worked for John T.
Yes, right. So Gertie Mann was born in Toledo, Ohio on December 11th, 1904. She graduated from Marymann's College in Toledo. She attended Cleveland Marshall. She graduated in 1940. When I went there, I went to where all the old photos were, and she's the only woman in her 1940 class. Imagine that. It had to be pretty tough. But in a testament to her obvious talent, Corrigan picks her to handle the MAP case from the trial court level all the way Supreme Court level. And as another interesting sidelight about her, she married John Mann. Now, that name doesn't mean anything to you now, maybe, but he was the original prosecutor on the first Sam Shepard case. And they ended up marrying, and John Mann would go on to become a judge after the Shepard case. And in fact, his son, Bill Mann, who some of you probably remember, was also on the case. I'll tell you a fast, funny story about Bill Mann, who is the Gertie Mann's technically stepson. But on December 7th, 1941, Bill Mann was a student at Notre Dame, and that day it was common on Sundays to go to the movies in the afternoon. So at noon on December 7th, 1941, of course, Hawaii time is, 6 hours or whatever behind. He goes to the movies, and when he comes out, everybody's yelling, "The Japanese bombed Pearl Harbor, the Japanese bombed Pearl Harbor, the Japanese bombed Pearl Harbor." And finally, Bill Mann and everybody turns to each other, "Where is Pearl Harbor?" Nobody knew where Pearl Harbor was in 1941, which is not a surprise. Okay, so Don King, yes, that Don King is involved in MAP v. Ohio. Most people don't know this. When you read the case in law school, you don't know that Don King was involved. But he was born in Cleveland on August 20th, 1931. He was also always referred to as the Kid back in those days. He handled some of the most prominent names later in his career in boxing, including Muhammad Ali, George Foreman, Larry Holmes, Mike Tyson, Evander Holyfield. But before all that worldwide success, King was involved in Cleveland's underworld as a numbers operator. Now, Don King was involved in 2 killings during his time as an operator. On December 19, 1954, King shot a man named Hillary Brown in the back and killed him when Brown attempted to rob one of King's gambling houses. The shooting was later ruled justifiable. He was also convicted of second-degree murder in 1966 in the killing of Sam Garrett, who was one of his employees who reneged apparently on a $600 debt. The judge later reduced the charge to manslaughter. King served 4 years in prison. He was later pardoned in 1983 by then Governor Jim Rhodes. Now we get to the story of two cases where two cases intersect in MAP and what I'll call the bombing case and the extortion case. So this is 3713 East 131st Street, and Judge Mays always likes to remind me that she grew up right around the corner from this. But in the spring of 1957, King lived downstairs in this two-family double. And in the mid-1950s, King was paying Burns $200 a week in protection money. Now, Burns went to prison for tax evasion in 1955, and obviously King stopped paying at that point. When Burns returned in 1957, he once again began to extort money from all the numbers operators. Everyone paid except King. So now, 3 days before we get to the MAP case and the MAP search of Dolly's home, in the early morning hours of Monday, May 20th, 1957, a bomb explodes on the front porch of King's residence. King immediately suspected Burns was responsible. He knew other numbers operators like William Buckeye Jackson, Virgil Ogletree, Edward Keeling, Dan Boone, Elijah Abercrombie, Sam Elmore, and Fred Stipman were all associated with Chandra Burns. And these are the actual police photos from the bombing. So King was uninjured, but surprisingly to many, King went to Delau, Detective Delau, because he knew Delau was the one person who could respond to Burns' attack. And again, many were surprised that King would go to the police. But in the end, Burns and others, all the other operators, were charged with blackmail based on the information provided by King. King told police how the numbers operators worked, what the deals were, what the arrangements were, how much everybody had to pay, and everybody was charged. And this was a high-profile trial in Cleveland in the late 1950s. So, during the pendency of the case, King is shot. He informs the police about the activity of Burns and numbers operators, and now he's on his own. While the blackmail case was pending against Chandra Burns and the others, King was shot in the back upon returning one night as a warning not to testify. Fearless, King testifies anyway. Now, Dolly would also be called as a witness in this trial to testify. She got on the witness stand and refused to say anything, and she told the judge, I'm afraid to say anything. If I say anything, I might end up where I don't want to end up. So she was called as a witness to testify. She didn't testify. All the defendants were found not guilty because the only real evidence against them was King's testimony. And that just wasn't enough to support a conviction. So they all went free. Now, 3 days after that initial bombing and before this trial took place, this is Dalry Mapp's residence on Milverton Avenue, 14705 Milverton Avenue. It looks very much like it did back in those days today. Two-family residence, even though it doesn't look like that. Mapp resided with her daughter Barbara in the upstairs section. But on that day, Thursday, May 23rd, 1957, Delau shows up and wants to come inside. Now, the reason why Delau and the police show up at Mapp's residence is they're looking for Virgil Ogletree, who they believe might have been the bomber of King's home. And they also want to go in there because they think there's going to be gambling, paraphernalia, policy slips, clearinghouse materials, or whatever. And at that time, after a bombing like this, of course, the police are coming down hard on all the numbers people. And so they show up at the door, they pound on the door, and Mapp shows you, I mean, you're talking now about, what is this, 57 to today? That's, what is that, 60, more than 60 years ago. She's smart enough to say, you got a warrant? I mean, think about all the cases we have where people don't ask for a warrant, but she was smart enough to ask for a warrant. Not only did she ask for a warrant, she gets on the phone and calls her lawyer while the cops are outside. And she calls Alexander Kearns, who's her lawyer, but actually the person who answers the phone is Walter Green, another lawyer, because Kearns is not in the office at the time. And Green advises her, well, do they have a warrant? And she says, I don't think so. And she goes, well, if they don't have a warrant, don't let them in. And Green decides he's going to go over there, and he brings his camera, And one of the sad points of history, he takes a bunch of pictures, but then stupidly exposes them, ruining the film. So we would have had photos of all this today if that hadn't happened. But that home is 4.2 miles from this location that we're at today. So this is all very local and very local history. So Thursday, May 23rd, 1957. He doesn't have a warrant, so Delau calls the supervisor. He actually had to go up to the corner and use a phone. No cell phones, folks, in 1957. So the supervisor says another officer is coming out with a warrant, and when that officer arrives, a search commences. But police really don't have a warrant at that point. Police do find Virgil Ogletree and some gambling records. Virgil was in the basement. And they also find 4 obscene books in Mapp's residence. Now, the books were titled The Affairs of the Troubadour, Little Darlings, London Stage Affairs, and Memories of a Hotel Man. Can't make this stuff up, folks. So Mapp is arrested, and she's charged with felony possession of obscene materials under then 2905.34. So here is the one-page police report, and there's a lot of one-page-isms in this case and the following case. So Delau files this police report covering the activities of the police following the bombing of King's home and the search of Mapp's residence. There's no mention in the report about getting a warrant or the absence of a warrant. And at the subsequent trial of Burns and those numbers operated, again, Dolly was called as a witness, but she refused to answer questions out of fear. So these cases were kind of inexplicably connected together in one form. So now, what about this obscenity charge? Revised Code 2905-34 at that time said that no person shall knowingly have in his possession or under his control an obscene, lewd, or I can't even pronounce that. Lascivious. Yeah, I know. I always have trouble with that, you know? Print or picture. So you could get a fine of not less than $200 or more than $2,000. How about this? The penalty was 1 to 7 years, an indefinite term of 1 to 7 years. So Mapp initially pleads guilty on July 8th of 1958, but then she subsequently withdraws her guilty plea on August 1st of 1958. What's the one thing we all know? That ain't happening in today's world, right? You try to withdraw a guilty plea today. So her trial was commenced in September of 1958, and the jury quickly returned a verdict of guilty. This is the one-page complaint that was filed, and again, you know, she was quickly convicted. Now, she was represented by Alexander Kearns, who I mentioned earlier. He was the past president of the Cuyahoga County Bar Association. He was active in Republican politics at that time. He graduated from Central High School, Baldwin Wallace College of Law, and Cleveland Law School. And again, like I said, he ran against John T. Corrigan for prosecutor when the Mapp case was pending. He lost that election, and he died in February of 1968. So, the motion to suppress. A lot of one-isms, I said in this. It was one page. Want to remind everybody out there that likes to ask for extensions of space in their briefs that this was a one-page summary brief in the most important criminal case in American history. So and how about this? He cited no cases. He cited the Ohio statute that said you have to have a warrant to have a search. So sometimes the easiest arguments are the simplest arguments. So he did not initially challenge the constitutionality of the obscenity statute. He solely focused on the search issue. It was only later when Bernard Berkman from the ACLU and Jack Day and those individuals would come in that the First Amendment speech issue would become a prominent thing. Now, what I find fascinating about this motion to suppress, take a look at it. The service clause fits on the same page with the motion to suppress. Now that is efficient lawyering. So there you go. Keep that in mind. Any law students out there, hope they watch that. So here's our trial judge, Judge Leibarger, Don Leibarger. He was the trial judge of the Mapp case. Some of you may remember his son, Lynn Leibarger, who's a lawyer. I think he had his office in Parma for many years. Leibarger upheld the obscenity law to the extent that that was within this case, and the seizure of the materials from Mapp's home without a warrant. He then sentenced Mapp to 1 to 7 years in jail at the Ohio State Reformatory for Women. He did die on November 6, 1970. Perhaps aware of the significance of this case, he did give her an appeal bond. So she was out. She didn't do any time in jail on the conviction. Now, as fate would have it, the case, of course, was appealed to the 8th District Court of Appeals. And at that time, the 8th District only had 3 judges, Judge Joyce Seth Hurd, Judge Julius Cavacci, and Judge Skeel. One thing I will say about Seth Hurd is he had 68 grandchildren. I was able to check that out, so that's legit. Now, what I also find fascinating about this is it was a 1-page opinion. There's a lot of 1 pages in this story. And it cited no case law. Hey, these were trend-setting decisions. It referenced Ohio Revised Code 294583, which has long since been repealed, but I went back and, or there's a different variant of it in the code now, but I went back and looked at it. It was basically an argument for when a new trial should or shouldn't be granted. But here's what the 8th District said about the whole case. This is what they said about Mapp v. Ohio. Upon review of the entire case, we find no prejudicial error to the rights of the defendant. Again, this is 1959 America, so it's a different world, a different era. So now the case really starts to take on some significance, because not only do we have this search issue that's out there, search of a home without a warrant, but also growing is this obscenity issue that she's convicted of something that is obscene. And keep in mind, the items that were seized from her home were found in what amounts to a Foot Locker in the basement, and she used to rent to boarders in that basement. And through a lot of trial and error and going through some of the autobiographies and books about it, to the best of everyone's knowledge, those materials were owned by somebody named Morris Jones, who was a renter of hers many years earlier. So this is not like Dolly Mapp had purported pornographic material. It was, you know, that's how remote this was as well. So these 3 individuals, Jack Day, Seymour Terrell, and Bernard Berkman, would get involved in the case from the ACLU. The media was covering this case, and all the, you know, the Cleveland Press, the Cleveland Plain Dealer, the Cleveland News, they were all covering this case. It started to take on some interest, so the ACLU got involved. One of the people I will talk about here is Jack Day. He served on the 8th District from 1968 to 1984. He also probably should be credited with reviving the ACLU in Ohio in 1950. He got together with some people and really tried to revive it after it had been dormant for a number of years. And Terrell and Berkman were really high-quality lawyers who knew these types of issues very well. Day would participate in Jacobellis v. Ohio case. That's the case you all know as "I know it when I see it," the famous Potter Stewart quote. So now we have free speech entering the pendulum here. So this case goes on to the Ohio Supreme Court in 1960, and I won't spend a lot of time on this, but she almost won her case at this level, but for a strange twist in the Ohio Constitution that I believe was amended in either 1968 or 1994. I'm not an Ohio constitutional expert, but at that time you needed at least, I think you needed 6 votes to find a statute unconstitutional, and here they were 1 vote short. Taft, Zimmerman, Peck, Mathias, and Weigand all sided with Mapp on the obscenity question, but they didn't have 6 votes because 2 justices dissented. Now on the search issue, she lost that. Justice Herbert wrote the dissent in that case. So let me just touch on these individuals just real quickly. This is Justice Taft. He was born in Cleveland in 1903. He writes the majority opinion from the Ohio Supreme Court in Mapp. He graduated from Harvard, served in the Ohio legislature. He was on the Supreme Court from 48 until 1970 when he died. Interestingly enough, while on the court, he ran against the Chief Justice of the court. Imagine a contentious court that must have been. He ran against him and only lost by 1,772 votes statewide. So that didn't make for a happy Wednesday morning at the Supreme Court. But he also dissented in the Sam Shepard appeal, writing that he didn't believe the evidence supported a conviction. Now, Justice Herbert wrote the dissent. He was born in Cleveland, was a highly decorated World War I fighter pilot. He was a student of the law, and his biography says he loved ice cream and corn on the cob. you know, I had to include that. I mean, anybody who likes ice cream and corn on the cob gets a shout out. Now, he handed Governor Frank Lausche his only defeat in 6 gubernatorial elections in 1946. He lost to Lausche in a November 1948 rematch. And again, he wrote the dissent map focusing on the absence of a warrant, and he died in 1974. Now, I would be remiss if I did not mention this judge, who is my favorite judge in Ohio history, and I'm going to tell you why. This is Judge Charles Zimmerman. He was born in 1891 in Springfield, Ohio. He's a Democrat. He served for 35 years on the Supreme Court. Now, this is what I love about him. He never felt confident enough in his job security, because no public official is, that to purchase a house in Columbus. So he traveled by bus from his home in Springfield each Tuesday morning, returning home the following Friday, and slept in his office on a cot for 35 years. And the old-timers on the 2nd District tell me that he used to hitchhike on some days. When he missed the bus, he would hitchhike from Springfield to Columbus. Can you imagine? Where are you going? I'm going to the Supreme Court. True story about the guy. I don't know, they should put a big cot monument in Dayton somewhere for this guy, but I really just love the story about Zimmerman. So on the case goes to the United States Supreme Court. Earl Warren, it's the Warren Court. Hugo Black, Felix Frankfurter, William Douglas, Tom Clark, Harlan, Brennan, Whitaker, and Potter Stewart, who was from Cincinnati. So 1969, look at how quickly they got cases out then, right? March 29th, it's argued. It's decided June 19th. So justice delayed is not justice denied in that era. I'm sorry? No, not a little more detail at the federal level, I think. But that's great. I got to use that line if I can borrow it. So let's look at the prior precedent just real fast. State versus Lindway. This was the Ohio case, the Ohio law that the exclusionary rule was not adopted by Ohio for state court proceedings. The comparable federal case was Wolf v. Colorado in 1949, where the U.S. Supreme Court, in a 6-3 vote, decided the Fourth Amendment was applicable to the states through due process of the 14th Amendment, but not the exclusionary rule. So it kind of had a law without an enforcement provision. So those were the stakes of the prior precedent at the time. There are 2 big issues. Obviously, Berkman wants to argue First Amendment, and he was totally focused on that with the ACLU. Kearns was more concerned about the second question, whether you could search a residence without a warrant. And so these were the 2 big issues that were before the court, and they summarily just ignored Berkman. I don't think they wanted to deal with pornography at that time, or obscenity, or the First Amendment, so they just ignored him. When you listen to the tapes of the argument, Berkman makes the far better argument. He's much more eloquent, much more distinguished, much more driven, but they just brush aside that, and they go right to the search issue, and eventually they will apply the exclusionary rule to this case. So Kearns, one-page Kearns was pretty good. He ends up winning the case. But there was one other humorous thing from the tape, if you ever go back and listen to the tape. Gertrude Mann, who I never think women's bar groups give her enough credit. I don't know what it is, that here's a woman who handled a case in the 50s from all the way through. But she's in the U.S. Supreme Court arguing for the state. And she starts out her argument by making this note, that one of the state's exhibits disappeared. One of the obscene books ended up missing. And she says, when the exhibits are returned to the Court of Common Pleas, there was just the cover of this one obscene book that came back. We don't know what happened to it. And one of the justices, it's not clear who, because these are just, oral or audio recordings, says, has the clerk been indicted? And of course, everybody laughs. So, again, kind of an interesting note. So, and this is the quote from her. The lead opinion in MAP is authored by Thomas Clark. Truman appointed Clark to the bench. He served from 49 to 67. He didn't have a lot of judicial experience, but Truman, in his biography, said it was the worst pick he ever made for a judge, ever. Called him the worst pick, my worst pick ever. And why was that? Well, it was because Clark sat on and wrote Youngstown Sheet and Tube, and if you remember, that was the big Union steel case in the 50s during the Korean War, and it really caused Truman a nightmarish experience. He did vote with the majority in Brown versus Board of Education. He was the father of U.S. Attorney General Ramsey Clark, and he was replaced when he left the court by Thurgood Marshall. So real fast here, before I get to the second case, MAP, it really was a big story in the media. I mean, it was covered across the country, covered here extensively. She became like a cause celeb, Dolly Mapp was like a figure. She was interviewed by local and national media outlets. She really felt vindicated in all of her commentaries. And of course, the police and prosecutors were outraged. They thought this was going to be the end of the world. We have to get a warrant to go into somebody's house? The New York Times ran a whole series of stories on the case. This is just one little one I picked up. But the other aspects were the editorial commentaries that went on in newspapers across the country. And you can Google these and read them. They're rather interesting for the time period. But everybody weighed in on it. And most were supportive, but many were wary and cautious due to the response from law enforcement, the concerns that law enforcement were raising about this issue. This was a new day in America. So what happened? So Chandra Burns, he was not a member of the Mafia, but he worked closely with the Mafia members in the 60s and 70s. Eventually, he got into a dispute with Cleveland racketeer Danny Green over a $75,000 loan from the Gambino family in New York. Apparently, the Gambinos had sent a courier with this money, and somewhere along the line, once it got to Cleveland, the money ends up missing. Green blames Burns for the missing money. Burns blames Green for the missing money. But guess what? The Gambinos don't care, right? They're blaming both of them for the missing money. So this was a source of contention between Burns and Green. Of course, neither of which were Italian, so they couldn't be in the Mafia, but they were actively working in association with their Mafia. Now, at that time, there was a split in the Cleveland Mafia, and there were two camps that had emerged within the Italian community running the Cleveland Mafia. And Burns and Green were on opposite sides of that split. So, what happens? In March of 1975, Burns is blown up by a bomb in the lot behind Christie's Lounge at 2516 Detroit Avenue. That location today is the site of a kind of an upscale apartment building, I would say, where they're getting $1,500 a month for its efficiency. Some crazy money like that. But Burns had tried to kill Green earlier, and although the initial numbers operators were the suspects, Burns' death had all the trademarks of a Danny Green hit. Burns was killed with C4 explosives, although Green was never charged. And this was a front page story on the Cleveland Plain Dealer the next morning. In fact, you can look there that the North Vietnamese had just captured Da Nang the day before, too. So end of the line for Chandra Burns. He's buried in Hillcrest Cemetery in Bedford Heights. Now, Burns' widow was oblivious to the conflict between Danny Green and Burns because he had largely sheltered his wife from a lot of his underworld activities. Aware that Green also was a pet lover, she ends up giving Burns his Doberman Pinscher as a gift. How twisted is that? So this is an image of Burns' gravesite. Danny Green. He's raised in an orphanage. He's a former U.S. Marine, union organizer with the Longshoremen. He read the book On the Waterfront. He called his Irish gang the Celtic Club. He killed at least 8 of the Mafia hitmen sent to assassinate him. And of course, he was the subject of the book and film, To Kill the Irishman. He used to go around and give out green pens. He drove a green Lincoln Continental. He wore green suits. I mean, he was all about being green. But the end came for him in October of 1977. He went to a dental visit at Cedar and Chagrin, parked his car, went into the dentist's office. The Mafia pulled a Nova next to his car, waited for him to come out, and a remote bomb was exploded in the Nova, killing Green as he was getting into his green Lincoln Continental. But he would get revenge in death because federal prosecutors moved in then to really shut down the Cleveland Mafia by the 1990s. And by the 1990s, all were either dead or in jail. Don King, he would go on to become the greatest promoter in boxing history, handling Muhammad Ali, George Foreman. He did the Rumble in the Jungle in Zaire. He did the Thrilla in Manila in the Philippines, the Ali Frazier fights. He was sued by every boxer he ever represented, including Muhammad Ali, Larry Holmes, and Mike Tyson. Now, you may wonder, how am I going to get a Michael Jackson reference into this presentation? Well, Don King managed the victory tour, the Jackson's victory tour in 1984. And in 1998, he purchased the Call Post. He's still alive. Don King is still alive. He's got to be in his 90s. Virgil Ogletree, the fellow who was arrested in the basement, he was never charged with the bombing of Don King's home. He was a lifetime friend of Dalry Mapp. He was involved in gambling activities until his death at age 82. He did have legitimate businesses, including a dry cleaning business on Cleveland's east side. He was never charged in the bombing. He was well liked and respected by those involved in both legitimate and criminal activities. He's very close to Chandra Burns. Now, Bernard Berkman went on to handle a number of ACLU cases. I love this headline: hippie leader Levy gets 6 months in jail. I mean, you can't make this stuff up. But he led the ACLU for a number of years. He was involved in a number of cases. He passed away in the early 2000s. Same with Seymour Terrell. Now, Dalry Mapp, she would go on and leave Cleveland for New York City. She started a furniture business in Manhattan, but invariably she got involved in a fencing operation and a drug operation in the Queens of New York. She went to prison for 9 years. She did 9 years in prison after the Mapp case. She was later pardoned by Governor Hugh Carey of New York. She lived in Queens until her death in Conyers, Georgia, on October 31st, 2014. She went down there and she had a niece, her daughter Barbara's sister's niece, or daughter rather, took care of her to the end. So that is our Dalry Mapp v. Ohio story. You learned a little bit about the personalities. Now, in the time remaining, I'm going to switch over to Terry v. Ohio, and we'll have some more interesting characters. So we just got to take a second here. Oh, no, those down there, we'll get rid of those, and now we'll try this one. So let me see here. So here we go, Terry v. Ohio. So this is the other big, it's amazing that these, you could make an argument that Terry v. Ohio and Mapp v. Ohio are the two biggest cases in Ohio, in American criminal jurisprudence history. And they both happened right here in the city of Cleveland, and many of the locations are still around. You can walk the streets right by them if you want to. So let's go through these, and I'll try to touch on this. So this was the old, for those of you that are local, and I realize there's a lot of people not from Cleveland that are on the video stream, so I'm trying to explain this a little bit. Anybody from Cleveland knows this location very well. Euclid and Huron and 12th, where they all kind of come together, the triangle, if you will. Where the big chandeliers are now. Right, exactly. But just to give a sense of people that this was the dominant shopping area in Cleveland from roughly, I would say, the 1920s through the 1970s. If you wanted anything, this is generally where you had to go. This is before the suburban shopping malls, before Amazon.com, before all that stuff. There was this stretch of territory between Public Square and roughly East 18th where you would shop, and for anything and everything. Sterling Linder, Halley's, Higbee's, May Company, all those stores were down there at that time. And of course, the triangle building that you see here is where the current Playhouse Square Hotel is located, the old Wyndham Hotel, as some of us know it as. But it retains the same shape, distinctive triangle shape today that the former building had. Now, let's go into some of our personalities. This is John Terry. He was born in Memphis, Tennessee in 1932. He was one of 7 children. His mother, sadly, died in childbirth. He was arrested in Memphis as a juvenile. He spent 1 year at an agricultural training school. He moved to Cleveland, where his stepmother's sister resided. Eventually, a number of the Terrys from Memphis, Tennessee, settled in Cleveland, and particularly in East Cleveland. John Terry had an older sister, May Stewart. Some of you in this room may remember May Stewart. She was involved in government in East Cleveland for many, many years. And she would play a prominent role in his life as well as in the East Cleveland government. She also had a relative, Bishop Terry. Many of you would remember Bishop Terry. He was a prominent member of the clergy from East Cleveland. Now, Terry served in the U.S. Armed Forces, where it is believed he developed a drug problem. After he moved to Cleveland, he was arrested, convicted of burglary and various violations of state drug laws. He did serve time in the Ohio State Reformatory, and his last parole date was June 17th of 1959. He lived at 1275 East 105th Street in Cleveland at this time period. Now, Richard Chilton was born March 28th, 1937 in Belle Vernon, Pennsylvania. He came to Cleveland in 1946. In 1953, at age 16, he became a printer. He was in the Printers Union in Cleveland. He worked at Grand Printing in Cleveland. He married in 1956, but separated from his wife. She moved to California. They had no children. He briefly relocated to Chicago, where he also worked as a printer at the R.M. Demian Company, and he ended up back in Cleveland in 1962. At that time, he was unemployed. He lived with his mother, Mossy Chilton, at 16101 Lotus Drive in Cleveland. That was at the time of his arrest. Now, our third figure in this is Carl Katz. Carl Katz was 49 years old at the time of his arrest. He lived at 3755 Mayfield Road in the Heights Garden Apartments in Cleveland Heights. Now, Chilton knew Katz from his job as a bar manager on the east side. There's no record of what exactly Terry's relationship with Katz was, but they clearly knew each other. In 1967, during one of the books summarizing the case, there's no record that anybody knows that Katz had a prior criminal record, but there's really not a whole lot known about his background beyond that. Now, one of our other figures in this drama is Martin J. McFadden. He's probably the classic Irish police officer of the mid-20th century. He's born in 1901. He briefly works as a timekeeper for the Cleveland Railway Company, and then he joins the Cleveland Police Force in 1925. By 1930, he was promoted to detective, and 1934, he went into the fraud unit where he worked the downtown area watching for shoplifters and pickpockets. McFadden had a warm and engaging personality, knew all the merchants and regular shoppers in the area. Now, one of his arch nemesis was a thief named Louis the Dip Finkelstein. It's a true name. Finkelstein was arrested 121 times by the Cleveland police between 1909 and 1959. In 1933, he spent time in 3 different jails in a 48-hour period for theft. So this was McFadden's job. Walk this beat between Public Square up to East 18th, around Huron, around Euclid Avenue, look for pickpockets, look for shoplifters, look for any kind of activity and so naturally, doing this day in and day out, he got to know pretty much all the merchants. He knew the regular shoppers. He knew everybody. So he was a little bit of a known entity in this area. Now, the events of October 31st, 1963, Halloween, Dolly Mapp's birthday. At 2:15, McFadden is walking east on Huron Road, and he observes 2 African-American men, Chilton and Terry, peering into windows on Huron Road near the back of the United Airlines office at 1276 Euclid Avenue. For anybody who's young, when you used to have to get an airline ticket, you would go to the airline ticket office. They had these airline ticket offices downtown. There was like United, the Trans World Airways, all these, and you would go there and you'd buy your ticket and you'd get a ticket. So these 2 individuals were later joined by a white male, that was Katz, and they appeared to be casing locations for a possible robbery. So McFadden watches them from a store opening. The store was called Rogoff's, which was on 1260 Huron Road, and McFadden follows them from Huron Road onto Euclid Avenue, where they walk to the front of Zucker's Men's Store at 1130 Euclid Avenue. McFadden then stops all 3, pats Terry down, recovers a handgun, orders all 3 into Zucker's Men's Store, where he pats the others down and recovers a handgun from Chilton. Katz did not have a weapon. McFadden did not play favorites. He arrested all 3. What did he arrest Katz for? Being a suspicious person. Could be arrested for being a suspicious person back in that time. So here's our little area for anybody that is unfamiliar with this. The red line, as you look at this, the shorter red line is Huron, and that would be the area of the back of the United Airlines store. And then the individuals would walk around the triangle, the point of the triangle, and head west on Euclid, on the south side of Euclid, all the way down to 1130, where the X is near the top right of the photograph. So that gives you a sense of how this plays out. Now we'll go into a little more detail on this. This is the back of the Halley building today. The arrow coming down in red is roughly where Chilton cats and Terry are first observed, and the green arrow points across Huron to where McFadden was located. Here's the former site of Rogoff's at 1260 Huron Road. In that little alcove entry is where McFadden stands looking across the street to observe Chilton, Terry, and cats. Here's 1276 Euclid Avenue, or where it would have been back in those days. This is part of the hotel complex now, but this is the site of the front of the United Airlines office that is the subject of part of this. Here's 1120 Euclid Avenue. I'm not sure if it's 1120 or 1130, but Zucker's Men's Store was located here. Here's actually where the stop and frisk takes place, involving initially Terry and then Chilton and cats inside the store. And this is the same building. It's still there today. You can walk by it and see it for yourself, where this all took place. Here is the Cleveland Police Headquarters at 21st and Payne back in the day. This is where what would happen is McFadden would call for a paddy wagon. Go figure, right? Politically incorrect term. Being Irish, a paddy wagon was summoned. Paddy means Irish, right? Pick up the Irish drunks and, you know. So they call for a paddy wagon. Cats and Chilton and Terry are taken to Cleveland Police Headquarters at 21st and Payne. And then McFadden will go over there and then write his report. And here's the front of the building for especially, mainly doing this for the people that are on Zoom watching this, because they probably, many of you in this room know these locations, but people outside don't. So this is very much what I call the Barney Miller Police Headquarters, right? Those of you that remember the show from the 70s, Barney Miller, that's what this is. It's really a classic building. So here is McFadden's incident report. And yes, to the young lady in the back, it is a one-page report. And actually, in the materials, I have included a readable copy of this if you want it. If you look in the materials, I have included a readable copy. I also want to stop for a minute and mention this about the materials. I have a note that John Terry writes to the judge later, and it gives you a better appreciation of John Terry. He was not just some drugged out, strung out criminal. He writes a really eloquent note to the judge that I have included in the materials as well that you can take a look at. Here's John T. Corrigan again. I don't necessarily have to go into all of his background, but he's the lead person on all these cases, at least in terms of he's the elected prosecutor at the time. Now, he assigns this case to Reuben Payne. And many of you may wonder, well, who is Reuben Payne? Well, Reuben Payne was born in Scioto, Ohio, in Harrison County in 1922. It's a small town of only 850 residents at the time of his birth. He served in the U.S. Army in North Africa, Sicily, Italy, between 1942 and 1945. He then came to Cleveland, graduated from Western Reserve University in 49 and Cleveland Marshall in 53. In addition to his private law practice, he worked at the U.S. General Accounting Office. He left the prosecutor's office after being hired by John T. in 1957. Briefly went on the State Personal Board of Review. In 1964, he returned to the county prosecutor's office, and John T. Corrigan assigned him the case of Terry v. Ohio, or what would be known as the case of Terry v. Ohio. So he's one of the first African-American prosecutors, and this case would represent the first time that we would have an African-American prosecutor, an African-American defense lawyer, and, since Thurgood Marshall would sit on the case, an African-American Supreme Court justice in American history. All happened right here in downtown Cleveland. Lou Stokes. Everybody in Cleveland remembers Lou Stokes. For those of you that are not from Cleveland and are not aware of his career, he was one of the best young trial lawyers in Cleveland in 1963 at the time of this incident. He was born in Cleveland in 1925. He had a brother, Carl, who went on to become the first African-American mayor of a major American city. That was here in Cleveland. Both of these young men were raised in the first federally funded housing project, the Outhwaite Homes at 55th and Woodland in Cleveland. They were raised by their widowed mother, Louise. Their father died in 1928 when these kids were very young. So they would both work under legendary Cleveland trial lawyer Norman S. Minor. And in 1930, Norman S. Minor became Cuyahoga County's first black assistant prosecutor. Remember Frank T. Culleton from the other case. And he was widely regarded as one of Ohio's greatest trial lawyers. Stokes would learn under Minor, then emerge as a great trial lawyer in his own right. Minor, Stokes, and his brother Carl had their law offices at 2584 East 55th Street in Cleveland. Now, how did Lou Stokes get on John Terry's case? Well, May Stewart, who was active in government in East Cleveland, had reached out to Lou and asked him, you need to help John and support him, and he did. Stokes took on the case as their lawyer. Now, just briefly, for people that aren't familiar with Cleveland, that's Carl on the left, the younger, and Lou on the right. And here's an image of Outhwaite Homes at the time it was constructed, and they had moved into these residences in 1938. And here's a picture of them with their mother. You gotta love a picture with two men with their mother, right? Come on. So that's their family. Now, where do these cases play out at? Well, of course, the old criminal courts building at 21st Street and Payne. This is where the trial took place at. This is where all the hearings took place at, the sentencing, everything. Now, interesting about this place, when you talk to old-timers that remember the old criminal courts building at 21st, the tower portion of this was the jail. So the inmates would stuff toilet paper in all the toilets and flush them to no end. And guess what would happen to the courtroom sections down in the lower levels? Yeah, a lot of lousy water would find its way down into those areas. So again, this facility was in operation until the Justice Center opened in 1976. Here's the site today. It's a parking lot. I'm big on forensic photography. I don't know why. I just like looking at old stuff and then what was there now, you know? So here's McFadden. Here's our detective. One of the things that I find fascinating about him is he was 64 years old at the time of the Terry stop. Can you imagine being 64 years old, working a beat, and then arresting three guys that are half your age? Unbelievable. Stokes and others referred to him as Mac. When I talked to Lou Stokes about the case before Lou passed, he told me he was a straight shooter by all standards. He didn't pull punches. He was a decent guy, just doing his job in his mind. So Judge Bernard Friedman, who everyone in this room knows his son, Judge Friedman, Stuart Friedman, who served on the Common Pleas Court for many years. But Judge Bernard Friedman was the judge that was assigned the case. And I think he never has gotten his due in relationship to this case. He was born in Poland in 1909. He came to the United States. He graduated from John Hay. He went to Ohio State, got his law degree here at Case Western Reserve University in 1934. He held a variety of positions. He was in the Cleveland Law Department. He was a lawyer for the Cleveland Transit Union. But he got appointed judge by Governor Michael DeSalle in the early 60s, and he was assigned this case. He was very respected by the attorneys, and Stokes spoke very highly of him, saying that I knew I was going to at least get a fair shake with Friedman as the trial judge. Now, this was Friedman's opinion, which was published. He was astute enough to know that this case was a big case, even though no one at the time fully appreciated how big of a case this was going to be. And he wrote that frisking by a police officer of a person stopped for interrogation because of suspicious conduct is proper to meet the practical demands of effective criminal investigation and the safety of the officer, the omission of evidence of the fruit of the frisk and a prosecution for carrying concealed weapons does not. This would go on to essentially become the law of stop and frisk, but Friedman never gets credit for it, in my opinion. He does a thorough examination of the facts and the law, and I believe all the subsequent reviewing courts basically stole his idea. I really, really feel that. I thought he was way ahead of the game in figuring this out. Now, the case came to the 8th District Court of Appeals in February 10th of 1966. At that time, there were three judges that handled this, Judge Silbert, Judge Artle, and Judge J.J.P. Corrigan. What was interesting was they saw that there might be future litigation associated with this case. And they saw it so much that they wanted to comment on it, that they said, if such abuse arises, we shall deal with them when the time comes. Well, what have we been doing for the last 65 years in the United States? We're dealing with stop and frisk cases, right? I mean, probable cause, reasonable articulable suspicion. So even they were somewhat ahead of their time. I will make one comment about J.J.P. Corrigan, not because he's Irish, but because of this. He was a city prosecutor from 1933 to 1937. In 1942, he joined the U.S. Army at age 41 as a private. So he went off the 8th District Court of Appeals, became a private in the Army, and at age 43, he landed on Normandy on D-Day. At age 43, amazing. So, and he's buried in Lakewood Park Cemetery. I could go on and on about all these characters, but we don't have a lot of time. So the case goes on to the Ohio Supreme Court, and they sua sponte dismiss the appeal, noting no substantial constitutional. Do you think they might have wanted to have a redo of that? But they didn't. That was it. So now many of you, we all call this case Terry v. Ohio, but guess what? It was not Terry v. Ohio. It was Chilton v. Ohio for the whole thing leading up to when it got to the United States Supreme Court. Terry was not even on the thing. Chilton was shot and killed in an armed robbery in Columbus in 1967, and that's when the case became Terry v. Ohio. Most people don't know this, but this is the news article counting that. And it goes to show you how big this case was becoming in American jurisprudence, that one of the defendants is shot and killed in a robbery in Columbus, that it ends up in a news article. So kind of a sad end for Chilton. But and how about this? This robbery, when you read the article, they got away with $23,000 in cash from a store. Why was that? And I had to think about it, and then people reminded me, well, in those days, certain stores, certain bars, certain restaurants on Fridays had huge sums of money because why? People went there to cash their paychecks, right? So that's why there was that much money there. And in an inglorious manner, Chilton was left dead by his two fellow robbers, so there was no honor among them. So I'm going to get real fast here and finish this up. It goes on to the U.S. Supreme Court. We know the outcome. They affirm the stop and frisk doctrine. Earl Warren writes the lead opinion of the court. Thurgood Marshall participates in it. He was a big fan of Earl Warren. He sides with the police. Most people identify Marshall as a defense-oriented jurist, and he was, certainly, but in this case, he sides with the police. William Douglas writes a dissent. The postscript of this, McFadden goes on to become somewhat of a celebrity. Some of you young people will have to Google Mae West, but she was quite the something back in the day, and that's McFadden off to the side there, and he used to be a bodyguard for her. He retires in 1970, a news story about him. Here's where he's buried. He died in 1981, and that's his wife there. In 2003, we worked to get a historical marker put up, and it's right there at the triangle. It tells the story of McFadden and the case. And then here we have Congressman Stokes, and of course he's buried in Lakeview Cemetery. And on his tombstone, I think I have it here, is aim high, from the projects to Congress. So quite a legacy. This was over at Marshall Law School when the Stokes family, we got a monument erected, Terry v. Ohio. Unfortunately, it's not at 1120 Euclid, but it's in what I call Monument Valley in the Huntington Park area there. And this is what was the dedication day that when we did the thing. So Reuben Payne, he would go on to Arizona. He always defended McFadden's right to stop and frisk. He went on to lecture about the case many times at St. John's University in New York, which has a great archive of the case. And he died in 2013 at age 90. Mae Stewart went on to try to get help for John Terry. She had him placed in Lima Hospital at one point. This is before drug courts. If there had been a drug court, maybe John Terry would have made it. But she was a very dynamic person in her own right. John Terry would pass away He was beaten up in jail during one of his episodes, and it's a sad story. He went into a coma. He never came out of it, and he died in a hospital. He went on to have a number of other arrests. They were almost always drug-related. It's kind of a sad ending. Now, one interesting story, and I know I'm getting into your time here, but I think this is a great story of life. So, Mae Stewart, she had, well, when Terry was in prison, one of his relatives, Robert Stewart, was only 14, would go to visit him. And he thought Terry was a nice guy, but he didn't want that kind of life. Stewart went on to become a member of the Columbus Police Department. And while he was there at the police department, a recruit came through named Chris Chilton. Little did you know that Chris Chilton was related to Richard Chilton. So both Chilton and Terry had two relatives after the fact that serve on the Columbus Police Department. And here's an image of them. And the young man who I think is the second from the left with the glasses on, that's Marty McFadden's nephew. So we got all of them together, and it's a kind of a nice little postscript. So I don't think I have anything else. Let me see. Do I have something else? These are just the source materials. Go down to the Cleveland Museum, Police Museum, and the Justice Center if you want to look at any of this stuff. It's all there. They'll get it out for you. You can look at it all. So without further ado, thank you very much.
Judge Gallagher truly is a great storyteller. So we're going to have a 15-minute break, and we will return at 1:15. Thank you.
It's just enough. You can't miss it. The big
Hi, good afternoon, everyone. And I'm Judge Emanuela Groves with the Ohio 8th District Court of Appeals. And the next hour we will spend on talking about the appellate judge. And notice it's not judges, the appellate judge, standing as the 13th juror in addressing issues of implicit bias in criminal cases. Professor Andrew Paulus will be the presenter this afternoon. He runs the Appellate Clinic here at Case Western Reserve University, and he started off back in 2008 as a visiting professor, and now he runs the clinic. And I'm sure for those of you that are now practicing, you know the impact, if you had an opportunity to be a student in the clinic, the practical experience that you get. And here at Case for the last couple years, the students have experienced quite a bit of success. And I don't know, I know as a trial judge and even as a practitioner, when you go against these students, they're pretty prepared and they're very zealous, and it's just a joy to see them, and particularly when they are successful. So we will hear about this issue, and then one of the things too that I asked Professor Paulus is one of his hobbies, and he said it's gardening and growing tomatoes, and I think that probably ties into the profession when you see young students and you see as they blossom and you see the opportunity to present in court. And so at this time I present to you Professor Paulus.
Thank you so much, Judge Groves. What a lovely introduction. Judge Groves was among a panel of 3 Case alumni. Judge Forbes was also on that panel, who visited here at the law school just last week. And some of the things that came up in that discussion, even though it was a reasonable stop case, it still had some very interesting implications that dovetail somewhat with my research that I'm going to be talking with you about today. So the thrust of my conclusion, basically the suggestion that I'm about to try to convince you to buy into, is theoretical. This is not the law. You have heard a lot of practical information at this seminar, and then just now through Judge Gallagher, we heard a really wonderful historical information. One of the things I was just telling Judge Gallagher about his presentation that I enjoyed so much was that it reinserted the humanity of those cases into the picture. So you're not just dealing with abstract rules or even concrete legal doctrines, but you're dealing with the people whose lives were really affected by those cases. And that's part of what drove me to this research. I have a very keen interest in the 1930s case of the Scottsboro boys. For those of you who aren't familiar, they were 9 African-American teenagers. They really were boys. It isn't just a disparaging concept. They were children who were riding a boxcar in Alabama, and when they were removed from the train, there were also 2 white females on that train who were worried that they could be arrested for vagrancy or what have you. So immediately, the 2 white females pointed to the 9 African-American boys and said, "We were raped by these boys." There was no physical evidence, but a jury convicted them in just about 10 minutes of deliberation time in each of the separate trials. And eventually, there were 2 Supreme Court cases, actually, that were driven by this. One of them was Powell versus Alabama, which was one of the early cases establishing the right to counsel even in state court proceedings. There had not yet been a full due process incorporation of that right, but in that case, they held it as sort of a precursor to Gideon. And the other case was Norris versus Alabama, which was a subsequent appeal from the Alabama court system's systematic exclusion of African-American jurors from the jury rolls so that everyone was guaranteed an all-white jury. And the Supreme Court said, no, that's not okay either. So the case has really been interesting to me for a number of years. And Judge Groves just mentioned that she brought up Brian Stevenson, who works for the Equal Justice Initiative. I guess, Judge Groves, your daughter has an internship there. Well, Brian Stevenson, I'm getting confused with our dean. Brian Stevenson and Judge Blackman, who is formerly of the 8th District, were participating with me on a panel to discuss the Scottsboro case several years ago, and it really raises some interesting questions about the role that racial injustice plays in our criminal justice system, not back just in the 1930s, but going all the way down to today. And so that kind of sparked in me the idea when I started helping my appellate students learn about the various things that you can argue on appeal. It dawned on me that this entire concept of manifest weight, which we in Ohio come to sort of understand as sort of a ubiquitous appellate remedy that is almost never actually afforded anyone. But I was very surprised to learn that most jurisdictions, Ohio is a very strong exception, don't have any manifest weight review on appeal. They have trial judges who are permitted to entertain motions for new trial based on manifest weight. But then that decision of the trial judge is reviewed on appeal by an appellate court for abuse of discretion. There is really nothing in the country, with a couple of states with handful of exceptions of a couple of states, nothing as robust as Ohio. But I would argue that Ohio isn't robust enough, and that's the sort of genesis of this research. So this is a paper that I wrote that's coming out in a couple of months in the Temple Law Review. It's the same as the title of my presentation. And you know, I've already shared with you a little bit about where this research comes from, but what I haven't mentioned yet, and it's really kind of the foundation of much of this research, is the concept of implicit bias. Many of us have come to be familiar with the phrase implicit bias. There is actually an online test that you can take that Harvard posts on its website. It's called the Implicit Bias Association Test. You can Google it and take it. There's a link to it in the article, which is among your written materials. But basically, the concept is that no matter who you are, no matter what color you are, no matter what gender you are, no matter what age you are, you harbor implicit biases. And it doesn't even matter how well-intentioned you are in your effort to shed them, because they're always there. And only a deliberate, conscious effort to overcome them can possibly rise to the level that it needs to for them not to infect the decisions that we make. Now, I don't mean to suggest that implicit bias is always bad. It's always bad when it comes to things like race and gender and sex and age and so forth. But it's part of the ways our brain is trained to work. We can't function in society without jumping to conclusions sometimes, because some of the decisions that we have to make need to be made very quickly, but not court decisions, not decisions that affect people's lives. And so to give you a little bit of an understanding of what I mean, what do you see here? System 1 processing, that's the intuition. That's the part of our brain that sees something and draws a conclusion immediately. And so System 1 processing tells you, as most of you suggested, that this is a raw egg in a bowl. But it isn't. System 2 processing, that is when we actually investigate and we look at it closely and we inform ourselves about it, what it really is, rather than just assuming it is what we think it is when we first see it. System 2 processing, that I am now allowing you to use because I'm giving you the information, will tell you that this is not an egg, it is half of a peach in a canned syrup, a canned peach in a bowl. But we all look at it and we think egg. Now imagine if somebody's life or liberty were at stake, and the decision that was made about whether to put that person away or even execute that person were based on something as erroneous as our collective conclusion that when you first see this thing, that it's an egg. And that's kind of where this differentiation between System 1 processing and System 2 processing comes in. And of course, the System 1 process, well, here's another example. System 1 processing would tell us this is a picture of an animal. It's actually just a misshapen muffin. That says that you didn't jump to the same conclusion that most people would, that it was a peach rather than an egg rather than a peach. And that's kind of an important point. I'm glad that you raised it, because not all of our system one processing leads us all to the same place, right? In that particular example, most of us thought it was an egg, but obviously you just thought it was food. That is a function of the way your system one processing worked in that particular situation, which is in turn a function of your life experience, the way your brain has been trained, the way you were brought up, the experiences that you have had. All of those things contribute to the way your brain systematically, automatically, intuitively reaches conclusions. Similarly here, this is not a mouse. I wouldn't want to eat this muffin, but it happens to be just a muffin. But your first impression of it might not have said to you, that's a muffin. So let's look at what system processing is. System one processing. System one processing is intuitive. That is, we intuitively think we know the answer to a question. It's based on preconceived, internalized, and sometimes even unknown beliefs that we have, or ways that our brain has been trained to think. By contrast, system two processing is deliberative, thoughtful, and receptive to new information. So when you think about the way that system one and system two processing intersect with each other, system one processing might be the thing that you think when you first encounter a situation that requires you or even inspires your brain to form a conclusion, whereas system two processing is the thing that you can use to overcome or confirm your original perspective, right? Which of these two gives rise to problems caused by implicit bias? I've already sort of given away the answer. It's the first one, right? System one processing is the part of our brain's operation, and this is not my research. I borrowed this from other people because I'm not a psychologist or a neurologist or any instances are appropriate. So that's the background on the processing pieces of it. What are the trial dangers of system one processing? Well, they are what you might intuitively imagine that they are. You can be, the outcome can be negatively affected by jurors' own baseline, sometimes race-based implicit biases. And research has documented a number of different discrete ways that a juror approaching a decision in a criminal trial, for example, will form conclusions that are based upon that juror's own system one thinking. It can be the criminal propensity of a particular defendant, not based on evidence, but based on whatever the juror might perceive about that defendant. It can be the credibility of a defendant. You might have a preconceived notion that people who appear a certain way are more credible than people who appear another way. Behavioral reactions is a big one. A lot of us think that other people in the world are going to respond to the same stimuli the way that we do, such as being stopped by the police. Some people behave very differently from other people when we are stopped by police, and that can be a function of our own life experiences, how we were raised, what we were taught to believe. Skin color goes into that, obviously, very importantly. But the question is, when you're sitting on a jury, and your reaction to a police stop isn't the same as the defendant's reaction to the police stop, your system one processing, can you overcome that and recognize that not everybody is going to react to that same situation the way you would? Meaning, just because somebody chose to flee does not necessarily justify an inference of guilt. It can, but it doesn't necessarily. And then finally, the accuracy of confessions. We know that some people, when they interact with police, are more likely to confess to crimes that they did not commit because of the circumstances of the interrogation. And race is one of the many things that can play a role in that. So when a juror hears that a defendant has confessed to the crime, but doesn't have the background or the necessary system one processing to conclude that that confession might have not been a true confession, or it might have been a coerced confession, that particular juror may have system one processing that makes that juror less receptive to the argument that it was a coerced confession. And without intervention, that juror might, in fact, bring those preconceived notions to that juror's decision. And then finally, the last of these is that witnesses are notoriously bad at identifying accurately the defendant who actually did the deed if the witness and the defendant are not of the same race. Cross-racial identification is really problematic, and the social science bears that out as well. So this is how a person who is not guilty of a crime through the manifestations of these various System 1 processings could be found guilty by a jury. And that leads us to the wrongful conviction rate, which is unknowable, obviously, but it is thought to be somewhere between 2 and 10% of our incarcerated individuals are improperly incarcerated. Yep.
You know if that figure is a totality, in other words, plea and trials, or is that just a trial?
It depends on that's why there's a range, but it depends on what study that you're looking for. But this is essentially about trial results, except to the extent that people are convinced to plead guilty because of the aspects of the case that their lawyers advise them are going to go against them. So some of these statistics, depending on which study you look at, do include resolutions short of trial. What's the actual absolute number that translates to? There are 46 to 230,000 people who have been convicted, and based on the percentages, these people are all convicted for crimes that they did not commit. Now, one of the things that obviously has got a lot of attention lately in legal circles is the DNA exoneration. The Innocent Project has done a lot of that. But bear in mind that not every crime is a crime for which DNA supplies that kind of information, right? Certainly there are crimes in which bodily fluids are left behind, and that's testable. But there are a lot of crimes, particularly lower level crimes, but still felonies, many of them, where there is no way of using DNA to exonerate someone who was convicted wrongly. So there's just no built-in method in our system to really attack this number, which is obviously an untenably high number. So let's talk about why the existing world of appellate review is inadequate to the task of dealing with these kinds of wrongful convictions. So first of all, procedural error is coincidental. What do I mean by that? Well, what I mean by that is that in our clinic, and some of my students are here with us today, in our clinic, we go through kind of a laundry list of different possible errors to look for when a defendant is convicted and wants to appeal. Some of these lists of things, sort of checklists, they come from different courts that have Anders briefing criteria that they require appellate counsel to look at to make sure that you don't miss something in the record that might support reversal. And most of those things, most of those ways of conventionally reversing a criminal conviction are procedural. Speedy trial rights, Fourth Amendment issues, something that went wrong in the evidence at trial. These are procedural things built into our system that are wonderful to have. But we cannot assume that every wrongfully convicted person suffered one of those missteps during the trial process, because these are, in essence, disconnected from the actual guilt or innocence of the person who has been convicted. So procedural error is great when you've got it, but it doesn't really speak to this problem. So what about sufficiency review? Well, what is the standard that an appellate court actually uses when giving a sufficiency review? Jackson versus Virginia is the key U.S. Supreme Court's case that says sufficiency review requires proof from which a reasonable jury could find no reasonable doubt as to every element of the crime. That's terrific, right? It's great language. We're going to hold every jury to the reasonable doubt standard on every element of the crime. Great. But it's not that a reasonable jury should or should not. It's could find. It's could find. It's theoretical. So regardless of what the actual jury decision was based on, regardless of whether a weak case that nevertheless survives the sufficiency challenge was decided against the defendant, not because the evidence was overwhelming, but because the jury, for whatever reason, chose to believe the evidence that was adverse to the defendant. And to the extent that that decision on the jury's part was infected by one of the implicit bias factors that I talked about a few minutes ago, by system one processing, to the extent that, and not the compelling nature or quantity of the evidence, was the reason why there was a conviction, a sufficiency review will never get you a reversal. So all the prosecution ever needs to do is check the box for each element, and as long as there is evidence sufficient for a jury to find no reasonable doubt, regardless of whether their own deliberation process is actually looking at it that way, this is not a defendant-friendly standard. And it certainly doesn't empower the appellate court to overturn the substance of most criminal convictions. Then you look at the United States Supreme Court as sort of representative of the judiciary across the United States. And although it's a little more diverse now than it was last year, it is still not representative of the overall population of criminal defendants, certainly not representative of the overall population of convicted criminal defendants. And I forgot to mention when I showed you that 200,000 number, it is disproportionately made up of people of color. Very, very disproportionately. So yes, we're doing a little better in the composition of our judiciary, but if you need a majority vote to get the kind of relief that a criminal defendant is looking for, then presuming that you are going to get different implicit biases based on different features of the judge, race, ethnicity, skin color, age, experience, judicial philosophy, and on and on and on, the composition of the courts that review criminal convictions is obviously going to be affected by the personalities and experiences of the people who come to the bench, bringing with them whatever intuitive thinking they have. Then we get to this concept of affirmation bias. So for our appellate judges in the room, forgive me if this is somewhat, it is a critique of appellate review generally, not of any particular judge in this room. But what is affirmation bias? What do you think it is?
The overwhelming number of decisions are affirmed.
The overwhelming number of decisions are affirmed. Why, though? What is it that makes it a bias?
Primacy, the decision was already made then.
Right. All of us tend to have a preconceived notion that if somebody decided something before we are faced with the question, then that decision is likely to be better than the one that we are being asked to make in the other direction. It's not just judges, of course. It's anytime you know that somebody holds an opinion, it's going to carry sway with you, obviously depending upon who it is that holds the opinion. But there is a documented affirmation bias in the US judicial system that has been tested empirically, and that when judges are told about a result and then asked to see if they agree with it, they will agree with it much more readily than if they are presented with the same facts but without that additional piece of information that somebody already held a particular way. That's what affirmation bias is. Okay. Whoops, what did I do, Rob? Thank you, Rob. Rob is my hero. All right. So it really does give the appellate court that extra imprimatur of integrity or reliability that is actually not supposed to be part of what the appellate review process is about. So you have our poor, unfortunate criminal defendant here who is theoretically at risk for being wrongfully convicted based upon implicit bias as that can play out in the jury system. And then you've got the Jackson standard layered on top of that, which is not an adequate basis, as I mentioned, for really getting to the substance of whether the conviction was right or wrong on the facts. And then affirmation bias on top of that. And where does that leave our criminal defendant? Without much of an appellate remedy for any of the substantive problems with the conviction. Still there for procedural problems, but not for substance, okay? So what do we do about that? Well, there is, as I mentioned, in most jurisdictions, an opportunity to challenge factual review, or to challenge the factual accuracy of a conviction in the trial court itself. In most jurisdictions, there is the right to ask the trial court to grant a new trial after the fact. In civil cases, we have Rule 59. In criminal cases, I can't remember the rule number, but the rule that gives rise to that relief isn't just about the weight of the evidence. It's about anything that you can argue went wrong in the trial. The point is that the rule is there to give the trial court judge that power to intercept or override a conviction that might have been tainted by one of the manifestations of implicit bias. So the trial court has that power, but the trial court does not frequently use that power. And when the trial court denies a motion for a new trial, it goes up to the Court of Appeals and gets reviewed for abuse of discretion, which, as one scholar has said, by that time there's really not a lot of meat in the broth anymore. So that, the abuse of discretion standard is obviously a very, very weak standard of review that does not give an appellant a real good shot at getting a trial court decision overruled. And this is not Ohio specific. This is actually not Ohio. This is throughout most of the country, that this is the only way in most jurisdictions that somebody who is truly aggrieved by an incorrect factual determination that led to a conviction, this is the remedy. That's it. And what that ends up doing, all the power is here. Of course, the power is in the jury as well, but all the legal power is here. The abuse of discretion standard is not going to step in very often to override the decision of that judge to deny the motion for new trial based upon whatever went wrong in the trial court proceedings. It just doesn't happen very much. So this power is basically the power that I am seeking to challenge here. I think it's too much power vested in one single individual. Why are appellate courts reluctant to disturb a jury's factual findings? Why? What do you think? What are the reasons why? Yep.
Jurors are there in the courtroom with the accused and the witnesses and can perhaps make better determinations of credibility because they're seeing the person firsthand.
So the answer given for those who are not able to hear it live is essentially one of institutional competency. The concept is that jurors have the better vantage point to assess things like credibility and to sort out inconsistencies in the evidence. That jurors are there, they witness the demeanor, they bring their life experiences, which is not always bad, right? We want juries comprised of our peers, if they're truly our peers. But the idea is that appellate courts are not in the business of doing that fact-finding because they're not there in the courtroom when the evidence is presented and they don't have that vantage point. There's another explanation for it as well, which is tradition. We people are really not good at bucking against tradition for the very fact that it's tradition, right? The first song in Fiddler on the Roof is tradition. We do things because of tradition. They are built into our system. Our common law tradition is a tradition. The prior cases that we rely on them because it's tradition. We don't want to change things. And so there is a traditional argument that the traditional province of the jury is to judge the facts, and the traditional province of the appellate court is to apply the law. And the second reason is what you said, notions of relative institutional competency, for the very reason that jurors are there in the courtroom and are perceived to be better adjudicators of witness credibility and the like than appellate judges who are looking at the cold record. Both of these don't really hold up. The tradition argument is based on the historic right to a jury trial. In criminal cases, that right is conferred on criminal defendants by virtue of the Sixth Amendment. Does that look like tradition from a standpoint of a criminal defendant seeking to appeal a conviction? The accused shall enjoy the right to a jury. The state is not listed there as having the right to the jury. The appellate court certainly isn't listed there as having the right to a jury. That traditional right, to the extent we value it for more than just the sake of doing the same thing we've always done, belongs to the individual on trial. And because it is the individual's right to have a jury trial, it is also the individual's right, if you follow the logic, to tell the appellate court, I would like you now to do what the jury did not do. So the traditional argument against appellate review of facts isn't really borne out by the particular circumstance in which a criminal defendant seeks to overturn the factual basis of a conviction on appeal. What about the notions of relative institutional competency? What about that? This is the one you articulated, and it's the one that really has the most compelling legal support for it if you dig through the case law. So the idea is that the judge who is sitting at the trial and facilitating the witness's testimony is not evaluating credibility. That is left for the jury to do, and the jury is there seeing it. And then the judge, who might be asked afterwards to grant a new trial, also saw it. So everybody in the room saw what the witnesses all said, what the evidence was. They are in a better position, so goes the argument, to decide if there was something wrong with that evidence or wrong with the process that led to the conviction. But guess what? It's not that simple. The transcript, that cold record, the white pages with black lettering on them, the thing that is often invoked as the justification for deferring to the jury with its greater competency, is actually a pretty darn good way of checking to see if the jury got those credibility determinations or the sorting out of the evidence correct. What can you do with a transcript that you cannot do in the jury box? You can sift back and forth the pages and see if testimony was maybe different from how the jury heard it when you actually look at the words. You can compare whether testimony from one witness actually contradicted another. You can compare whether the testimony of the same witness contradicted itself. And while a jury is there to hear those things, they don't always catch those things because they go by in an instant. Whereas the study that an appellate court can give to that cold record is a much better backstop against a jury's improper resolution of factual questions against a defendant. Now, I am not here to argue to you that it should all be done by the appellate court. We can live with both, right? We can give that jury the first pass at making those determinations. Without in any way watering that down, though, we can also give the appellate court a greater role in determining whether or not that jury acted reasonably in convicting a defendant. Okay, so that dispenses with the traditional notions that an appellate court shouldn't do this, and it essentially undercuts the setup that we now have in 48 of our states, with Ohio being one of the exceptions, or maybe 47. So, if the appellate court orders a new trial when the conviction appears to be contrary to the manifest weight of the evidence, which is what Ohio judges already have the power to do, we'll talk a little bit more about that, then we can guarantee that the appellate court is truly sitting as the 13th juror, as the case law suggests that it should, and it's supposed to reassess credibility and reweigh the evidence. Now, One of my former students is here and knows that we have seen some conflict in 8th District decisions on this very point. I think Judge Sean Gallagher is a big proponent of doing a full credibility review on manifest weight. And I think there are other articulations of the manifest weight standard in the 8th District that say we defer to the jury's fact finding. So that's, by the way, an en banc conflict that maybe one day will get resolved, right? In fact, the Supreme Court just dismissed a case called State versus Metz in which that issue actually came up. And so I was hoping we would get some resolution to it. In any event, the key here, 13th juror, that language 13th juror that you see in every Ohio manifest weight decision comes actually from a U.S. Supreme Court case called Tibbs versus Florida. And in Tibbs versus Florida, the Florida Supreme Court had overturned a defendant's conviction, and the debate was this a sufficiency reversal or a fact reversal? They don't call it manifest weight everywhere. And what the Supreme Court basically said is, if it's a sufficiency reversal, then double jeopardy prevents a retrial. But if it's only a factual weight reversal, then the remedy is a new trial, and double jeopardy does not step into the picture because it is a factual review that initiated by the defendant that does not deprive the state of the opportunity to retry. So that distinction was drawn, but here's the key. Think about that phrase, 13th juror. What does it mean? What work does that phrase do in the case law? Yep. SCOTUS said it, but it was reviewing the Florida Supreme Court's decision. And what does 13th juror mean? What it means is we've got 12 jurors sitting in the courtroom. What happens if one of them refuses to budge and the other 11 all say guilty? And they do the charge and the jury says, sorry, we can't resolve it. We have one holdout. What happens?
Mistrial.
It's a mistrial. And then? A retrial, right? That 12th juror, that holdout juror, does not prevent the state from prosecuting the defendant in question, even though there has been a hung jury. What that 12th juror has done has been to require the state to do it again, and if they can't prove to another jury that there is guilt beyond a reasonable doubt, because that jury comes back with an acquittal, then you know that one lone juror who held out actually functioned as the 12th juror and did something important in that case. Why would it be any different for a 13th juror? Essentially, what manifest weight is really all about is just giving that last juror an opportunity to vote after everything is said and done, and that last juror might say, I don't know, I don't feel it. Hung jury. It takes a unanimous 12-juror conviction and turns it into a 12-to-1 conviction. We're at the appellate court sitting in the place of the jurors, not in the place of, in addition to the jurors who were in the trial court. There is no double jeopardy, as I said, because it's Tibbs versus Florida. So there is no real concern here that you're going to let innocent or guilty people go free, right? You're not discharging them the way that you would do in a sufficiency review under Jackson. You are saying that they deserve another trial because we lack the confidence in the integrity of the trial that led to this conviction. But it's available only in 3 states.
So if the goal is to avoid the implicit bias and you grant the order to have a new trial, what's going to be different? I mean, is it just putting the gerbil back on the wheel?
Well, it's a great question, Judge Groves, and you can't know what the next jury is going to be. And I'm not here to suggest to you that if you give it another shot that you will eliminate a wrongful conviction by virtue of that second jury, but you'll at least give it a chance. And there are other ways that judges can help jurors overcome their own implicit biases. Micah Thompson, who's out of the University of Missouri at Kansas City, has written all about the value of implicit bias jury instructions. In other words, remember, I told you, System 1 thinking can be overcome by System 2 thinking, but it doesn't happen without work. And so if you give the jurors the instruction that they are to be careful about how they make determinations based on implicit bias, that can help resolve the issue. At the end of the day, if there is another trial, that second trial, if it results in a conviction, the defendant has the same rights of appeal as the defendant otherwise would, and whatever error, including manifest weight, that defendant wants to argue, it can be argued again. There used to be, Appellate Rule 12 used to prohibit a second reversal on manifest weight. It no longer does. That has come out for about 10 years now. So I guarantee you that I am not suggesting this is a perfect solution, but it's at least in the right direction. Texas and Florida have both struggled with this idea of manifest weight, and eventually both of them got rid of it. So instead of taking a step in the right direction, they took a step in the wrong one. Now, let's take a look at our appellate panel here. Let's say, I skipped a slide here. Let's say we've got our 3 judges who are sitting on the appellate bench, and they are asked to overturn a criminal conviction based on manifest weight. So they might all vote to affirm. And if that's the case, the conviction stands and there is no remedy for the defendant. Or you might get 2 reversals, or 3 reversals, I'm sorry, unanimous reversal, and this would, of course, be overturned for manifest weight. What about 2 reversals and 1 affirmance?
It's called Mets.
It's called Mets, right.
Or maybe that was 2 affirmative.
Unanimous, right?
This case would be affirmed in Ohio if it's 2-1 in favor of reversal, because under the, in a jury trial, right. Because under the Ohio Constitution, only a unanimous panel of 3 judges can override a jury's decision of guilt. Think about that. Does that make sense? In a time when the systematic recognition, the recognition of systemic issues in the justice system is at its height, which it's terrible that it is there, but it's wonderful that we're looking at it now more closely, right? In the 1960s, the civil rights movement left everybody, well, not everybody, it left a lot of people feeling like everything's better now. We don't have to worry about racial issues in the justice system. We fixed all that with you know, awakenings and legislation. But we know that isn't true. We know that isn't true. And so if there is a need for correction for those 200,000 people who are wrongfully convicted, why would we demand unanimity on the appellate panel? To the contrary, I think that you should be able to get a conviction overturned on manifest weight grounds, even if you have only 1 appellate judge who thinks there's a problem. Let's look at why. So, in this scenario, where 2 of the judges would affirm on a manifest weight challenge, and the 3rd one would reverse, maybe this judge is thinking the jury just wouldn't accept that it was a peach. And if one of those judges feels that the jury wouldn't accept it was a peach, why should that reasonable doubt on the part of a jurist, a trained lawyer with practice experience, often criminal practice experience, why should not that judge have the same power to be the 13th juror as the panel in its entirety has? What is the policy justification for not giving that power to each judge on the panel, other than tradition? Of course, there are some easy answers to that question. There are easy answers to what the policy justification is. It's obviously more work. It's obviously more uncertainty. It obviously sends more cases back for retrial. But is that really such a bad thing if one of our appellate judges thinks the jury got it wrong, and we know that the wrongful conviction rate is as high as it is? So this case would be reversed per my proposal. And let's look at why. Why single judge reversal? Relative competency. Relative competency. What do we mean by that? A background that brings a particular judge to the bench may not be the same as the background that brings the other two judges to the bench. Think about that concept of diversity in the judiciary and how our Supreme Court looks very different today from how it looked a year ago, and very different a year ago from how it looked 4 years ago, right? That kind of diversity is hugely important to the judiciary, and the only way to empower it and give it teeth is to give every judge the power to do justice. Training, every judge is a trained lawyer. This concept of jury unanimity. There is a recent US Supreme Court case that says that the states, there were 2 states, Oregon was one of them and I can't remember the other, the states that said that a criminal jury could convict even without unanimity. 10 out of 12 jurors, I think it was, in Oregon, could convict. And the Supreme Court, even this Supreme Court, said, no, it's got to be unanimous. That kind of a verdict that is not unanimous, to allow that to stand is a relic of the time in our country when Norris versus Alabama was decided, and excluding people of color from the jury rolls was just one of many tricks to avoid having a defendant of color acquitted by having somebody look at the case from a perspective that was not uniform, right? The uniformity of all white juries, for example, which was prevalent in the South, it's unconstitutional. And so why would we not require unanimity on the appellate bench as well to affirm a conviction that is being challenged as against the manifest weight? That unanimity is central to our conviction process. Why just at the trial level? And then, of course, you know, the 230,000 people wrongfully convicted, if that's not a powerful enough argument for you to buy into this, then nothing that I can say will get you there. Yep?
So what would be the purpose of a jury under this system? I mean, they're the people in the courtroom, they're seeing live testimony in the evidence that the appellate judges aren't able to see in the same fashion. They don't get to hear inflections or tone or fidgeting or any of the mannerisms that the jury sees and evaluates. And we're going to give 3 vetoes, only one of which needs to be exercised to wipe out the conviction that required a unanimous jury?
So the question, for those who didn't hear it, is why would we give that kind of veto power to an appellate judge when our system is designed around having juries decide cases? They're the better position to evaluate the evidence and so forth. On the institutional competency piece, I just revert you back to what I said before, which is that it's a mixed bag. But the question is, why have a jury? Well, my answer to that is because every path that stands in the way of conviction is a guarantee, for the constitutional guarantee, that there's going to be more due process. So if the jury acquits, we're done, right? But if the jury convicts and all 3 appellate judges are fine with that, we're also done. So you still got to go through that jury process. They are essentially the gatekeeper to a conviction, but the appellate court is the safety net that prevents the wrongful convictions from, theoretically, from being upheld. So to me, they work hand in hand. And I don't see an inconsistency there. I agree with you that we are, in some ways, watering down the role of that first jury, but don't forget that if an appellate judge vetoes what that jury has done, it goes back, as Judge Groves noted, to a second jury. It's still ultimately the jury's decision, as long as the issue that we're dealing with here is a factual one and not a legal one.
But every time it goes back, more time has passed. Witnesses begin to no longer show up for these trials. You lose other evidence. It deteriorates over time. There is a...
So that's all. What we are going back and forth about here is really just a value judgment. If you value expediency over eliminating wrongful convictions, I'd agree with you 100%. I put my value eggs in the other basket. That's just my personal view. Yep.
To follow up on the jury question, the jury is a group of 12 individuals with their own life experiences, with their own implicit biases.
Mm-hmm.
So they act as a unit together. So they go back into the jury room, they confer with each other, they talk to each other, and therefore we have a diverse jury in theory. They've all heard the evidence, they sit there together, and they have they obviously deliberate, and they come to a conclusion together, right? So it's not one person's implicit bias taking over the jury. And they were the ones who were there, they heard the evidence, they're in the best position to point out the credibility and the contradictions, and if they miss any contradictions, I'm sure that the defense attorney brings it up in closing argument and points those contradictions out to them, and if the defense attorney doesn't, they already have a ineffective assistance claim there. And you want to take the jury and put the jury's decision as a group of people, you want to be able to have one judge sitting on the Court of Appeals making a decision on their own without conferring with the other 12 jurors and having their decision and their own implicit bias come to the decision that we need a new trial.
Yes.
Is that your position?
Yes, that's exactly my position. That's exactly my position. Thank you.
So the judge's implicit bias trumps the 12 jurors who come together whose implicit bias is mitigated by deliberation.
I mean, you're assuming that the judge who comes to that conclusion is exercising implicit bias. No, I'm not assuming anything. I'm giving the power to the judges to.
Then the premise of this entire, your premise of your entire argument falls there if you're not assuming implicit bias.
I don't think it does, but I would suggest that you advertise yourself as willing to speak next time, and you can give the counter argument. You're doing a great job of it. Yep.
We have this panel acting, I would say, not as the 13th juror, but as the 13th, 14th, and 15th jurors, any of them who can hold out. So if we get, 3 affirms there, do we actually get like another 19 jurors if we can somehow manage to pull an en banc panel, get rejected there, and then take it up to the U.S. Supreme Court? Do we continue to?
Where is the end? Is that what you're asking?
I mean, the end is certainly no further than the Supreme Court, but like I'm wondering, does your proposal, allow for continued like one judge rejection?
So, first of all, my proposal is so theoretical and so unlikely ever to see the light of day in any actual jurisdiction that I'm not bothering with the intricacies of those details. But I will tell you, and I think it was, I can't remember who asked the question, well, what if the second appellate panel wants to do the same thing, or one judge on the second appellate panel? And my answer to that is I trust our judges enough to have the history of the case be part of what they consider. I would imagine that the judge who reversed the first case and then it comes back and a second jury has convicted might think a little bit more carefully about reversing it a second time if they want to give that deference to the jury. It's just a safety check, right? It's just a way, because we all know juries get it wrong. And when we know that juries get it wrong, none of these other arguments to me carries any weight at all, because you've got 230,000 people sitting in prison who shouldn't be there. And to me, that's a greater injustice than any of these critiques, which I welcome. I get your points. Anyway, the remedy is, to emphasize this, the remedy is a retrial. It's not discharge. So you're not sending criminals out onto the streets. You're giving accused defendants who have been convicted once an opportunity to get out from under what at least one judge perceived was a flawed trial. But maybe this will help, because you're rightly wondering, how does that single judge who might not agree with her colleagues make a decision to reverse with all that power, that veto power? And here's what I would say to you. You don't have to have any evidence of overt bias. There actually there are very few instances when overt bias is present in the record. That's what makes this so nefarious. The couple of times that it happens, it gets called out on appeal. Justice Sotomayor wrote a concurring opinion in a case in which a federal prosecutor used ethnic stereotypes to convince a jury that the defendant was in fact a drug dealer. And by the way, I will say that I have been present in a courtroom, as I know at least one other person in this room has, when one of our 8th District judges asked a question that absolutely suggested implicit bias because there was nothing in the record to support the factual predicate for that question. It was all because it was a parental rights case and our client was African American. I'm certain of that. So it happens at every level. You need to have folks on the judiciary who have the power to step in when it does happen. So you need one or more of the following. You need serious conflicts in the evidence that are patent in the trial record on dispositive facts. There has to be an actual conflict in the evidence or a serious possibility of a verdict that was based on improper race-based propensity, which you might be able to glean from either the voir dire of the jurors, or something that happened in the course of the presentation of the evidence. A serious possibility of tainted credibility determinations, and this is where that transcript review, I don't care how good your defense counsel is, they're not writing down every word. They can't argue to the jury everything that comes out in the trial. Sometimes they don't even hear it, but a record will disclose it. And then a serious possibility of a coerced confession, depending on the circumstances of evidence of a confession and how it was presented. To me, that ought to also be a factor that goes into this. So. And then a conviction that is premised on cross-racial identification is also a good candidate for studying very closely to see how strong the other evidence against that same defendant was, considering what we already know about the inaccuracy overall of cross-racial identification. So that is my proposal. I am delighted that it has inspired so much controversy. I don't know that I ever hoped it would get this much attention, and the pushback is just great publicity for me if you keep going with it. So thank you very much for your time. Does anybody else have any questions? We have a couple more minutes. Yep.
I think following the gentleman, I think what the gentleman was talking about was you started this by saying that system two thinking is a way to overcome the implicit biases. And I think what he was referring to that there are many examples of system two thinking from the very beginning, from the police investigation to the prosecutor's evaluation of a case, to the jury deliberation, to the defense attorney's closing arguments. So there's a lot of system two opportunities for system two thinking in this process, and yet it's still inadequate. And what I want to ask you is, why do you believe that it's still inadequate, even though it's already kind of in, some of it's already in there?
Because the jury has no role in any of those other opportunities, right? It's the jury's system one thinking that we're worried about here. It can be, but if you accept the premise that every jury studiously overcomes whatever biases that they may have and they never reach verdicts that are tainted by bias, if that's what you believe, then maybe you're satisfied with it. I don't believe that. Other questions? Yep.
So to kind of bring it in more to the practical of how this standard is currently working, I was looking at a case recently from the 8th District that talked about two of the judges voted manifest weight to overturn a conviction. The third said this is not the rare case where that should happen. In your research, do you feel that maybe because we have other maybe safety or relief valves, post-conviction remedies, habeas, that maybe some judges are a little more likely to say, okay, on a direct appeal, I'm not going to be that one to say I'm really going to stick with the jury because this is the true wrongful conviction, the true wrongful conviction, that there's a post-conviction relief somewhere out there that I'm not going to have to be.
Yeah, if that's what the judges on the appellate panels are thinking, I've got news for them. The last thing you want to hang your hat on is post-conviction relief, and the very last thing you want to hang your hat on is habeas. So those may have been designed to help prevent injustice, but they are woefully inadequate to the task. I'm sorry, I'm happy to entertain questions after, but I don't want to go past my time. Thank you all very much.
Good afternoon. If it's not November, I'm still Judge O'Sullivan. We brought this to you today. We'd like to talk to you today about something that's more important than anything else you've heard today. It's your health, something that concerns us all. I know that when I first became an attorney back in 1990, the ABA published these outstanding numbers. 10% of the general population is likely to be suicidal, become an alcoholic, or become severely depressed. But only 13% of surgeons. So surgeons, because it's so stressful, it's a little higher. Lawyers is 25%, trial lawyers is 35%. So the ABA, we went on for 30 years, and Mr. Moat and I were just talking about this. They published the numbers again a couple of years ago, and it's still 10, 25, 35. So your mental health is one of the more important keys that you have to being a successful attorney. You can't argue any of these things if you're in a hospital somewhere, if you have a heart attack, or you wrap your Mercedes around a tree at age 50, like I've known many people not in this room to do. So Scott Mote is here. He's the executive director of OLAP, the Ohio Lawyers Assistance Program. He tells us that he has been sober himself since January 7th of 1985, which I cannot say the same thing. That's the year I graduated from college. Scott was a general practice lawyer for most of his practice, but is now the executive director of OLAP, and also enjoys golfing and loves to go to museums and enjoy the art, which is one of these keys about this whole thing is you have to find ways that are healthy to relax. And Scott has done that, so I'd like to introduce to you Scott Mote.
Good afternoon. Pretty day to drive up here. The leaves are kind of dull, though. They're just not really bright. I'm Scott Mote. I'm an alcoholic. Come on, one. Hi, Scott. Hi, Scott. There you go. Thank you. You got to see 28 Days. It's on Netflix again. It's really good with Sandra Bullock. I cried through most of the movie. It's a little bit close to home. I'm Scott Mote. I'm an alcoholic, and by the grace of God, one day at a time, I've been sober since January 7, 1985. And I grew up in a small town in western Ohio down near Dayton called West Milton. And it was a community for people that commuted into Dayton, commuted to Troy, Vandalia, etc. to work. I was a good boy. It was kind of like a Leave It to Beaver, if you're old enough to remember that. Upbringing. Four merit badges shy of an Eagle because I got a driver's license and a girlfriend, and that took care of those priorities. A good student, a leader in the school, a leader in the community at my age group, a pretty good jock for no bigger than I am, all of those things. And after a high school football game in 1965, I'm 15 years old, sophomore in high school in Nellie Lowry's woods on the edge of town, had a bonfire. Somebody brought 3-2 beer in. That's how old I am. We still had 3-2 beer. I'm 72, glad to be here. I had my first beer at age 15. And I didn't like the taste of it, but I loved the way it made me feel when that ethyl alcohol hit my brain, and it was like I have been waiting for this my whole life. This is the best thing that could ever happen to me. How do I get more? And what I found out in January of 1985 at Talbot Hall, Drug and Alcohol Treatment Program, now part of the Ohio State University Medical System in Columbus. What I found out during my 28 days inpatient treatment for chemical dependency, alcoholism, was that I had a genetic predisposition to chemical dependency, to alcoholism. Alcoholism runs in the male side of my family. And what I did in 1965 was trigger a genetic predisposition, and I spent the next almost 20 years, the professionals told me, trying to find that buzz again, trying to find that sweet spot again in the pleasure receptacles in my brain. Trust me. At no time in my 20-year drinking career, at no time in all of the fights with my wife, at no time at looking myself in the mirror and hating the person who was looking back, at no time when I shirked my client responsibilities, at no time when I dipped into my trust account to pay a bar bill during those last years of my drinking. There wasn't a single time that I did it volitionally, that I became an addict volitionally. I've been sober now for 37 years plus. One day at a time, I've gone to I don't know how many 12-step meetings, and I don't care. I'll just keep going. I don't know. I've helped over 3,500 lawyers, judges, and law students in the state of Ohio with addiction and mental health problems. I have yet to meet anybody who said, I became an addict intentionally. I have yet to meet anybody who said, I became mentally ill intentionally. Haven't found that person yet. If you're in the room, please identify. Yeah. So, in my 30 years of practice in Columbus, primarily what I did was civil litigation. I was in a small firm. We represented family, closely held corporations, kind of stuff, real estate developers, And when the litigation started, that's when I got involved in it, in the business litigation side, and did some domestic relations type stuff. You know, what you're doing as a trial lawyer is you're letting somebody tell a story, trying to create a story here, a line, and do a story. So I found it helpful to let my clients speak in working with the Ohio Lawyers Assistance Program, because I can stand up here and do the medical, well, it's not a very good medical speech, but I can give you statistics and numbers and all of that kind of stuff, chemicals and whatever. But I think if we listen to our colleagues talk about how they get here, what's happening, what's going on, what I need, kind of thing, I think, you know, perhaps you get a better idea of what we do with the Ohio Lawyers Assistance Program. You know, I was listening to Professor Paulus talk about, you know, the publicity. I'd love to see us be able to put the Ohio Lawyers Assistance Program out of business, but I don't think that's going to happen anytime soon. The first one I'd like to talk about, this is an Ohio guy. This is a kid out of Minneapolis, St. Paul. This was sent to me by my colleague Joan Biebelhausen, who runs the Minnesota Lawyers Concern for Lawyers program. This is out of the Minneapolis Star-Tribune newspaper from a few years ago. Christopher A. Oster, second-year University of Minnesota law student, age 22, of St. Louis Park, Minnesota, took his life on January the 14th. Beloved son and brother of the devastated parents Paul and Daniel, survived by siblings Kim and Jonathan, we will miss forever your brilliant wit and charm. And Joan went to the University of Minnesota Law School, and she talked to classmates, she talked to faculty, she talked to administrators, and she found a lot of people there who observed Christopher Oster during his first year of law school, first semester, second year of law school, decline. They watched him spiral down. He came in vivacious and engaged, and they watched him stop going to classes and get dark and gloomy and gray, resulting in eventually him making an irreversible decision to kill himself after finals his first semester of his second year. It's no one else's fault that Christopher Oster killed himself. What she couldn't find is anybody in that law school who took the time to say, hey, Christopher, are you okay? Is there anything I can do to help? And I don't fault people who don't come forward with those questions. It's a tough question. You don't know what the response is going to be. But you don't have to ask the question. I get 2 to 4, 6 suicidal lawyers a year. In Ohio, we get a couple, 3, 4 who will actually go through it. Some of them I've been working with, and they haven't been able to grasp the change and get out of the despair and choose to go in a different direction with the professional help that we've recommended to them. Occasionally, I'll get the phone call, usually on a Monday morning, by a lawyer someplace in the state who's angry. I can hear it in their voice, and they say, why didn't you help Mary Smith? And I, well, who's Mary Smith, and why are you calling me on Monday morning? I can tell you're angry. What's going on? Well, Mary killed herself over the weekend. Well, how long had Mary been having difficulties? Oh, everybody in town knew she was in trouble for at least a year. Why didn't you call me a year ago? So if you haven't seen it yet, if you do at some time, I don't care. As I said, you don't have to be right. You don't have to diagnose. You don't have to fix. You don't have to do anything, but be willing to reach out to somebody else who knows what to do, how to do it, to try to intervene in somebody's life before they make an irreversible decision, because we get them in the profession. You know, the Ohio Supreme Court did away with the mandatory substance abuse education in January of 2014. So I'm here because it's not required. I'm just part of professional conduct now. If you recall, if you're old enough, we used to have to get a half hour every 2 years. The court did away with that. But interestingly enough, the court did not do away with the 1 hour of mandatory instruction to take the Ohio bar exam. So we still get to go to all the law schools, including this one. So I get to go to 4 or 5 of the 9 a year, whatever it is, depending upon what our schedule is like. And invariably, it seems I'll get a phone call or an email or something within the first 24 hours after a presentation. It's just like clockwork. So this is an email that I received. I spoke, this just happens to be at Ohio State. I spoke in the afternoon. I probably finished at 4:30 or something, and at 5:02 in the afternoon, I got this email from a female 35-year-old third-year law student. I attended the presentation you just gave. I have obsessive compulsive disorder, but I am not medicated, as I have never found anything that works for me. I also think about killing myself all the time, but I do not consider myself suicidal because I would not actually go through with it due to my responsibilities to the people around me. My boyfriend has asked me to seek help repeatedly, but I don't have the money, time. And I'm worried that if I'm officially diagnosed with a mental illness as an adult, I would have a hard time being permitted to take the bar exam. I was first diagnosed with OCD at age 11. So we're 14 years later, coming out at the end of law school and recognizing that my coping skills are starting to not be enough, and maybe I can reach out and get some help. And I responded to her immediately. We met with her the next day, did an assessment, referred her to appropriate counseling, helped her get the counseling she needed, the medication she needed, and she was permitted to take the bar exam, and her life has gone on the way it can be when somebody reaches out and provides some help. I happened to speak at one of the other law schools in the state one morning, and I got this about a half hour after I finished. This is an email again from a female third-year law student at that law school. I was at your lecture this morning. I need help. I have been suffering from depression for as long as I can remember, stemming from being molested as a child. My life has been a textbook case since then, ranging from re-victimizing myself through rape to reckless behavior to not being able to connect with anyone. I thought I had it under control, but lately I feel myself slipping. I am on antidepressants, but they don't seem to be enough anymore. I tried the counselors through school, but they were of no help. And I responded to her immediately and went to the law school, arranged with her, calling on the phone, arranged with her to go pick her up and bring her back to our office or our clinic, my clinical director at the time. Did an evaluation, did an assessment, and a recommendation of my clinical director was, let's take you to an emergency room and let's get you medically stabilized because you're not. And she agreed to do that, and she voluntarily admitted herself to the hospital for 3 days where they got her evaluated and got her on the right kinds of medication she needed in order to treat the clinical depression and the anxiety. And when it was time to take the bar exam for her, we made full disclosure to the Ohio Supreme Court Office of Attorney Admissions about what's going on, what she's doing about it, and how she's being treated, and all the excellent things that she's doing. And the Supreme Court said, hey, there's absolutely no reason why you should not be permitted to take the bar exam. And she also has gone on to having a successful legal career because we were there to help. And I'm here because you guys pay for the Ohio Lawyers Assistance Program and support it out of the Attorney Registration Fund. I spoke at the University of Akron, and they do an all-school thing twice a year, once in the spring, once in the fall, in a great big amphitheater that must seat 300 people. I don't know. It's huge. So I did that in September a couple years ago and came home from playing golf one Saturday in October, and this is a series of emails exchanged between myself and a law student at the University of Akron at that time. Sir, I hope you're the gentleman who spoke to a group of us several weeks ago at the U of Akron. I have some questions I would like to ask. But I need to be sure of several things before doing so. Once I verify that this is the person I want to inquire about several things. Thank you for your consideration, and I respond. I spoke at Akron on 9/17. Feel free to ask away. All contact, including your identity, is confidential, and he responds. I believe I need some sort of assistance. Life is beginning to spin out of control. I thought I could handle it, but now I'm beginning to realize that this is not necessarily the case, and I respond. let's think about you coming to Columbus and meet with one of my clinicians. It takes 2 hours to drive here, and assessment takes a couple hours, so we need a day. Happy to talk on the phone. Give me a call Monday morning, 9 to 11. I leave at 11:15 for the rest of the day. I'll be in on Tuesday after 1:30. If you can't wait until tomorrow to talk, call me at home. And I gave him my landline, my cell phone. I look forward to helping you get to a better place. And he responds. I am in class from 9 to 12:15, so I will try to call on Tuesday. Further, I don't have a car anymore, so I have no way of getting to Columbus, and I respond to him Sunday night. I can send a clinician to Akron. We'll figure this out Tuesday. Are you thinking about killing yourself? His response, that is a difficult question to answer. Right now, no. But I drink 1.75 liters of vodka per day, straight. And I never heard from him again. Typical alcoholic behavior, typical substance use disorder behavior. I'm in crisis mode. I reach out for help. I need to do something here. I did it myself more than once. I'm in trouble. I need help. And then I go, well, wait a minute. Not that bad. Not that bad. I'll get by okay. I'll get by. I can do this. I can't tell you the number of times I asked God to let me get through this one and swear that I will never drink again, and the next day I drank. Never heard from him again. Heard about him. The law school called me early in December. Hey, have you ever heard of this guy? One of our first-year law students, people says he drinks a lot, and he's just kind of disappeared on us for the last 10 days. Nobody seems to know where he is. We thought maybe he reached out to you. I recognized right away who they were talking about, but because of confidentiality, there was no way I was going to acknowledge that I had ever heard of this young man. So I don't know whatever happened to him. But it's my understanding that he never finished his... Yeah. This is a smart kid. He's like you, he's like me. He's motivated. And his addiction is now taken away. Everything he'd worked for up to at least age 21, 22, 23, whatever it was, gone. Opportunity gone. I got this email in my box on a Tuesday morning. This is from a lawyer in Columbus who I looked him up on the Escort website. And he was in like his 9th, 10th practice of law. He worked for one of the government agencies, state agencies in Columbus. And he sent me this out of the blue on a Tuesday morning at 9:13. Mr. Mote, it is very difficult for me to write this email as I have always found myself to be strong-willed and capable of controlling my lifestyle. However, I have reached a point where I am compelled to ask what I need to do to get some help from OLAP. I am not a daily drinker, but when I do drink every weekend and sometimes on a weekday, I find it difficult to stop without having at least 10 drinks. Having done this for some years now, I want to be substance-free. Any direction you can provide to reach that end will help. And I responded to him immediately. That time my office was in downtown Columbus, still with my law firm. I'm at 37 West Broad. You're at 30 East Broad, the Rhodes Tower. You're a 5-7 minute walk from me. Why don't you come over, meet with one of my clinical people, let's do an assessment. We'll tell you what we see. Nobody will ever know you're here because of confidentiality. You take the information that we provide and you choose to do with it what you will. We're here to try to help. Crisis mode, oh, I need help. Nah, it's not that bad. It's okay. Never heard from him again. Heard about him. 6-8 months later, I received a phone call one day from a woman lawyer who identifies herself as a colleague of this fellow, working in the same office. And of course, because of confidentiality, I don't acknowledge to her that I have any idea who she's talking about, but I knew immediately who she was talking about when she used his name. She said, I'm really worried about him. We've worked together for 7 years. He's a great guy. He's got 2 kids. He's a really good lawyer. He's a wonderful friend. He's always been kind of a drinker, and it's just gotten worse and worse, and he screws some stuff up here at the office. and he needs help, and I don't know what to do. And I explained what we do at the Ohio Lawyers Assistance Program about facilitating interventions. I said, be happy to facilitate an intervention with you, other people in the office. We might be able to get his wife involved, I don't know. But whatever we need to do, I can help with the Ohio Lawyers Assistance Program. Why don't you talk to your section chief and get back to me if you think that's appropriate. I don't know if you should talk to this. Oh, yeah, she knows. So, end of conversation. 2 days later, the woman lawyer calls me back and says it's too late. Talked to the section chief, and she's really angry because he screwed this thing up, and she's afraid that it's going to cost her a promotion that she thought she was going to get, so she fired him this morning. End of story. At that point. 12 months out, I'm reading the Columbus Dispatch, looking at the obituaries, and there he is. And I determined that he shot himself. After having lost his job with the state government agency, he left a wife and 2 children. I always wonder if the section chief got her promotion and what she thinks about all that. So if you haven't seen a colleague yet, you will. If it hasn't happened to you yet, I hope it never does. But if you get to a situation where you have an opportunity to help somebody, I hope you'll call the Ohio Lawyers Assistance Program or somebody and not just look the other way. So Ron O'Brien in Columbus was the county prosecutor at the time of this email, and John Coughlin at that time was the Supreme Court Disciplinary Counsel. And this is an email that O'Brien sent to Coughlin on a Thursday afternoon. The above attorney with the Westerville residence address was arrested yesterday by the county sheriff for possession of a felony amount of oxycodone and appeared in Muni Court today where a $50,000 bond was set. An inmate was making phone calls to family to contact him and give him drugs in exchange for representation. The family cooperated. The lawyer agreed to receive drugs and conversations that were taped. The drugs were delivered yesterday to him. He was placed under arrest. He advised the deputies that he knew that they were going to eventually catch him. This is a 52, 53, 4-year-old criminal defense lawyer in Central Ohio who has been practicing law there his entire career. And if there is anybody in the city knows that outgoing phone calls made by an inmate at the Franklin County Jail are not confidential, he does. And his addiction forces him to throw all caution to the wind, forget about the negative consequences. I knew you were going to eventually get me, and arrange to get those drugs. And he was like the other 10, 12 lawyers that we have worked with, men and women over the years, who got themselves addicted to oxycodone, OxyContin. Every single one of the lawyers who I have worked with started out with a legitimate medical reason for taking the medication. Surgery, automobile accident, whatever it was, there was a legit reason for taking this stuff, but when they took it, their brain flipped on them. For whatever reason, usually because instead of taking 1 every 4 hours, they started taking 2 every 4 hours, or 2 every 3 hours because the exhilarating effect was such that the next thing you know, they're addicted, and now they're on the street buying it. One of the women lawyers I worked with had pending felony charges in three counties in the southern part of the state because she had stolen a prescription pad from one of her docs and was falsifying prescriptions for her oxy and going to different pharmacies in a three-county area in the southern part of the state where she lived in order to get them filled. Knowing, because she did criminal defense work and drug defense work, that the state DEA, equivalent of the DEA, is watching these computers all the time and seeing who's filling these prescriptions. She ended up going to prison. I had 3 county prosecutors and the judges in each of those counties all agreeing to try to hold off and let's get her into treatment. Let's see if we can't help her get moving in a different direction. We can deal with the criminal stuff later. Let's try to save her life. Let's try to save her career. Let's try to save her family because she had 3 kids at home. And she couldn't make it. And she ended up going to prison. So, if somebody recommends that you take Oxy or somebody in your family takes Oxy, my recommendation is you ask if there's an alternative med. And if there isn't, then don't let the patient hold the bottle. In August 31 of 2015, another one of my genetic cool things that happened to me, I had to have open heart surgery because I got really bad arterial sclerosis and all that kind of stuff. The cholesterol thing, and I got blockage, and I got the widowmaker, and I found it because I got a huge pain in my chest playing golf, walking. Play golf. It's a wonderful way to find out if you need open heart surgery. It's warm enough today to play. It's a little bit windy to have to work on my knockdown 7-iron a little bit today. But I ended up, because of genetic predisposition, all the men in my family die of heart attacks, so I'm going to go eventually that way. You know, it's nice at least knowing that part of it, I guess. But when I was discharged, I told my physician, Dr. Fanning, I said, I am not interested I don't like to take anything that's a mind-altering substance. My brain will just go. I don't trust myself after 37 years. I just don't. It's the way my head works. And he said, I need you to take this because your body is in such pain. That's the only way you're going to heal. So I never did know where the Percocet was in the house. My wife Gretchen had the bottle. But I did know every 4 hours when that alarm on her cell phone went off that I was going to get another shot of Percocet. Yesterday, I don't know if you saw it up here. Yesterday, there was an article coming out of the court news from the Ohio Supreme Court about a lawyer named Adam Stone in Bucyrus, Ohio. And I'm not busting anybody's anonymity because it's right there in the Crawford County Now newspaper out of Bucyrus. This is what Adam Stone released yesterday, a press release to Crawford County Now. It is my understanding that the Ohio Supreme Court Office of Disciplinary Counsel released this complaint against me to the court and local media sources. As of this writing, I have not had an opportunity to respond to the allegations. However, well before the filing of this complaint, I already applied with the Office of Attorney Services as well as the Supreme Court Office of Disciplinary Counsel to resign and forever retire my law license. He was admitted in 2009. Having handled and defended the cases that I have over the last 13 years in state and federal courts, all the things that I saw, and the recent passing of my grandfather and father created a situation in which my mental health needs addressed in an ongoing fashion. And I am undertaking that process to be better. In fact, my application to resign was supported by correspondence from my mental health provider who reinforced this decision to leave the practice of law. My first obligation is to my children, wife, family, etc. For a long time I had forgotten that and prioritized my life in such a manner that bit by bit I became lost in case after case of rape, murder, child exploitation, and many others. I do not want this for my family or for myself or my family anymore. I understand that some think this is somehow newsworthy, but my resignation has nothing to do with the disciplinary complaint. In fact, I haven't even read it in its entirety at this point. The reality is that I am resigning regardless, and I hope that all reading this will respect my privacy and the privacy of my family. And he even submitted a written report from his therapist, a statement from his therapist to the press. Because his career exposes him to deeply disturbing content, images, and intense psychological demands, this letter is written in support of his decision to discontinue the practice of law until he is better equipped to manage the emotional aspects that are inherent to the profession. It is my opinion that Adam's work-related stress has had a tremendously detrimental impact on his mental health. Although he may be quite skillful in his trade, it is advisable for him to step back at this time to prevent further decompensation and permit him to focus more on self-care and recovery. I have never seen that before. anywhere, let alone Ohio. I have never seen that before. A few years ago, I spoke for the Midwest State Bar Association Midwest Labor and Employment Law Conference. Anybody do labor law? These people had a 7:30 in the morning seminar.
Overtime.
Jeez, I don't even take a 7:30 tea time unless I have to. I will get in a duck line at 7:30 in the morning and a deer stand, those kinds of things. Back when I did that. Anyway, 7:30 in the morning, I am at the Hilton Easton, and there are probably 500, 700 lawyers from all over the Midwest in their labor lawyers, and I spoke at the seminar, and then I left and went directly to the golf course and played. They stayed on Friday and did their seminar, but be that as it may. I got this email the next day from a fellow who I had never heard of before, and this is what he said. Hi, Scott. I had the pleasure of hearing you speak at yesterday's Midwest Labor and Employment Law Conference. I am an X-year associate with a lawyer in a large firm in X city. 3 years ago, at the age of 32, I was diagnosed with chronic and serious depression and on the verge of suicide. Neither my wife, family, nor friends knew that I was feeling this way. It was hard to get out of bed in the morning, and I was engaging in other self-destructive behavior that would have, at the least, destroyed my marriage. Over the years, I had contemplated suicide at various times in my life. At this time, I had a plan. I went as far as to sit down at my desk and begin writing a goodbye letter to my family and friends. After my breakdown, I remember admitting to my counselor that I had contemplated breaking the window and jumping from my office on the 32nd floor. I knew I had a problem, but I thought I could fix it on my own. Eventually, I went into counseling, and with the help of my family and friends, began to realize what I needed to do to change my life. Mental health issues run in my father's family, and maybe that combined with this high-stress career caused me to become a danger to myself. Today, I'm still at the firm where I was when I had my major breakdown. My career is as strong as ever. My marriage has been repaired. We're expecting another child. I hold various leadership positions both in and out of the legal community. Most of my colleagues don't know of my past mental health issues. If I could offer advice to any lawyer or law student, young or old, I would tell them not to be ashamed of feeling the way I did and not to be afraid to ask for help. Mental health issues do not fix themselves. Everybody in this room has probably heard of a guy named William Rehnquist, right? I mean, how can we not? Okay, so William Rehnquist, in 1986, is a sitting associate justice on the United States Supreme Court. Ronald Reagan nominates him to become the Chief Justice, and in connection with that nomination, as we know, that brain trust known as the Senate Judiciary Committee vets the nomination. Do we confirm or deny? And in connection with the background information, the vetting, the Senate Judiciary Committee has William Rehnquist's medical records. For years and years and years, they are not open to the public. Eventually, under the passage of time and because of Freedom of Information Act and all that kind of stuff, eventually the medical records become available to the public. And here is some of what the Senate Judiciary Committee learned about Justice Rehnquist. Also detailed in the declassified file was Rehnquist's 1981 hospital stay for treatment of back pain and his dependence on powerful prescription pain relief medication. The FBI investigated his dependence on Placidil, which Rehnquist had taken for at least 10 years, according to a summary from a 1970 medical examination. When Rehnquist checked into a hospital in 1981 for a week-long stay, doctors stopped administering the drug, causing what a hospital spokesman at the time said was a, quote, disturbance in mental clarity, close quote. The FBI file, citing one of his physicians, said Rehnquist experienced withdrawal symptoms that included trying to escape the facility and discerning changes in the patterns on the hospital curtains. The justice also thought he heard voices outside his room discussing various plots against him. Prior to his hospitalization, Rehnquist occasionally slurred his speech during his questions to lawyers at Supreme Court oral argument. Wow. Chief Justice of the United States Supreme Court is a drug addict. What other conclusion do you draw from that? Now, let me ask you this, hypothetical. Do any of you think that William Rehnquist intentionally became addicted to prescription pain relief medication? Like I said earlier, in my 37 years of recovery, in all of my years of working with the Ohio Lawyers Assistance Program, I have yet to meet anybody who said, gee, I decided when I was 32 years old I'd become depressed, clinically depressed, and lose everything, and just become an alcoholic and go live in a shelter. Haven't found that person yet. I haven't found that person yet. You know, I talk about law students and I talk about lawyers, and I end up talking about a guy that becomes the Chief Justice of the United States Supreme Court. You know, and where does it start with us? You know, and the judge alluded to it with the ABA stats. If I brought my clinical staff here or any law school, first day of law school, right before they're getting ready to start, and they're all bright-eyed and scared S-less, you know what that means, about what's going to happen. And we did an assessment on the incoming class, first-year students. The numbers basically would show that 10% of the incoming class is diagnosable under the DSM-5 with a mental illness. Primarily what we're going to see is depression, anxiety, hostility, paranoia, obsessive-compulsive disorder, one or a combination of those five, diagnosable under the DSM-5 as a mental illness, 10%. That's the same number as non-law students. That's the general U.S. population, generally 10%. So when we start law school, we're no screwier than everybody else, and I'm a little bit of facetious. I'm not making fun of that because I've been diagnosed with my own mental health issues. I grew up with a mother who was bipolar. Back when we called it manic depression, it wasn't fun. It was kind of scary, but be that as it may. 10% at the end of the first year of law school. If I bring my clinical people back and we do an assessment on the kids that are still here, the number diagnosable with a mental health problem has tripled to 32%. Law school changes people. You think so? Did it change you? Mm-hmm. Yeah. Not bad or wrong, not good or bad. It's just, it's a fact. All right. 32%. It has tripled. If I come back at the end of third year day, fourth year night, do an assessment on the law students who are getting ready to take the bar exam and join us in the practice of law, the number diagnosable with a mental health problem has jumped to 40%. And the number doesn't go back to pre-law school days of 10%. It doesn't go back to the surgeons, 13%. It goes back to about a third. Statistically, 1/3 of the practicing bar, and I don't care where you are, where we are, if we are in courtrooms, if we're in government agencies, and we're in nonprofits, we're in for-profits, we're in big firms, small firms, solos, I don't care where we are, 40% of us are diagnosable, a third of us, are practicing law currently under a mental health disorder. It's not only having a negative effect upon our ability to practice law, the kind of job that we're doing for our clients, but what's going on at home? What's going on with family and neighbors and kids and significant others and partners and all of that? It takes a toll. You know, 25% of law students, when they start, are diagnosable with a substance use disorder. What we have actually found is that law students drink more when they get to law school than they did when they were in undergrad. It's an acculturation thing. The problem is, and when I talk to the kids, and some schools will let me on orientation, University of Cincinnati, when they called me and said, can you come down and speak to my professional responsibility class? And I said, sure, be happy to. Can I also get on the orientation? Give me 15 minutes so I can talk to the kids. She says, no way. She said, well, they're already so scared. We don't want you to scare them more. Talk about hide the facts. Let's start law school by playing hide the facts. How about that? No wonder you're an academic. Excuse me for the academic. 25% of law students, 6% of law students have suicidal thoughts. Some studies have shown that as many as 15% of lawyers have suicidal thoughts. On the good side, you know, the Texas Bar Association did a survey of their membership a few years ago, and 88% of the lawyers said if they had to do it over again, they would become lawyers again. So it's not all dim and dismal. It's not all negative. But where I have found where law school changes people, you know, and this is work that was done by Susan Daycoff, who was a psychologist and a lawyer, has an LLM. She used to teach at Capitol. She's elsewhere. Went to Arizona. What she's found is that when we come to law school, and I don't know if it applied to you, but it did to me, because I came out of a liberal arts background. I had a bachelor's and a master's in English, and I was staying in school as long as I could until Vietnam was over, because I had that 2S deferment. Then I got a high lottery number, you know, and I went 1A so I could get through that, and I did. Then I had a career choice because I didn't know if they were just going to take me over there and shoot me, so I was kind of holding back on stuff for a while. They're peddling, trying to stay alive, drinking, and smoking good dope, so it wasn't all bad. You know, I mean, we had good dope back then, not the stuff they have now, but it was okay. You know, Thai stick, if you ever got into any of that, that was pretty good stuff. But anyway, I went to law school because I wanted to help people. It's an intrinsic value. I wanted to be part of the solutions. You know, if you're not part of the solution, you're part of the problem. And don't trust anybody over 30. And now I'm 72, and here we are, you know, with that. But that's where I grew up, and I wanted to help people. You know, and I lost that for a while. I did it. But I started looking around, and I started looking at BMWs and country club memberships. You know, at one time I belonged to two. Houses, the accoutrements, the power, the influence kind of thing. I got acculturated into the deal. And getting sober for me gave me an opportunity to reconnect to who I was before I became an addict. And the addict wasn't all responsible for it. It was just I allowed myself to get sucked in to the promise of money, power, influence, prestige, and all that by being a lawyer. You know, and statistically, that's what happens to us. And what I see in my office every single day are lawyers who come in who started out wanting to help people, found out that in order to do that in some fashion, if they could stick with it at all, required them to get into a profession that is built on adversarial positions. Everything that we do is surrounded by negativity. I practiced law for 30 years. I was never super successful. I always had more money than I needed, kind of thing. Wonderful life. Gretchen, my wife's a lawyer. I met her in law school. Our daughter's 37. She's in her 10th year, 11th year of practice in Columbus and doing great. You know, we're the first lawyers in the family. You know, I loved being a lawyer. What I got tired of were the clients and other lawyers with the constant negativity. You know, and I say this kind of facetiously. In all of my years of practice and all of the cases that I handled, some more successful than others, maybe. You know, I was always one guy that said, if I didn't get 150% result, I was a failure. Go figure. But the only time I didn't have clients complaining about something were like 2 uncontested adoptions or something. Everybody else, I don't care if I saved a client $1 million. I don't care if I made a client $1 million. I don't care what I did. Somebody complained. You charged too much. It took too long. I didn't want to do it this way. You know, the guy I bowl with, his lawyer did this. And I go, God, go hire the guy you bowl with. the negativity, and then we lawyers do it to each other. Like, you know, you get these lawyers that are mean and nasty, like I'm going to suddenly fold and sell my client out because you're a jerk. You think this is going to encourage me to settle because you holler and scream and pound your... And we do it to each other. You know, and I recognize the real world. No question. You know, and I say this all the time. You know, this whole wellness thing with lawyers, I think it's wonderful. I don't do goat yoga, never will. Don't understand that, but if that's your thing, go ahead and do goat yoga. You know, I'm more likely going to go hit golf balls, or go to the driving range, you know, go hunting, do something other than goat yoga. What I've found is that we lawyers have a tendency to be so self-critical that we allow the negativity to change who we are and how we view ourselves, you know, subconsciously. We may not be conscious of it, but if you've got somebody complaining to you about what you're doing, how you're doing it, the result, what it costs, whatever it is, constant negativity, and it goes on for day after day after day, year after year, month after month, whatever it is. Eventually, you're in my office saying, I'm burnt out. And I'm not saying that I can control what anybody else does. I learned a long time ago, 37 years actually, when I was in treatment at Talbot Hall, I had to learn that I can't control other people, places, and things. I can only control the way I let them affect me. I can't control other people, places, and things. I can only control how I let those people, places, and things affect me. My first visceral response to something might be anger or fear. I understand that. But I have the ability to step back and go, wait a minute. Wait a minute. And I don't have to get sucked into the negativity and destroy my own self-image. And we do that all the time. And it starts in these seats, perhaps, with lawyers. How many of you did not make law review? You ever have a client ask you if you made law review? I was working. I would have liked to have been smart enough maybe to write, but I was working full time. I had a full-time job with 2 Shoss in the tax department. Well, I was going to law school my last 2 years, so law review wasn't something that I was into. Did anybody ever ask you what your class rank was? Your clients? Ask GPA? Me either. Think back to when the list of people who made law review came. Think back to when you got your first grade, that you had never seen a grade like that before in your life, and it happened here, right? I got mine. Got a buddy checking the grades as they come out first semester, and contracts come out, and he says, you got a D, and I said, did you say D? As in dog? I was in Dayton, and I was in school at Stetson in St. Pete, Florida, and he was checking the grades as they came out when I was home after exams. He says, yeah, you got a D. I said, what did you get? And he said, a B+. I said, T. I went back to law school intending to withdraw. I had gotten like 2 B's, a C, and a D or something like that, and I had never gotten grades like that in my life. And I had really tried and studied with this group of guys. And what my contracts prof said to me was, he says, you know, before you came in here today, I took a look at your file. Your LSAT was good, your GPA is great, everything in your application is wonderful. You know, we would not have let you in here if we didn't know that you could be successful. Don't panic, you're used to being the smartest guy in the room. Everybody here is the smartest guy in the room. The competition level just changed. Do law schools tell their students that? No. That's why they won't let me on orientation. Don't panic. We wouldn't have let you in if we didn't know that you could be successful. Law firm setting, I get lawyers in my office all the time. They're solos, they're small firms, they're office sharing arrangements. I got a call earlier this week from a 59-year-old partner at one of the major law firms in Columbus who's getting ready to walk out the door because he's just had it with the internal conflict among him and his colleagues, the people he used to think are his friends, who have not become too much friendly anymore because they lost one of their major clients and everybody's fighting over what pool of money's left. Wow. Wow. Grateful not to ever have been in that position. You know, the other thing that I don't like to talk about because I'm getting close to becoming Exhibit A is the age-related cognitive impairment piece. I'll look at somebody I've known for 30 years and I go, Jesus, I can't even remember their name. Now, my excuse is I have so much information in here that it gets kind of jumbled up. You know, it's not age-related. It's part of, I laugh with Gretchen, my wife. I say, I can't remember what the hell I ate for lunch yesterday, but I remember something that happened when I was 6 years old. Getting there. The profession, we baby boomers are aging for sure, and we are not prone to giving up lightly. We grew up in an era when you worked for what you got and you achieved what you were going to get because you put in the hard work for it. And let's not just walk away from this. After all, I don't have anything else to do for many of us. I do, but a lot of lawyers don't. And what I'm seeing now are calls from colleagues, from partners, and a lot of judges that have elderly lawyers appearing in front of them who are, let's be kind and say, mixed up. They just cognitively can't do it anymore. And we trying to help our colleague are kind of helping them along, but things are getting worse and worse. And I'm constantly concerned that what we're doing is enabling one of our colleagues to go out of the end of a wonderful career as respondent in a disciplinary matter and a defendant in a malpractice case. If we don't step in and call somebody. Once again, you don't have to be able to diagnose, you don't have to fix, you don't have to do anything other than when you observe the aberrant behavior, you observe the failing behavior, call the Ohio Lawyers Assistance Program and let's get something moving in a different direction. The only cure I have for people say, what's the solution? Well, we could ask everybody in the world to be nice to each other. How do you think that's going to happen? You know, as I tell Jamie Dimon, the president of J.P. Morgan, Bank of America, he's scared to death every single day like everybody else is that everything's going to blow up. There isn't anybody running around out here doing anything that's still breathing that doesn't have some fear thing going on. It's part of the human condition. Go back and read the classics. Go back and get into the literature again. It's not just, we're not learning anything new, in my opinion. And I'm the only opinion that matters in my life. The anger piece, we're not going to change society, so what we need to do individually and collectively if possible, but certainly individually, is learn how to take care of yourself. And I think the first place and the easiest place to do that, just go online. If you don't already have a spiritual place to live, find one. That's a good place for me. But the other thing is to learn how to be resilient. And most of us have got pieces of it. But to start thinking intentionally about it a little bit more, because we're getting buttressed every day. We're just getting pounded every day. It's only getting worse. Nobody talks, everybody screams. It's all exclamation points now in capital letters, kind of thing. You know, we don't even have to talk to each other face to face anymore. I just shoot you an email, give you a finger that way. You know, and it's wearing. It's not fun. You know, my daughter's 37 years old. She says, Dad, man, She said, I thought it would be more fun than this, and she does litigation. She said, the mean and nasty stuff. She said, I'm not doing this forever. And I said, I don't blame you. She said, I'm getting a sailboat and going to the Caribbean. And I said, I hope I live long enough to come see you. Go for it. Do it. Don't do it forever. So everything I do at the Ohio Lawyers Assistance Program is absolutely confidential. Absolutely confidential. I remember we had a case up here years ago, and I got a telephone call from a woman who identified herself as a reporter for the Cleveland Plain Dealer, and this is 20 years ago. And it's kind of some notoriety to the case. Anyway, OLAP's name gets mentioned in something at the court or wherever it was. And she calls me on the phone. She demands information from me, and I said, well, everything I do is confidential. I neither admit nor deny that I know the lawyer who you're talking about. And she says, well, you're a public agency. You have to give me the. I said, I'm not a public agency. She said, well, I'm just going to get hold of our lawyers and sue you. And I said, you still represented by Baker and Hostel? And she said, yeah. And I said, well, tell Jim Jones I said hi. Take your best shot. Everything I do is confidential. I have never once been asked by the Office of Disciplinary Counsel to violate that. Never once been asked by Bar Counsel here in Cleveland. Never had a justice on the Ohio Supreme Court ask me to violate the confidentiality. You don't have to worry if you're calling for yourself or for somebody else that we are going to turn around and call your colleagues or call your spouses or call the court or call discipline or the Bar Association. It is absolutely confidential. If you're concerned for yourself today or somewhere down the road or for somebody else, anything to do with the kind of stuff that we talk about, and you can look at the stuff in the PowerPoint that I don't use, but I just put it up there because it makes me look technologically savvy. It's all appearances, isn't it? Happy, joyous, and free. If you're concerned, call us. You don't have to do this all by yourself. Thanks for the opportunity to be here.
That does conclude our program. Wow, what a busy, fast-paced day. I hope you enjoyed it as much as I did. Remember, if you're in person, I see a lot of you have your attorney registration information so you can get your CLE credits. If you're remote, do I have to give the bar number? No, we're good with that. The written materials are from Case Law School, where you registered for this event. You can be linked in to get the written materials. And as you see from our speakers, they spoke fast, they spoke a lot of opinion, they spoke a lot of law, but a lot of stuff is in the written materials, so do go there. Thank you again on behalf of the 8th District Court of Appeals and Case Law School. Thank you.
The activity code for this program is 499-242, 499-242. The evaluation for this is in the link. This message is for our virtual audience. The activity code is 499-242.